IPA. This is again a pleasure to be a part of one more webinar, and this time we are aiming to discuss on the personal guarantee, the provision pertaining to the personal guarantee, a class among the class of individuals. So that was basically a challenge before the Honorable Supreme Court on 15th November 2000. So basically, as far as the constitutional validity is concerned, the constitutional validity of that circular of 15th November was upheld by the Honorable Supreme Court. And considering Part 3 of the Insolvency and Bankruptcy Code, which is notified for the class among a class. So basically here we are not going to deal with the individuals or a partnership firm, but yes, we will be dealing into those aspects wherein an individual is a personal guarantor to a corporate debtor, or we will be dealing into the cases wherein the CIRP or liquidation, whether commenced or not, or in case if it is successfully completed with the approval of resolution plan, but where a financial creditor, a secured financial creditor in whose favor a personal guarantor has given a guarantee, and that creditor has invoked that guarantee, and even after the invocation of the guarantee, the amount is still in default, and such applications are being made before the Honorable Tribunal these days under Section 95. So I would like to deal first into the past, that how the provisions pertaining to the personal guarantee has been notified. Later on, it was challenged. The constitutional validity later on was challenged and upheld by the Honorable Supreme Court, and how the applications are being made. And once the application will be made, the interim moratorium, the moratorium, once the applications get admitted, how the repayment plan, so what we call resolution plan in case of a company that is corporate debtor, or in case of a corporate person, we used to call a repayment plan. We used to have this language repayment plan in case of the personal guarantor, what we have a resolution plan in case of a corporate debtor or a corporate person. So our focus will be on entirely on the matters pertaining to the personal guarantors. And one thing is very clear nowadays, the creditors are very cautious while approving a resolution plan, because if the resolution plan is having a condition that post approval of the resolution plan, a secured creditor will not be in a position to invoke the personal guarantee, then the fact which is admitted by the COC, later on it cannot be overruled by invoking a personal guarantee. So these days, a creditor, while approving a resolution plan, are quite conscious whether their right to invoke the personal guarantee will subsist later on, or that will come to an end. So going with the background, that how this was notified, what were the challenges initially, how the challenges have been taken care of by the Honorable Supreme Court, and presently how the applications are being made before the NCLT. The jurisdictional issue is very much clear. Pursuant to Section 60 of the Insolvency and Bankruptcy Code, we will be dealing with those aspects also, that what is going to be the jurisdiction. And there was initially a confusion whether the DRT is going to be a forum, or the NCLT is going to be a forum or a jurisdiction. So these days, the applications are being made before the Honorable Tribunal, where the CIRP or liquidation application is pending before, or again in the matter of corporate debtor. So that NCLT is going to be the jurisdiction where the application under Section 95 or application under Section 94 will be preferred before, and that is NCLT is going to be the jurisdiction who is going to decide the matter pertaining to the personal guarantors. I'm just sharing a screen to discuss the background, and post that discussion, we will be dealing into the aspect of Section 60 first of all, so that we can have a discussion on the jurisdiction part. Post discussion on the jurisdiction part, our focus will be on to take care of the provisions with regards to personal guarantee, that is in Part 3. We will be dealing, as far as the provision is concerned, Section 194 to Section 120, which is what we are going to deal with. We'll be dealing with the rules, we'll be dealing with the regulations, and we'll see how practically it is going to be difficult on the part of the RP to invite the claim or to constitute a COC, because here the number of creditors are numerous, though value is going to be very small. So practical difficulties can be understood out of the provisions of the code, out of the rules of the code, out of the regulations of the IBBI. So that is going to be the another aspect we are supposed to take care of. I'm just sharing screen for the sake of discussing the brief background, how it was notified. Because see, as far as the notifications are concerned, now this was notified on 15th of November 2019, but it has been made effective from 1st December 2019. So as far as the provisions of the code with regards to a class of individuals, that is a personal guarantor, the section were notified on 15th of November 2019, but as it has been made effective from 1st December 2019. The same is the case with the rules. What we used to have, insolvency and bankruptcy application to adjudicating authority rule. Here, application to adjudicating authority for initiation of CIRP of the initiation of insolvency resolution of the personal guarantor. So that was also notified on 15th November 19, effective from 1st December 2019. And same is with regards to the regulation, which is framed by the regulator, that is IBBI. I'm just sharing screen for the sake of convenience of all. Is this visible?
Yes, sir.
Thank you. So now this is something from where it can be identified that how or what exactly the genesis of this personal guarantor. Now this is prior to the introduction of the code. The insolvency resolution of the individual was governed under the Presidency Towns Insolvency Act. So it was covering the jurisdiction of Bombay, Kolkata, and Madras, and Provincial Insolvency Act 1920, which stands repealed with effect from 19/8/2016 by the virtue of Section 243 of the Code. Now, when you see the amendment in Section 2, now Section 2 deals with, as far as the IBC Section 2 is concerned, the applicability of this code. And as far as the applicability is concerned, the code has made, so as far as the unamended part is concerned, there was no segregation with regards to an individual and personal guarantor. But as far as the amendment is concerned, you can find even a personal guarantor to be falling under the domain of Section 2, and that is Section 2 Clause E. Apart from that, partnership firm and proprietorship firm, for them, Part 3 is still not notified. Individual other than those referred in Clause E, that is again Part 3 is not notified. So our limited approach is going to be for the personal guarantee to the corporate debtor. So when you see that they are falling under the basket of Section 2, that clearly indicates that for the action against the personal guarantor corporate debtor, even after the resolution of their insolvency, so even after the approval of resolution plan, guarantee may be invoked by the creditor, and this is going to be dealt by the same bench which has dealt with the CIRP or liquidation of the corporate debtor. Now, this is just a brief background. This is an exercise of the power conferred under Section 1 subsection 3 of the code. While notification dated, I said that it was 15th of November 2019 when the sections or the rules or the regulations pertaining to the personal guarantor was notified. Part 3 of the code relating to the insolvency and bankruptcy of an individual and partnership firm insofar as applicable to the personal guarantor to the corporate debtor, including impugned provisions. So basically, that circular was challenged before the Honorable Supreme Court, and this is something which is itself a landmark, Lalit Kumar Jain versus Union of India and others. So there was a challenge before the Honorable Supreme Court inter alia. The central government, while issuing a notification, had acted in excess of the power conferred upon it under 1 subsection 3. It was contended that the power conferred upon central government under subsection 1(3) of the code could not have been resorted to in a manner so as to only extend the provision of Part 3 of the code selectively in relation to the personal guarantor. So basically, this personal guarantor itself is a class within a class. So class per se is an individual, but subclass within that class is the personal guarantor, those who have extended a guarantee on behalf of a corporate debtor in favor of a creditor. The Honorable Supreme Court, in case of Lalit Kumar Jain, upheld the validity of the notification dated 15 November and also held that the liability of the personal guarantor is not discharged merely on discharge of the liability of the principal debtor. And these days, we are coming across certain plans, certain resolution plan, which is also dealing with the extinguishment of the liability of the personal guarantor. And the COCs are very cautious in approving those resolution plan. But if the COC has taken a conscious call of approving those resolution plan, which later on debar a secured creditor to invoke a personal guarantee, in that case, the liability of the personal guarantor later on cannot stood up just because of that a personal guarantor has extended a personal guarantee on behalf of a corporate debtor, especially when the clause pertaining to the personal guarantee, extinguishment of the liability of the personal guarantor, is taken care of itself in the resolution plan. So there is an order which is passed by the Honorable NCLT Indore Bench, which was challenged before the NCLET, and we are going to deal into that particular part after completion of all the provisions with regards to the personal guarantor. Now, this Lalit Kumar Jain versus Union of India. In Lalit Kumar Jain versus Union of India, the question which was placed before the Honorable Supreme Court was, the MCA notification dated 15 November 19 is lawful and within the scope of the government power. The second question which was raised, does sanctioning a corporate debtors resolution plan can revive the corporate debtors personal guarantor? So basically it was dealt in the matter of Lalit Kumar Jain versus Union of India. As far as this particular impugned notification was concerned, which has resulting to enforcement of Part 3 of the code, which deals with the insolvency of an individual. But as far as this subcategory is concerned, presently it only deals with those individuals, those who have extended a personal guarantee on behalf of a corporate debtor. The notification has led to strings of challenges as to constitutionality before the High Courts. And finally, on October 29, 2020, the Supreme Court has stayed the High Court from admitting or hearing any or all the writ petition challenging the impugned notification and transferred to itself all the matter pertaining to the High Courts. The major ground of challenge, as I said, was central government did not have power to bring into force selected part of the code and in turn create a subcategory of individual. But it was very much required, because when a resolution plan is being approved, in that case, it's always upon the secured creditor to invoke the guarantee against a personal guarantor. So resolution of the corporate debtor will not resolve the issue pertaining to the personal guarantee extended by a personal guarantor on behalf of a corporate and debtor. And that's why there was a dire need to invoke, or there was a dire need to dealt upon the situation wherein the personal guarantee is invoked and the personal guarantor has committed default in payment to the creditor, whether in full or part. This contention was premised on the claim that the power under section 1 subsection 3 of the code to bring the provision into force was only function of the conditional legislation, whereas the action undertaken through the impugned notification was inherently legislative in nature. Court analyzed the number of precedent to determine the scope of delegated legislation and conditional legislation. It finally held that where the power granted to executive wing was limited to determine when a particular provision must be brought into force and allowed making a peripheral modifications to effectively administer such law in a particular circumstances while keeping intact the inbuilt. So basically, it was finally clarified by the Honorable Supreme Court that this particular notification per se, even though the constitutional validity is challenged, but it was the requirement. It was a requirement qua the CIRP of the corporate debtor. Now, 2018 amendment modified 2 clause E and subcategorized individual into 3 categories. First is the personal guarantor. Second one is a partnership firm and a proprietorship firm. And third is an individual. This was calculated move following the recommendation of the report of the working group of the insolvency, emphasizing the intrinsic relationship between a personal guarantor and a corporate debtor, and how the insolvency resolution process of the corporate debtor would be in any way incomplete without bringing the personal guarantor under the scope of the same. And that's why the jurisdiction was also again clarified. And this is what we can see here. The court held that 2018 amendment, as far as it inserted section 2 clause E and altered section 60 subsection 2, sought to streamline the resolution process. It sought to bring together all the stakeholders under the same forum. And that's why you will find the resolution professional who is being appointed as a RP in case of personal guarantor. Earlier, there was a disqualification, or earlier there was a limitation. The person who acted as an IRP or RP or a liquidator. I said a person who acted as an IRP, RP or liquidator of the CD. Initially, they were not eligible to act as a RP, but later on it was identified that the information which they possess in the capacity of IRP, RP and liquidator, it is quite difficult for a newcomer to come in and to gather the information of a personal guarantor. So basically that particular clause was removed, and today even the person who was, or even an insolvency professional who acted as an IRP or RP or a liquidator of the corporate debtor is also eligible and entitled to act as a RP in case of a personal guarantor. We will be dealing into this aspect. This is something which is very clear that secondary issue addressed in the judgment was the juxtaposition of the treatment of personal guarantor under the code against the right of guarantor under the Contract Act. The successful end of the resolution process of the corporate debtor is synonymous with the successful resolution plan, extinguishing the liability, whole or part of the debt. Yes, if there is anything to discuss, we can very well stop and discuss the same. So we were dealing into this part that successful end of a resolution process of the CD is synonymous with the successful resolution plan, extinguishing the whole or part of the debt. Although the claims as against the corporate debtor stand extinguished, the same treatment is not rendered to the personal guarantor, as all the avenues are open for a creditor to proceed against the personal guarantor. But there are lot many challenges to it. There are multiple challenges to it, because see, if I as a MSME proposing a resolution plan, and if that resolution plan is being approved by the committee of creditor and later on it is approved by the adjudicating authority, I will get my position back on the corporate debtor's seat as a director. But again, this has, or it has not bring an end to my liability to a personal guarantor. So basically the purpose is not going to be fulfilled. On the one side, I have got the position back on the corporate debtor's seat, but later on when the untouched portion of the debt, if the secured creditor wants to invoke the personal guarantee to recover the cutoff which, or the haircut which they have accepted while approving of the resolution plan against a new layer of litigation, against the new round of litigation will be started against me, though I back my, or though I have got my position back, but there will be a new round of litigation will be initiated against me in the capacity of personal guarantor, and ultimate purpose of getting the position back on the corporate debtor seat will not serve the purpose. And that's why these days which I can witness nowadays is the resolution plans are being drafted, are being prepared, are consciously being prepared in a manner wherein the clause pertaining to invocation of the personal guarantee later on after the approval of the plan is also being dealt with. And the clauses are being placed in the resolution plan that upon approval of the resolution plan, a secured creditor will not be in a position to invoke personal guarantee. And in consideration of that, there is some sum and earmarked for the payment to such secured creditor, those who are giving away their right of invoking a personal guarantee. Now, I'm just, rather than discussing much upon this Lalit Kumar Jain and Union of India, I will be dealing into one more aspect, and that was Dilip B. Jivrajka versus Union of India, wherein the multiple applications were made under Article 32 of the Constitution of India, and later thereon Section 95 to 100, the constitutional validity of Section 95 to 100 was challenged before the Honorable Supreme Court, and later on it was also clarified. And this is again very much a landmark judgment of the Supreme Court, wherein the constitutional validity of Section 95 to 100, which was initially challenged, but later on it was upheld by the Supreme. It was decided by the Supreme Court that Supreme Court has upheld the constitutional validity of the provision of 95 to 100, and this was a writ petition made before the Honorable Supreme Court on the basis of the natural justice opportunity to the personal guarantor. So here, even the eminent entrepreneurs like Anil Ambani, in case of Arcom, they have also preferred this writ petition before the Honorable Supreme Court. And out of that bunch of writ petition, it was ultimately concluded that the provision of Section 95 to Section 100 are very well constitutional in nature. As far as Dilip B. Jivrajka versus Union of India and other dated November 9, 2023, the constitutional validity of the provisions pertaining to the personal guarantor in Part 3 of the Code were recently challenged in series of 384 writ petitions filed under Article 32 of the Constitution of India. The validity of Section 95 to 100 of the Code was challenged inter alia on the ground that they are volatile of the principle of natural justice, on the ground that the personal guarantor was allegedly condemned unheard and unfettered power, including adjudicatory power, were vested with the RP. So it was very well clarified the position of the RP in the insolvency in the personal guarantee matters. On 9th of November 2023, wide a common judgment, which was delivered by the Honorable Supreme Court in the matter of Dilip B. Jivrajka versus Union of India, the Supreme Court upheld the constitutional validity of the impugned provision of the code and dismissed the writ petitions. So the question or the challenge before, so initial challenge was pertaining to notification dated 15th November 19. So when that dust was settled by the Honorable Supreme Court, thereafter the writ petition was made before the Honorable Supreme Court, and Honorable Supreme Court in the matter of Dilip B. Jivrajka versus Union of India has settled the position of the constitutional validity with regards to 95 to 100, which we are going to deal with. The main question or the basic question of law which was framed in the writ petition was, do the debtor and the personal guarantor have right to know the grounds for accepting or rejecting an insolvency application? And that's why these days you will find the report under Section 99 before admission of an application by the adjudicating authority is required to be served to the personal guarantor. Does an order of interim moratorium by the RP amounts to arbitrary exercise of the power? Does the submission of RP report under 99 without providing a copy to the debtor and personal guarantor that violates the principle of natural justice? The impact of the personal guarantee in relation to the corporate debtor undergone insolvency proceedings under the IBC has raised interesting legal issues. The personal guarantee refers to a promise made by an individual to assume the responsibility of repayment of the debt in event the corporate debtor fails to fulfill. So that is a definition of the personal guarantor, which we can able to find in Section 5 of the code. The recent pronouncement as far as this Surendra B. Jivrajka versus Omkar Asset Reconstruction Private Limited has settled the ambiguity surrounding the liability of the personal guarantor under the code. Nevertheless, certain issues remain unaddressed. Following the notification dated 15 November 19, the personal guarantors are directly subject to insolvency proceedings without the requirement of creditor primarily initiating insolvency proceeding. So one thing is very clear. Initially, there was a question that in order to invoke a personal guarantee, is it required to initiate an application of CIRP against a corporate debtor? But later on, it was settled that in order to invoke guarantee or in order to initiate an application under Section 95, there is no requirement that creditor first invoke Section 7 or 9 to initiate CIRP against a corporate debtor for which a personal guarantee is given by an individual. Supreme Court recently clarified the constitutionality of these provisions under the code, along with the extent of liability attributable to the personal guarantor. The judgment is critical since it grants higher leverage to the creditor of the CD to retrieve the outstanding amount that was not collected throughout the CIRP of the corporate debtor by the virtue of personal guarantor's insolvency resolution process. This creates a dual safety net for the creditor to claim their dues from not only single entity. The result of recently pronounced judgment in Omkar Asset Reconstruction strengthened the already high bargaining power of the creditor, leaving the personal guarantor with limited scope of protection. So basically, this is what happened when you face Section 95 application against a personal guarantor, and when you are representing a personal guarantor, there is no much room to contest such application, because here there is no question pertaining to whether proving of the liability, because liability is already proven, that is on paper, and that default is already established the moment when a corporate debtor has failed to repay to the secured creditor. So as far as now, good thing, what's supposed to be taken care of is, I'm focusing on that part, unaddressed issue. The code introduced a paradox, promising enhanced recoveries for the creditor, but imposing a notable challenges on the standing of the guarantor. One pressing issue is the potential for multiple and concurrent insolvency proceedings. Because what my belief is, if I'm a personal guarantor, if I'm a personal guarantor to a corporate debtor and corporate debtor have failed to repay the amount of the secured creditor very well will invoke the personal guarantee, but then I will be left with no option of getting the sum recovered from the corporate debtor, because I am also one of the creditor of the corporate debtor. Then the code introduced a paradox, promising enhanced recoveries for creditor but imposing notable challenges on those standing as a guarantor. One pressing issue is the potential for multiple and concurrent insolvency proceeding. The coextensive liability of the debtor and guarantor allow the creditor to initiate simultaneous insolvency action against both parties. This raises a concern about the jurisdictional conflict and the operational challenges for NCLT. Example of a guarantor providing guarantee for the companies in different location, coupled with initiation of CIRP in different cities, further underscores the complexity. So if I have given a guarantee on behalf of a corporate debtor in favor of its multiple lender, and multiple lenders have moved before the NCLT, then jurisdiction is going to be one of the question. And this is what I have provided. The example of a guarantor providing a guarantee for a company in different location, coupled with initiation of CIRP in different cities, further underscores the complexity. Section 60, subsection 2, which we are going to read, mandates filing of insolvency proceeding against the guarantor where CIRP of the borrower is underway, creating uncertainty regarding the precedence and the formulation of repayment plan. Now, this is very good point. Another issue which emerged in the form of creditor double dipping, a practice allowing a creditor to initiate simultaneous CIRP against both debtor and guarantor, while NCLT or NCLT has expressed concern about double dipping. The coextensive liability of the personal guarantor and borrower, 60 subsection 2 of the code permit a concurrent proceeding against both the party. The potential for double dipping by creditor raises a question about a fairness of the insolvency resolution process for a guarantor. Further, it calls for the question of res sub judice, how the code permit a concurrent proceeding when proceeding on the same matter, same issue, and same party already subsisting before the tribunal. And this is the great point. The extinguishment of the guarantor's right of subrogation under the code stands out as a significant issue which the court have failed to address so far. Traditionally, the guarantor possesses the right to step in into the shoes of creditor, recover the money paid on behalf of the principal debtor. However, the court denies guarantor this right, emphasizing the pro-creditor nature of insolvency regime. Denial of such right of subrogation will only hinder the personal guarantor from extending guarantee owing to the extremist nature of the code towards personal guarantor. So these are the major challenges which I can say. One is, which is what I have dealt in the last paragraph, that if I'm extending a guarantee, the question is on what consideration I'm going to extend my guarantee. Because I know if CIRP will be initiated against the corporate debtor or leave CIRP, if corporate debtor tomorrow will commit a default, the amount is going to be recoverable from me. Okay, now suppose if I fail to repay the amount, the personal guarantee will be invoked and I will be subject to a proceedings before the NCLT. But now what about the right of subrogation? Because it giving a guarantee also give me a position of the creditor. Now, how I'm going to recover my interest from the corporate debtor? This is one of the untouched portion leading to which you will find the directors of the company will be stepping out or will be stepping or will be taking a step back as far as giving of a guarantee is concerned. Please check the last observation. The extinguishment of guarantors' right of subrogation under the code stands out as a significant issue which court have failed to address so far. Traditionally, the guarantor possesses right to step in into the shoes of creditor, recovering money paid on behalf of the debtor. But court denies guarantor this right, emphasizing the pro-creditor nature of insolvency regime. Denial of the right of subrogation will hinder the personal guarantor from extending guarantee, and this will owe to the extremistic nature of the court towards the personal guarantor. This is one of the very important aspect which is not dealt in any of the judgment, whether Lalit Kumar or Dilip B. Jibrajka. Double dipping issue, wherein even though the CIRP is initiated against the corporate debtor, but the creditor is also invoking a personal guarantee. So this is the creditor's double dipping, a practice which allow creditor to initiate simultaneous CIRP against both debtor as well as a guarantor. While NCLAT expressed concern about double dipping, the coextensive liability of the personal guarantor and borrower, subsection 2 of section 60 of the code permit a concurrent proceeding against both parties. This potential for double dipping of creditors raises question about the fairness of the insolvency resolution process for guarantor. This further call for the question of res sub judice. How's the court permitting concurrent proceeding when a proceeding on the same matter, same issue, same parties is already submitted and pending before the tribunal? And this is one of the very crucial issue which is still not addressed upon. So these are the basic concerns as far as the personal guarantee is concerned or the invocation of the personal guarantee is concerned. And as I said, the jurisdiction is always going to be a trouble. So if this Vinit Nagar has given guarantee on behalf of 10 corporate debtor, all 10 corporate debtors are having its registered office at 10 different locations. And if 10 separate corporate debtor on whose behalf I have given a guarantee on behalf of all their 10 separate lenders, then jurisdiction is going to be a big trouble as far as section 60 is concerned, and that is also which is not addressed upon. The code introduced a paradox, promising enhanced recovery for the creditor but imposing notable challenges. One pressing issue is the potential for multiple and concurrent insolvency proceeding. The coextensive liability of the debtor and the parenter allow creditor to initiate simultaneous application against both the guarantor as well as a corporate debtor, but it raises a concern about the jurisdictional conflict. Example of a guarantor providing a guarantee for a companies in different location coupled with initiation of CIRP in different cities further underscores the complexity, because it will be quite difficult. Which is going to be the bench where my application is going to be adjudicated? Because all those entities, 3, 4, 5 entities on whose behalf I have given a guarantee, all those entities are at different bench because of having a different registered office at different cities. Against all those corporate debtor, the CIRP is initiated where my application is going to be entertained. The example of a guarantor providing guarantee for a companies in different location coupled with initiation of CIRP in different cities underscores the complexity. So these are the primary issues which are still not addressed by the Honorable Supreme Court in any of its judgment. As far as the rules and regulations are concerned, these are presently vanilla in nature because nowadays the applications have started being admitted. The complexity will start when the RP is going to bring out some repayment plan or will practically deal into this situations or circumstances. So basically, as far as this personal guarantee insolvency is concerned, this is at very initial stage and will initially face a teething problem. If you have certain things to discuss, we will be discussing the same first, and then we will be going to the code and we'll be dealing with the rules, and thereafter we'll be dealing with the regulations. I'll be happy to have your views on the same, because three primary issues which are just now addressed before you, if you have some say on it, we should have a discussion on same before dealing into the code in detail. So let's begin with the code, the provisions of the insolvency code. We will be reading those code with the rules with regards to the personal guarantor. As I said, notified on 15 November 19. It's been made effective from December 1st, 2019. And after this Supreme Court judgment in Dilip B. Jivrajka, Supreme Court has cleared the dust. And at this moment, the applications nowadays, you will find numerous applications are being made under 94, 95, which are being adjudicated or which are being dealt by the honorable tribunals or the bench across India. I hope the screen is visible to you. Now, this is the code before us. Is this visible or?
Visible.
Thank you, sir. Now, this is what I said. When you see section 2, and already this, before, much prior to that circular, much prior to that notification dated 15 November 2019, much prior to that, it was 2018 amendment, which has already amended section 2. And when you see section 2 of the code, it deals with the applicability part. As far as the applicability is concerned, the provision of this code shall apply to, and you will find the personal guarantee to the corporate debtor. So basically, it has classified individual into three categories. One is the personal guarantor. Second one is the partnership firm, proprietorship firms. And last one is the individuals. So basically, it is a class among the class. So it is a subcategory of an individual for which the part 3 is going to be dealt with, or part 3 is notified. Not only this, when you see corporate persons, something which we are aware of, it's including the company LLPs and any other person incorporated with limited liability under any law for the time being in force, but shall not include a financial service provider. Corporate debtor, it is something a corporate person who owes a debt. These are certain important definition, but when we deal into section 5 of the code, that 5 deals with a particular definition of a personal guarantor. You will find that under section 5 clause 22. A personal guarantor means an individual who is a surety in a contract of a guarantee to a corporate debtor. So this is a private limited company. Suppose if I'm a director and I've signed a deed of guarantee on behalf of company in favor of ICICI. So I'm an individual who is a surety in a contract of guarantee to a corporate debtor. So ICICI in case of default may invoke a personal guarantee, and date of default will remain same unless otherwise provided. So that means an individual who is a surety in a contract of guarantee to a corporate debtor. As far as section 14 is concerned, which deals with the moratorium, you are aware of this fact that this moratorium will not give me the liberty, or that will not give me an immunity of moratorium. And that is somewhere we can read out of section 14. The provision of subsection 1 shall not apply to a surety in a contract of guarantee. So meaning thereby, even though CIRP is initiated, a secured creditor in whose favor I have extended a guarantee on behalf of CD. I said a secured creditor, that ICICI, in whose favor I have extended a guarantee on behalf of that private limited company, they can very well initiate insolvency application against me. So the provision of section 14(1), moratorium shall not apply to a surety in a contract of guarantee to the CD. So that is section 14. And thereafter, when we deal with the most important aspect, that is section 60, which deals with the jurisdictional issue. And section 60 of the code, this is quite important for us to understand before we reach to section 94 or 95. We need to check which is going to be the jurisdiction wherein section 94 or 95 application will be made. As far as section 60 is concerned, adjudicating authority for the corporate person. Now, this is for the corporate person. But when you see certain alterations, some amendment which has taken place in 2018 amendment, 2018, it was very much amended. The adjudicating authority in relation to the insolvency resolution and liquidation for the corporate persons, including corporate debtor and a personal guarantor, shall be the NCLT having a territorial jurisdiction over the place where the registered office of the corporate person is situated. So suppose if I'm a partner of the LLP and on behalf of LLP given a guarantee in favor of State Bank of India, suppose if that LLP makes any or commits any default in payment, in that circumstances, it is the LLP which is situated in Gujarat and the insolvency proceeding is pending before NCLT Ahmedabad bench. In the same bench, before the same forum, a section 94 or 95 application can be preferred to initiate insolvency of the personal guarantor. This is section 60 all about. Section 60 subsection 1, which deals with adjudicating authority in relation to the insolvency resolution and liquidation of the corporate person, include a corporate debtor and a personal guarantor thereof, shall be the NCLT having a territorial jurisdiction over the place where the registered office of the corporate person is situated. So this is something which is important for applicant under 94, applicant under 95 to decide. But I said a challenging situation is if 3 corporate debtors are at 3 different locations. All 3 corporate debtors are in CIRP. All 3 corporate debtors on their behalf have extended a guarantee. And the creditor in whose favor the guarantee have extended, they have already invoked a personal guarantee. In all 3 cases, jurisdictions are at 3 different places where my insolvency application is going to be adjudicated. Subsection 2, which deals with without prejudice to one, and notwithstanding anything to the contrary in this code, where a CIRP or a liquidation proceeding of the CD is pending before the NCLT, an application relating to insolvency resolution or a liquidation or bankruptcy of the corporate guarantor or a personal guarantor, as the case may be, shall be filed before such NCLT. This is something which is clear, that without prejudice to one and notwithstanding anything contrary contained in the code, where a corporate insolvency resolution process or a liquidation proceeding of the corporate debtor is pending before NCLT, application relating to insolvency resolution or liquidation or a bankruptcy of the corporate person or a personal guarantor shall be filed before the NCLT. So jurisdiction is not going to be the DRT, and it is the NCLT. Insolvency resolution process or liquidation or bankruptcy proceeding of the corporate guarantor or a personal guarantor, as the case may be, of the corporate debtor, pending in any court or tribunal, shall stand transferred to the adjudicating authority dealing with the insolvency resolution process or liquidation proceeding. So this is dealing with those aspects or under the Presidency Towns or Provincial Insolvency Act. If it is pending in any court or tribunal, that shall stand transferred to the NCLT dealing with the insolvency resolution or the liquidation of the corporate debtor. As far as section 4 is concerned, there is section 60 subsection 4. NCLT shall be vested with all the power of the DRT as contemplated in part 3 for the purpose of subsection 2. I said for the purpose of subsection 2. That means if the guarantee is being invoked and if the guarantee was given on behalf of a company or the LLP, and if the company or the LLP commits any default, then in that circumstances, that creditor will move before the honorable tribunal, and honorable tribunal shall have a jurisdiction to entertain and dispose of such application. There is one question which I'm framing or just I'm placing before all the learned participants. I'm a director of a company. Presently, that company is having a healthy business. At this moment, the company is a going concern, not in CIRP, not in liquidation. Neither are any chances wherein any application is going to be made against the company for CIRP. So in near future, the company will survive. Company is happily doing its operations, a going concern. I was a director of the company, but recently I tendered my resignation. Please take care of this question. मैं कंपनी का डायरेक्टर हूं या मैं कंपनी का डायरेक्टर था. आई वाज ऑन द बोर्ड ऑफ वन ऑफ द कंपनी. दैट कंपनी इज प्रेजेंटली अ गोइंग कंसर्न or that company is presently a solvent or in a position to discharge its liability as and when it became due. So in near future, there are no much chances that that company will go into the CIRP. But my question is, since I tendered my resignation from the board and I have extended guarantee qua director of the company. Since I was on the board, I extended a guarantee, I signed the guarantee deed. But presently, since I am no more on the board of that company, I want my guarantee to be recalled. I want to withdraw my guarantee. I want to take that guarantee which was extended. I want to take guarantee back. But the company's board of directors are not extending any additional security, and that's why my guarantee, that bank is not discharging me from being a guarantor. My question right now is, what is going to be an option available with me in such circumstances? Because when you see section 60 subsection 5, does it mean that everything which is within the sky can fall under subsection 5 of 60? Or can I have any, or whether NCLT's jurisdiction or NCLT is having the jurisdiction to delve into such cases? Because as I said, today the company is not in CIRP, but tomorrow if the company will go in CIRP, and in case if that company commits a default in payment to the secured creditor, of course the creditor is going to invoke guarantee. But since I left that company, I resigned the board of that company since long, and thereafter I was having no control over the operations of the company, but just I was a guarantor. Can that guarantee be invoked against me? Yes, if that guarantee is not withdrawn or if the bank is not discharging me. In that circumstances, can such application be made under subsection 5? Because subsection 5 deals with, notwithstanding anything to the contrary contained in any other law for the time in force, NCLT shall have a jurisdiction to entertain and dispose of any application or proceeding by or against a corporate debtor or a corporate person. Any claim made by or against the corporate debtor or corporate person, including claim by or against its subsidiary situated in India, any question of priority or any question of law or fact arising out of in relation to insolvency resolution or liquidation proceedings of the corporate debtor or corporate person. Now, my question is very, and since I was reading this particular part, there was the another case which was before me, wherein a outgoing director or a director who already tendered resignation months back is struggling to get his guarantee withdrawn just because of the present directors of the companies are not willing to extend the additional security. In that case, a company which is a going concern, can section 60 subsection 5 be invoked or not? So this is a question. Going through the provision of section 60 subsection 5, under which section of multiple applications are being made.
Vinitji, if they are not related parties, if they are not promoter, the person who has resigned, like you rightly said, If this person has resigned prior to any stress in the company, obviously he has a right to give notice to the bankers, asking them to release his security so that a new security, if required, can be taken. If not, they can recall their loan extended or the debt extended. Now,
This is, I understand your point, sir,
okay,
but this
that
is
is
the
a
limited
simple.
concern.
Got your point, sir. So this is a simple solution in the ideal world,
Hmm.
right? You are moving out, you are removing your guarantee, you are asking the company to give a new guarantee. If new guarantee is not given, you withdraw your debt. Right now, the company is not in stress. They will return your debt. They should return your debt. If they are not able to return your debt, they will be compelled or bound to provide another guarantee of yours. But yes, what you have rightly raised is things are not happening this way. And at times, even like directors, like the outgoing directors, they also did not care because they never knew that IBC 2016 will come to haunt them. Now, yes, that is uh, you know a dragon which is after their life, and since no subrogation is also allowed, they can't
That
escape.
is, and that is the unaddressed concern. And this is happening in most of the cases where there is a management disputes. On the one side, they are removing me from the board of the directors of the company. And since I was a director at the time when the guarantee was or guarantee deed was executed, now today, if you are initiating an action against my removal, for that I will be invoking or I will be willing, the first thing which I would be willing, since I will be having no control after my removal with regards to the affairs of the company, I will be willing to move an application before the particular bank that let my guarantee be released or let I should be relieved as far as my guarantee obligations are concerned. In such circumstances, banks are going to be very centric in their approach. They are going to be remain self-centric in order to protect their interest. They will prefer the same matter before the existing management, and no existing management is going to extend any guarantee. In that circumstances, the big difficulty is where to approach in order to get myself relieved from that contingent liability which is going to arise if the company is going to make any default. And
Vinay,
for
Vinay,
that default, I
let
don't have any control because I am no longer on the board of the company.
correct. Vinayji, but none of these directors, believers, whatever we come across, they have never written to the bank to release their guarantees.
Absolutely, yes.
If they have given in writing, they have a fair defense when it comes to 95, that why you are invoking against us when we have been telling you for last 3 years. If they
Right.
would have done that part, bank would not be in a position to invoke those 95. It would have been even more difficult. Though we all know that invoking even 95 is a big task these days. But if that letter is there, those communications are there, follow-ups are there, I don't think directors, outgoing directors in a healthy company should have issues.
Yes. Now, ultimate question, which is right now still unanswered or hanging. Now, in that case, in such circumstances or in given circumstances, the company is not in stress. The company is solvent, discharging its obligation and liability as and when it becoming due. In such circumstances, if I take the benefit of section 60 subsection 5 and approach honorable tribunal, whether honorable tribunal is going to dealt into such application wherein the CD is not in distress or no application against the CD is pending before the tribunal pertaining to CIRP or liquidation. Just I'm approaching the tribunal. It's a question which requires to be addressed, and I'm approaching that it's a question of law. Now, whether in this given circumstances, NCLT is going to entertain such application or not, because I have not seen any precedent
Uh,
which help. Yes,
Vinayji, I would like to answer that if with my limited knowledge.
correct.
See, you approach 60/5 when it is IBC.
Absolutely.
Now there is no IBC. You are saying company is healthy, going concern, no stress. So why will you approach under 60/5? Why don't you approach under Companies Act to the same NCLT on Mondays, in Delhi, and ask them to remove you, which is a much simpler application instead of going into 60/5. So never file under 60/5 because you are not in IBC. IBC only when there is stress. When you want to remove yourself from the position of a guarantor, approach NCLT if bank is not taking any call under the Companies Act.
The same question is going to be raised by the Honorable Tribunal, that
Yeah.
is this your limited issue? If yes, if the limited issue, then under what provision you are coming before this tribunal? And when I say this is Rule 11, which gives you an inherent power to settle the dust of this nature, that is something which is the primary question. Or the same thing, suppose if that company is into CIRP, and if the guarantee is invoked, and today if I'm approaching with the same grievance that since I was removed from the board, or since I tendered my resignation from the board with effect from this date, and this initiation of CIRP was made later on, commenced on this date, and therefore I should not, or this application is not maintainable. Now, whether NCLT is going to have any soft corner for such nature of applications?
Viniji, now this is second issue you have raised. First one we have answered that if it is not under IBC, let's go directly in the Companies Act.
Correct.
11, you rightly said. Now CIRP has already been initiated. You did not do anything prior to initiation of CIRP.
So yes, when I was on the board, there was no default committed by
Yeah,
the
but now
corporate
you
debtor.
want to take, but then you also did not take any action to remove yourself from the liability.
Action was initiated, and probably because the action were initiated, it allows me to get rid of Section 95 application which is pending before me. So that is what that is what is going to be the outcome. And I think these problems are going to be nowadays, which will be coming before the bench. The reason is, as I said, the practical difficulty which the court has not settled is pertaining to my subrogation right. Because giving a guarantee is something which gives me an equal footing as a creditor. But after invocation of guarantee, I will be having no right to claim my position back, or no right to get the power of a creditor against the corporate debtor, which is already in stress. So I think nowadays, bank will find it difficult to have a person on the board or the KMPs who are extending guarantee on behalf of the corporate debtor.
Sir, can I speak?
Yes, sir.
The solution to this issue is, in future, is that we have to put a clause in the personal guarantee agreement with the bank
Absolutely, sir.
that on a cessation of my directorship, the guarantee shall stand extinguished.
Absolutely.
That is the only thing. As on date, we cannot, the court or NCLT will not be able to offer any help to the personal guarantor. It's a contract between two individual parties. And if there is no condition that if I cease to be a guarantor, the guarantee comes to an end, the bank are not going to relinquish their right. And hence court or NCLT cannot do anything to abrogate a contract which is
Absolutely.
validly entered into. So the
And that's
personal
why.
guarantor has to face the music.
Absolutely, yes, sir. So these days, the guarantee agreements will be cautiously, it's going to be executed. It's cautiously, which is going to be signed these days now. So now let's discuss as far as the provisions of the code is concerned, as far as section or part 3 of the code is concerned. Let's have a look on that part. Now, as far as jurisdiction is concerned, the practical challenges are going to be on the way of RP when they will be dealing into the application of the personal guarantee, or the personal guarantor who has extended a guarantee on behalf of a corporate debtor which are at different location, and in favor of the separate secured creditor, those who are again located as separate location. And in that case, when I have extended a guarantee on behalf of a company which is in Mumbai and a company which is in Ahmedabad, and both the companies are in CIRP, the practical question which is going to be before the Honorable Tribunal is to identify the proper jurisdiction, more particularly in the case wherein my entire operations and my entire business affairs are somewhere located in Delhi. So there will be a jurisdiction which is there in Mumbai. Since I have extended a guarantee on behalf of a corporate debtor located in Mumbai, I have extended a guarantee on behalf of a company which is located in Ahmedabad. I have extended a guarantee on behalf of both this corporate debtor in favor of their secured creditor, and my operations are primarily running somewhere in the north, which is in Delhi. So this practical difficulties which is going to be faced by the RP, and the tribunal will gradually, or the NCLAT gradually, or the Supreme Court gradually will iron out such creases which is going to be there in. Yes. So as far as part 3 is concerned, I will be dealing into that part first. Will be dealing with the rule, and that rule is the insolvency and bankruptcy application to adjudicating authority for insolvency resolution of the personal guarantor. So as far as this rule is concerned, these rules are again notified with effect from 15th day of November 2019, but it has been made effective from 1st December 2019. So we will be dealing into the rules, and thereafter we will be dealing with the regulation. That regulation again, as far as the notification is concerned, again 15 November 2019, effectiveness of that regulation is concerned with effect from 1st of December, and that is IBBI, insolvency resolution process for corporate, for the personal guarantee to the corporate debt regulation 2019. But primary to deal with is part 3, section 94. But before 94, let's have a look on the definition part. Now this is as far as part 3 is concerned. Now this is the insolvency resolution and bankruptcy for an individuals and partnership firm. It's always, we used to say that unsuccessful end to a CIRP results to a liquidation of the corporate debtor, and this is the same case here. Unsuccessful end to an insolvency resolution of the personal guarantor that results to initiation of bankruptcy proceedings. So what we call a liquidation in case of a company or a corporate person, we used to call a bankruptcy in case of an individual or a personal guarantor. And since we are only going to deal into those category of the individual, we are not touching upon a partnership firm or a proprietorship concern. We are neither dealing into the case of an individual, but we are dealing with the personal guarantors. So as far as section 79 is concerned, section 79, there is a definition which is provided, but the most vital one to take care of is excluded asset and excluded liability. That is an excluded debt. So as far as the excluded asset is concerned, excluded asset for the purpose of this part includes, so considering this exclusions, they will not be forming a part of what we call a liquidation asset in case of a company. Unencumbered tools. So it is very important, as what was mentioned before a few minutes, that agreements require to be cautiously drafted. Unencumbered tools, that means if there is no lien, and this is what you need to check, because the provision, the section 79 subsection 14 of the code will give you an immunity to keep it altogether away from the proceedings. You are supposed to have an agreement in a manner which actually you can take the benefit out of this exclusions. Unencumbered books, unencumbered vehicles, but make sure it should be unencumbered. Equipments as are necessary to debtor or bankrupt for its personal use or for the purpose of his employment, business, or a vocation. So it has to be unencumbered. Unencumbered furniture, household equipments. There is some noise which is coming. I request the participant to mute. In case if there is a question, we will be having a healthy discussion on the same. But if this can be muted, this will remain uninterrupted. So excluded asset we are dealing into. But I must say, while drafting the guarantee agreement, you need to check that you have not extended a security over such vehicles or equipments which otherwise are necessary for you for the purpose to carry on your employment, business, or vocation. Similarly, unencumbered furnitures, household equipments, and provisions as are necessary for satisfying the basic domestic need of bankrupt and his immediate family. We will be dealing into immediate family, which includes dependent children and parents. All any encumbered personal ornaments of such value and the value which is there in the rules, we will be dealing into that. That is up to an amount of rupees 1 lakh. Debtor and his immediate family, which cannot be parted with in accordance with religious usage. An unencumbered LIC policy, life insurance policy, pension plan taken in the name of debtor or his immediate family, that is going to be untouched. Unencumbered single dwelling unit, residential unit owned by a debtor of such value as may be prescribed, and the value is there prescribed in the rules, which is of rupees 10 lakh in case of rural and 25 lakh in case of an urban. Excluded debt, meaning thereby you will not be discharged in case of repayment plan. This liability will not come in between. So that is a liability for which you cannot move an application under 94. It's a liability to pay fine which is imposed by the court or a tribunal. Liability to pay damages for negligence, nuisance, breach of a statutory, contractual or other obligation. Statutory obligation, contractual obligation, and a legal obligation. Liability to pay maintenance to any person under any law for the timing in force. Liability in relation to a student loan and other debt as may be prescribed, which is not so. Immediate family including spouse, dependent children, and parents. So I'm dealing into that repayment plan. This is what we are going to deal with. So this is going to be a plan which is going to be prepared by me. If I'm the personal guarantor, I'm going to finalize, I'm going to propose a plan. So I will draft the plan in consultation with the resolution professional. This plan will be later on proposed before the committee of creditor. And this plan includes a restructuring of my debt. So this is why we are going to deal under section 105 and 06 of this particular code, which deals with a personal guarantor. Repayment plan means a plan which is prepared by a debtor, that is a personal guarantor. In this case here, for a debtor, we will be using word personal guarantor in consultation with the RP. There is no provision which talks about IRP or RP or liquidator. It is all about RP. Under 105, containing a proposal to the committee of creditor for restructuring of its debt. So basically, I will prepare a repayment plan in consultation with the RP, which carry a proposal to the COC, which allows me to restructure my liabilities. RP is something which is insolvency professional appointed under this part as a RP for conducting fresh part process or insolvency resolution process. So I'm dealing into section 94, and while dealing into 94, I will be taking care of the rules also. But first we will be taking care of 94, we will be dealing into 95 first, and then we will be taking care of the rules. And the rule is all about insolvency and bankruptcy, application to adjudicating authority for insolvency resolution of a personal guarantor to a corporate debtor rules 2019. As I said, notified on 15th November 19, but made effective from 1st December 19. 94. Chapter 3 of Part 3. Application by a debtor. Here I will be using word application by personal guarantor to initiate insolvency resolution process.
So can I ask one question?
Yes, sir, please.
So many times in this insurance process, when you are taking the action under SURFACE, they will file the application under section 95 and they will get the moratorium, and the secretary is not able to take action under SURFACE. So how to
Absolutely.
deal with?
In that circumstances, that is the ultimate interim moratorium and moratorium, same what we have in section 14, which allows a corporate debtor to invite a resolution plan in order to get out of the CIRP. Same thing is going to apply here. If an application is pending against me, not only SURFACE but also under the RDB, recovery of debt, when a banker has moved against the guarantor of the borrower, a principal borrower, But as far as section 94 is concerned, the moment I will invoke 90 or moment I will be filing under 94 or moment a 95 application will be made against me, in that circumstances, automatically that will comes to a standstill position till completion of the insolvency resolution process.
Can we take that till the time that application is, approved by them, or just filing is only mere moratorium start, or it
Moratorium
required
will
to be?
start immediately upon filing, and that's why there is a provision called interim moratorium. This interim moratorium will be lasted till the admission of application under 100. And once the application under section 100 will be admitted, the moratorium will start, which will be having a validity up to 180 days. That is still the approval of the repayment plan, or in case if the bankruptcy order is passed, till that the moratorium will safeguard me that no action will be initiated against me. And if already initiated it, then in that case, that will not be run against me. So for the time being, there will be a stay on those proceedings.
So being a secured creditor, I'm at the loss if someone goes and file 94, 95 and get the interim moratorium. So my other actions comes to standstill.
Absolutely. So
And
this is what you need to
taking
decide that
advantage. It's like
absolutely.
basically the borrower, a secured debtor, is taking an advantage of this. By getting it.
Secured creditor is taking advantage of it.
Debtor. I said debtor, not creditor.
Debtor.
Debtor.
So that is what the role of RP will come to, or RP has to play its role during this phase of 94 to 99. You need to check the intent with which an application is made. And you will find more of section 95 applications which are being made. I don't know why the secured creditors are not preferring to go to invoke SARFACI, and they are moving section 95. The reason is very singular.
No. In this case, in our case, like what I am discussing is that
I got
have
your
already.
point. I got your point that the personal guarantor is moving 95 application,
Exactly.
getting the benefit of interim moratorium, and because of which the right of secured creditor under SARFACI, under
Yes.
any other act, they may
Yes.
not be able to invoke. So this is the fact. Ultimately, the objective, same question will goes to the corporate debtor also. Once the insolvency application is admitted, you don't have that choice of invoking a cross litigation before the DRT under SARFACI. That is the law. The intention is
Exactly.
resolution, not recovery
But
again.
they are getting only aggrieved by my action under SARFACI. Of that, they will go and file some application before DRT for the stay of that, which they are not getting reliefs because they have to make some payment, upfront payment, part payments and all.
And that's why they are moving under 94 and they are getting the
Exactly. So
benefit of interim
this is the cheapest and the easiest way for them to not to pay
Absolutely.
anything.
Absolutely, yes, sir.
So today we are like here. Well, basically, why I am here and my team is here to understand that what would be the way out. Like, how would I think that to come out to bring
No,
that?
sir. One thing is very clear. You cannot see, as far as the SARFACI is concerned, it has very clear objectives. As far as the insolvency code is there, it is having its own objective. Now, suppose you are basically a secured lender, extended some credit facilities to a corporate debtor, and on behalf of a corporate debtor, I, in the capacity of director, has extended a guarantee. Right? It was you who initiated an application against me under SARFACI.
Yeah.
Under SARFACI. Now, my point is whether you moved any application under section 7 before the insolvency code, before NCLT. My question right now before you is,
So even if that was there, that was against the company and to their assets. But
absolutely.
what I have tried to do is that to the same company, there were the personal assets of the guarantors, which we invoked the SARFACI, that I can fire my guns on both the ends, like it may be in DRT SARFACI and even through the NCLT. Now
you
in here,
cannot. That is my point is,
how?
suppose if that company is in CIRP, if
Yeah.
the company is in CIRP, in CIRP, you will be dealing into whatever may be your claim as a financial creditor is, that is going to be dealt in the resolution plan. Suppose if the resolution plan is
That is
coming
okay,
before
sir.
the RP.
That is
But
okay.
now here, I'm coming to your point.
Hmm.
You accepted the haircut as a member of the COC. You accepted the haircut as a member of the COC. Now you feel aggrieved that since I accepted a 20% haircut or any percentage of haircut, now I want to recover beyond what is something which I left upon or which I sacrificed in the plan. Now, today you want to avail the benefit. You want to avail the benefit of having the options which are available before the SARFAESI. You want to invoke a guarantee. RDB Act you are choosing. But contrary, I will be having an option which is given under this code to resolve my position as a personal guarantor. Now, you are having a mindset, you are of that belief that since I'm approaching under 94, my only intent of approaching 94 is to bring an end to the litigation which is initiated by you before the DRT. I will be showcased. My intent is to resolve my distress by the way of repayment plan or resolution plan. So I moving an application before the NCLT on through the resolution professional. That resolution professional is filing a report, taking a conscious call with regards to the intent. That intent is to get out of the distress. Of course, in that circumstances, you have to deal with your claim in this insolvency proceedings which are pending before the NCLT and not before the DRT. The reason is very clear that since the IBC will be having overriding provision, what treatment a corporate debtor has received in the IBC, the same treatment I'm going to avail in section 94. Whether you believe for the sake of safety I'm doing it or for the sake of resolution I'm doing it, but once I move an application under 94 and once that application is getting admitted, you have to deal with your claim in the insolvency process and not before DRT. And that is the objective of the code. That is the objective of the code. The objective, you can take it on other way, that objective probably may be to avoid the litigation or to avoid being answerable before the DRT. But this is the insolvency resolution mechanism which is given under the code. If suppose if this moratorium will not be provided to me, ultimately these things will ended up with two different jurisdictions. You will be recovering my asset out of the SARFAESI proceedings, and my other creditor, those who are unsecured, will be crying before the NCLT that why different treatment. So that is the only reason what section 14 benefits CD, section 94 benefits me as a personal guarantor.
Okay, but being a secure creditor, I will be definitely doing that, sir. And I need a recourse out of that. So today will further discussion will be on that point, that how an RP or 95 or under 94, I would be getting out early, because this is taking so much of time. Because on mere filing of an application, the moratorium starts, interim moratorium starts, and everything comes to standstill. It is taking around a year and a half to get that application on board. And then my RP or my advocates will be coming on board and saying that this was with an intent to just to avoid or to constrain the secure creditors from taking any further action, and there was no other course. There were not suitable evidences or documents produced before the court
Absolutely.
about the unsecured creditor coming and filing all this stuff. So, well, that is the reason. We'll discuss this, sir, later.
See, let's come into it once again. Everyone who are participating in this programs are aware that what is the intent of section 7 or 9 application. We know the inherent objective is just to recover, and we are least concerned about the stress or distress of the corporate debtor. Now that is an intent. When you move an application under 7 or under 9, the intent is very singular, and that is to get recovery of my claim, and that's it. But as same thing happens here also, as far as the spirit of law is concerned, I will talk about the spirit of the law before the NCLT, even though my intention is to defeat the purpose of. Are you getting my point or not, sir?
I'm getting your point. See, I'm trying to understand. Still, I'm trying to understand. How would I get out of this? You help me out.
I got your point. So as far as your remedy is concerned, at this moment, I will say only one thing, that I know if there is a fire against me before a forum, and if I have something to avoid that fire, I will be invoking that, even though my principal intent is not a resolution to my stress. I know when I know that if I'm having no resources to get out of the present situation, but contrary, now as far as now my point is, now what damage it will cause, because you are a secured creditor. You are a secured creditor in whose favor the guarantee is extended. In what happens, suppose if you don't choose DRT, and if you choose even under section 94, your rights are going to be safeguarded. why
My rights
DRT?
are see, my rights are definitely safeguarded, sir. I'm not denying that. No one
Correct.
can do anything. Neither he, neither me. No one can do anything. But the
That is
point
what my
is,
point is.
there is a
Sir,
delay.
moratorium. There is some disturbance.
Hey. Mr. Jitendra, can you please?
Yes, sir. So let's have our discussion on. Now, my point is, interim moratorium, how interim moratorium is going to benefit me? The only manner in which the interim moratorium will benefit me is the litigation will not be initiated. And if we already initiated, that will comes to an end for a time being.
For either of the sides, sir.
No, I'm reaching to my conclusion. I'm reaching to my conclusion. See, you are before DRT. You are before DRT. Before DRT, I will be the respondent. I will be responding to your claim. That litigation will not ultimately bring an outcome which you exactly want. You want a recovery out of my asset, which can be very well recovered in this NCLT application. Because in the NCLT application, I will be proposing my plan. And when I will be proposing my plan, I will be admitting. There I will be contesting to your claim. Here I will be admitting to your claim that you are a secured creditor. You have both the choice open. Either relinquish or else not to relinquish and deal into the secured asset by your own way. See, there is a possibility of early resolution in section 94 rather than before DRT. The timeliness are which are very specific here. The moment section 100 application will be admitted against me, the RP will be the authority. The RP will give you altogether a different treatment as a secured creditor, and he will try everything out to sell out that asset just in order to discharge your liability. And secondly, I think the solution which you are going to get under section 94 will be far quicker and will be litigation free in comparison to what you will be getting in DRT. If you have some other thought in this regard, please explain, sir.
I definitely have. I'm not agreeing to this because in DRT, at some particular case, I was at the verge of getting the attachments over the properties and the lease rentals and everything. At that same moment, when the order was yet to be passed, the final day of passing the order, the secured debtor, one of the guarantor comes and says that there is an interim moratorium against me because Section 95 is filed.
Okay.
The entire order got stuck. After 1.5 years, the matter is still yet not listed. After 1.5 years, DRTPO has put my original application along with the IFR attachment under ambience and said that now we cannot decide this because we cannot keep it open till the time this interim moratorium comes to end. So that's why my OA was disposed of and kept aside with liberty to reopen. So I'm completely like nowhere. 150 crores of claim, I'm stuck. I cannot do anything.
Coming to that part. Now, coming to that part.
Sir, don't take it otherwise, sir.
No. See, it's all about.
I'm trying to understand is,
and I'm trying to make you understand
from
that.
the other hand. You may be talking from the guarantor's hand, but
Absolutely.
I'm talking from the end of the. You are trying to show me that what remedies other people have, what remedy the secure creditor have. I have the remedy with that is very nice and also, but the delay which has caused in this entire process and then getting stuck with all the litigation, sir. Now in here only secured debtor was benefited and not me. So how I get out of this?
Sir, that is what my point is. Now, suppose it was the SARFAESI action which you initiated. The property was put for
not
auction.
Not only SARFAESI. I initiated RDDB Act where I wanted an attachment over the lease rentals, also an attachment over the other assets owned by the guarantors.
Correct. And there I was contesting to all those applications.
You were.
Yes. Here, there is no question of contesting to any decisions which are being taken by the RP. I moved an application admitting the fact that yes.
Sorry to interrupt. But when in the RP comes in, sir, here 1.5 years spent on RPS, yet not on the record, sir.
The only reason of delay till date was the thing were challenged before the Honorable Supreme Court. Today, I don't see any kind of delays which are being taken place by the NCLTs. Section 95 application and 94 applications are contest free. If I am moving before the NCLT admitting my liability, there is no one who is going to challenge. There is no other than the ultimate conclusion of this application is admission only. Nowadays, if you see, these applications are being admitted in a month time.
Also, Vinitji, we can give an advice to Mr. Devang that don't contest it further. Let it get admitted. Why? So it will
Absolutely.
solve some purpose.
Ek minute.
somehow.
Devvart sir, what
Let
I'm saying is, I'm okay. Your advice is very well welcome. And I am actually not contesting. I wanted to get to admitted. I wanted the
Absolutely. So
application to
at
get
least the
admitted, but
process
let
will
it come
start.
on the board, sir. That is also
Absolutely.
not happening.
Now, sir, our problem is
Sir, that is the
this
problem with
forum,
our
we
judicial
cannot do
system.
much about it. That is our only trouble. The NCLTs have their own way of working. Hopefully, they are not the DRT way, but yes, they are also a little slow in that.
Sir, I have also one submission.
Please, sir.
My 99 report is filed since over 2 years. I'm still awaiting that.
Exactly.
Sir, I think.
Good, Jitendra ji, you are on the point.
And sir, I really empathize with the gentleman. I did not get his name. That the corporate data by filing under Section 94, he got away with the moratorium.
Jitendra ji,
That
my
was only because the
bankruptcy,
Supreme Court had not decided.
Jitendra ji,
So-
my bankruptcy application is pending for 2 years. Forget in
Yes, sir.
personal insolvency.
Sir, sir, just on a lighter side, my dissolution application is pending over 2.5 years.
Absolutely. So those are
Yeah.
things which this forum cannot help you, sir. We cannot.
Absolutely. So I can understand what the bench is feeling at this moment when all grievances are being referred before the Honorable Tribunal from Monday to Fridays. I think they are the right authorities to expedite the case, especially in 94, because when 94 application is being made, there is no reasons for any delay beyond a prescribed deadline which is there under the code.
But sir, by that submission, even section 10 should be admitted as soon as possible.
But section 10
But
application, the
even
intent of
section
section
10
10s are not fair. No.
nobody
I'm
admitted.
not with the same view. When you see section 10 applications are being made, you can check what was the balance sheet 2 years back and what is the balance sheet they are proposing at the moment when they are filing section 10. So I'm absolutely not at all in line with your thought process as far as section 10 application is concerned. Section 10 application takes more larger time than section 7 and section 6, because section 7, they have to prove their justification. They have to show that there was the bona fide leading to which, or they have to show the actual distress which the corporate debtor has they have faced or they have derived out of the economic crisis or the industrial constraint. So I think section 10 applications are very well being adjudicated by the NCLT, and the rejections are because section 10 applications, if it will be lightly accepted or it will be formally accepted, the corporate debtor will be having a solution to get rid of every such litigation or every such claims. I don't think so that section 10 there is requirement to have any lenient views. I think we should proceed with 94 if the forum permits.
Yes, sir. Please proceed. We'll also try to find out a way how we can.
Absolutely, sir. Thank you. So 94 is something which it was a point wherein there were multiplication of views or there was divergent of views. But yes, section 95, which is the application which is going to be made by a debtor, and here I would like to confine my discussion to a personal guarantor, commits a default may apply either personally or through RP to adjudicating authority for initiating insolvency resolution process by submitting an application. Now, when I move section 94 application, and if the time is being taken by the honorable bench member, in that case, this is something which is not within my control, and you cannot challenge my intention of getting interim moratorium. When I'm moving an application under 94, admitting that there is a default, then in that circumstances, to admit that application, not to admit application, that is something authoritative delay, or there is a delay from the administrator part or judiciary part. Otherwise, I moved an application with a very clear hands that there is a default, and because there is a default, this application is being made. Subsection 2, which talks about a debtor is a partner of the firm Such a debtor shall not apply under this chapter. So basically it is dealing with the liability of the partnership firm. I'm not dealing into that part. Application under subsection 1 shall be submitted only in respect of the debt which are not excluded debt. So as far as the excluded debt is concerned, there is an obligation of discharge and you cannot get rid out of it. And no such application can be made for such debt which are excluded in nature. You cannot move an application if already an insolvency resolution process is going on or bankruptcy order is passed, that is undischarged bankrupt, or if a bankruptcy process which is right now moving before or against me before the NCLT, I cannot take the benefit of section 94. A corporate debtor shall not be eligible to apply under subsection 1. I'm talking about personal guarantor. So personal guarantor shall not be eligible to apply under subsection 1 if application under this chapter has been admitted respect of the debtor during a period of 12-month proceedings. So same what we have in section 11 of the code. Now section 95. When you see section 95 application, section 95 applications are being made by those unsatisfied secured creditor accepting the haircut on the one side and moving before the tribunal to recover the part of their amount which they have left out in the resolution plan. So section 95 is by the creditor or creditors, so they may move a collective application also before the NCLT. 95(1), a creditor may apply either by himself, jointly with other creditors, through RP. So there is a word or through an RP to NCLT, the same NCLT bench which dealt with or adjudicated an application of CIRP or liquidation of the CD, for initiating insolvency resolution process under this section by submitting an application. Creditor may apply under subsection 1 in relation to a partnership debt owed to him for initiating insolvency resolution process against. So we are not dealing here with a partnership firm. Where an application has been made against one partner in a firm, anyways, this is again not applicable as far as part 3 is concerned. My extent of discussion is only up to the personal guarantor. An application under subsection 1 shall be accompanied with detail and document relating to debt owed by a debtor to a creditor or creditor who are submitting an application, failure by debtor to pay the debt within a period of 14 days. So it is mandatory requirement that there is one form B which is prescribed, and that form B is for a demand notice which is required to be served upon the personal guarantor. And only in case if there is no reply, or in case even if there is a reply and not is up to satisfaction, on completion of 14 days, such application can be made by creditor in form number C, which is going to be dealt with in the rules. As far as the relevant evidence is concerned, there is always a record of default which can be extracted from the NESL. Creditor shall also provide a copy of the application made under subsection 1 to the debtor, and not only to the personal guarantor in this circumstances. The notice, the copy of the application is also required to be served upon both the guarantor as well as to the corporate debtor on whose behalf a personal guarantor has given a guarantee. Subsection 6 of 95 deals with application referred in subsection 1 shall be in such form, and this is something, as I said, that is going to be form number C. The details and document required to be submitted is also there in form number C itself. So I will be dealing, before interim moratorium will start, we will be dealing out with the rules, and that rule, as I said, this is the IBB, that is Insolvency and Bankruptcy, application to adjudicating authority for insolvency resolution process for personal guarantor to a corporate debtor. Notification 15 November and effective date of this notification, that is 1st December. I'm dealing into the rule now. And the important aspect to deal with is rule 6 and 7. Is it visible?
Yes, yes.
Thank you, sir. Now, as far as these rules are concerned, it's a notification dated 15 November 2019, and the rules are insolvency and bankruptcy application to adjudicating authority for insolvency resolution process for personal guarantor or to the corporate debtor, coming into effect with effect from 1st of December 2019. Now, when you see the definition of the guarantor, This is what we have seen, personal guarantor definition. And as far as a guarantor is concerned, guarantor is a debtor, is a personal guarantor to a corporate debtor in respect of whom a guarantee has been invoked by the creditor and remains unpaid in full or part. Now here you will find, when we see insolvency and bankruptcy application to adjudicating authority rules, there is a particular mode of service of demand notice which is prescribed. Here you will find one more peculiar mode of service, and that is, apart from communication by the means of registered post, speed post, courier, or email, which is capable of producing or generating an acknowledgement of receipt, there is one more mode which is prescribed for invoking such service or for facilitating the services, where a document cannot be served in any of the modes. If documents cannot be served in any of the modes, then in that case, it shall be affixed at the outer door or some other conspicuous part of the house or building in which the addressee ordinarily resides or carry on business or personally work for gain. So this is something you will find in this particular rules, which is mean for a personal guarantor. So you can serve the notice, you can serve an application through any of the means which are prescribed as registered post, speed post, courier. Hand delivery also will be included, electronic form, but there is a mandatory requirement which is capable of producing or generating an acknowledgement of delivery, proof of receipt of such communication. And when it is not practically possible, then in that case, you may affix at the outer door or other conspicuous part of the house or building in which the addressee ordinarily reside or carry on business or personally work for gain. Excluded asset, what we dealt with, that will remain untouched, that is going to be excluded even though insolvency or bankruptcy application is initiated and pending before the honorable tribunal. So that will include unencumbered personal ornaments, not exceed a value of rupees 1 lakh. Unencumbered single dwelling unit by a debtor, but the value shall not exceed, in case urban, if it is 25 lakh, in case if it is located in rural, 10 lakh. So this is something which is there in the rule. But this 6 and 7, these are two important rules to be taken care of before we go directly to the provisions again. As far as the application by guarantor is concerned, we are dealing with section 94 read with rule 6. When we see 94 read with rule 6, it states that application under subsection 1 of 94 shall be submitted in form A. You will find form A exhaustive, and it is practically not possible when you don't get a necessary cooperation from the personal guarantor. Shall be submitted in form A, because in case of a corporate debtor, there is other resources available. MCA data is available from which you can get necessary information with regards to its financials. You can approach auditors, you can approach their company secretaries, you can approach the banker. But in this case, if there is no necessary, or if you are not getting necessary cooperation from a guarantor, the practical difficulty is going to be faced by the RP. And that's why you will find in this particular case that this is one of the practical difficulty which RPs are facing under section 95. There is no room for non-cooperation in case of 94. But we never know, because I have seen many of the matter which are being made under section 10, and where the IRP is filing 92 application. Now, there is no rationale of moving 92 application when the application is made under section 10, but there are multiple judgment to it. So when an application is made under section 94, a personal guarantor is moving an application under 1, application will be in form number A along with the application fees of 2,000 rupees. Guarantor shall serve forthwith a copy of the application to every financial creditor and corporate debtor for whom the guarantor is a personal guarantor. So there is a requirement of serving a copy of the application to each financial creditor of a corporate debtor in whose favor the personal guarantor has extended a guarantee. So this is quite important, that guarantor shall serve forthwith a copy of the application referred to in 94(1) to every financial creditor and also to the corporate debtor for whom the guarantor is a personal guarantor. Application by a creditor. When application is made under section 95, that is by creditor or creditors, there is a prior obligation on them to serve me a demand notice in form number B. And they should give me an opportunity of 14 days to respond to that demand notice. A demand notice under clause B of subsection 4 of 95 shall be served on the guarantor demanding payment of the amount of default in form B. The application under subsection 1 of 95 shall be submitted in form C along with the fees of 2,000 rupees. Creditor shall serve a copy of the application to the guarantor and to the corporate debtor for whom the guarantor is a personal guarantor. So if application is made under section 9, under section 94 by a guarantor, I should serve a copy to the CD and to the financial creditor on whose favor I have extended a guarantee on behalf of a CD. And if the application is being made by a creditor, then a copy of the application is served upon the corporate debtor as well as to the personal guarantor. In case of joint application, creditor may nominate one among themselves to act on behalf of all the creditor. Now, there is a provision as far as the copy of the application is concerned. The applicant shall provide a copy of the application file under 94(1) or 95(1) as the case may be, if not provided earlier, to the RP within. So basically, there is an option which is available that you can move section 94, 95 application through the RP, but if the RP was not proposed, then RP will be appointed by the NCLT and you have to serve them a copy of the application. And here also there is a provision what we call a withdrawal of application, both prior to the admission of application and post admission of the application. So adjudicating authority may permit withdrawal of the application under rule 6 or 7, that is 94 or 95, as the case may be, before admission on request made by the applicant. But here you will find after admission on request made by the applicant, if 90% of the creditor agree to such a withdrawal. And here you will find 90% in numbers and not in value. So after that is 12A nature provision, this rules is just like section 12A of the IBC. After admission on request made by the applicant, if 90% of the creditor agree to such withdrawal, and for that FA is prescribed for 12A. Here you will find that application will be made in form number D. So this is for the limited purpose of understanding 94 and 95 read with the rules. Now when we again go back to the rule provisions of the code, we have section 97 or 96 to deal with the interim moratorium. Now this is section 96. Which is subject matter of deliberations before few minutes, that 94 is being invoked or section 94 application is being made just in order to get rid of all the pending litigations against me. Probably yes. As far as 96 is concerned, interim moratorium. When an application is made under 94 or 95, an interim moratorium shall commence on the date of application in relation to all the debt, and shall cease to have effect on the date of admission of application. But again, then interim moratorium will comes to an end and moratorium will start. So when an application is filed under 94 or 95, an interim moratorium shall commence on the date of application in relation to all the debt, cease to have effect on the date of admission of the application. B, during interim moratorium, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed. The creditor of the debtor shall not initiate any legal action or proceeding in respect of any debt. So that was one of the major concern of the lenders. Where the application has been made in relation to a firm, the interim moratorium shall operate against all the partner of the firm. The provision of subsection 1 shall not apply to such transaction as may be notified by government. So that is something which is still not notified in this case, which are the other transaction. 97, as I said, that the appointment of RP will be either on the basis of the one who moved an application or the RP whose name was proposed in the application of 94 and 95, that person will be appointed as an RP. But if there is no such proposal with regards to RP in that application, that tribunal out of their panel, they will appoint the resolution professional. 97(1). If the application under 94 or 95 is filed through RP, the adjudicating authority shall direct board within 7 days of the date of application to confirm that there is no disciplinary proceeding pending against the professional. So this is quite theoretical. Otherwise, the one whose name is proposed get appointed as an RP, where application under 94-95 is filed by debtor or the creditor himself, and not through RP, the adjudicating authority shall direct board within 7 days of the filing. So it is the NCLT which is going to appoint RP in that section 97. Now, when you find section 97, it deals with the appointment of RP. And when you see 98, this is the power of the personal guarantor or power of the creditor to replace the RP at any stage. Where a debtor or the creditor of the opinion that the RP appointed under 97 is required to be replaced, he may apply to adjudicating authority for the replacement of such RP. The adjudicating authority shall within 7 days of the same thing. It is the tribunal which is going to appoint in that case, because till date, the committee of creditors are not constituted. And this is what provided the erstwhile RP has to share all the information and details or the documents to the new RP, which is being appointed by the order of the NCLT. Now, this is the crucial point, that section 99 application, which is pending since years, and there is no purpose not to deal with. I can admit that since it is pending since 2 years, 3 years, because, and one should also understand that there was a stay on the application. I'm coming to all your consent that it was pending since 2 years or 3 years, but I don't think so that bankruptcy application was pending for 2 years, because after that Dilip Jivraj ka judgment of Supreme Court, which is in the month of November 2023 onwards only, that was of the November 23, and thereafter only, see, personal guarantee applications are being touched upon by the NCLT, and there was stay by the Supreme Court not to deal into such application. That was the only reason your grievance was pertaining to pendency of last 2 years or pendency last 3 years, because we as an RP or IRP is of the opinion that yes, once I have given my consent to act as an RP in personal guarantee application, but what in case if there is a stay by the Honorable Supreme Court only? So that is one of the concern. In Dilip B. Jivraj ka case only, the Supreme Court has cleared the dust, has ironed the creases, that section 94 applications and 95 applications can be dealt upon and can be adjudicated. Otherwise, the provision of section 95 to section 100, the constitutional validity was challenged before the Honorable Supreme Court. And because of which, no 94 or 95 applications were being dealt by the Honorable Tribunal. And you will find the interim order of all those 2 years proceedings. I hope I can, or I have touched upon that point of, on behalf of the benches, that for what reason the applications were not being adjudicated by the Honorable Tribunal.
I have one small point, practical.
Practical point. Yes, sir.
After admission, an advertisement is required to be given for inviting claims. Who bears the expenses for advertisement?
It is going to be an expense.
Initially.
Absolutely, by this only, this RP only. This is going to be a cost. CIRP cost, what we deal with. And here you will find, these days when you will go to any bench of the NCLT, you will find a notice board wherein such publication is also. And you will find the language of the law. Here, the adjudicating authority is also under an obligation to give a publication. And that's why they generally give the said publication in their notice board or in the website. But yes, expenditure part is concerned. This is again, what you said is a practical difficulty, because on the one side, your appointment is confirmed. When that publication is required to be made, it is only out of the expenditure which is going to be initially going to be borne by you only as RP. And that is going to be the cost firstly recovered out of the repayment plan.
Vinitji, just one thing, in Bombay, NCLT, also Mumbai, they have asked applicants to submit 2 lakh rupees to RP to cover the fees and expenses.
Yes, many where it is going. Section 94 application में ऐसा हो रहा है.
Yes, yes. So 94, no, even
in 95 also many of the courts are giving. But
Yes.
in many cases, still they are not giving. In that
Yes,
case,
yes.
normally applicants and the RP are talking themselves, and applicants are being a banker are at times giving the advances to the RP.
Absolutely. In 94, I've seen that this kind of provisions are being made. In
Yes.
95 application, again, many of the benches are taking this conscious call of directing the guarantor applicant to, or in case if the bank is moving such application, yes, it is going to be a cost to be recovered at the time of that is revival plan, what we call a repayment plan here in this case.
No, Vinit, what I wanted to say is if the panel is being appointed, if the person is being appointed from the panel, because see, if it is proposed, then that person must have discussed this aspect
Absolutely, with the
already.
applicant.
But if it is from the panel, then NCLTs are aware of the fact that this
Yes,
cost
tribunals are taking care of the RPs
correct.
and the consequences which RPs are going to face post admission. Yes, sir.
Initially, it was not there, sir, first few months, but now it is there. It is
Yes,
fine.
when practical difficulties are being addressed to the bench
Correct.
are taking this particular conscious call. They are giving this kind of a leeway to get a recovery out of it. So yes, there are the benches which are imposing such order or imposing such cost to be defrayed.
Different benches are taking different steps. In case of panel appointment also, in some of the cases, the member has not given any advance. But in most of the cases, now they are giving.
Absolutely, yes, sir. Now, this is a crucial stage from where the things take some turn. 99, submission of report by RP. As far as the RP report is concerned, RP simply need to examine the application, which is under 94 or which is under 95. And based out of that examination of the application, they have to submit their report to the Honorable Tribunal. And Honorable Tribunal accordingly takes a final call. Now, RP shall examine the application referred in 94 or 95 as the case may be within 10 days of his appointment. And this is something which is, again, I would like to say, discretionary power of the tribunal, and submit a report to the adjudicating authority recommending for the approval or rejection of the application. So something which is required to be done within 10 days and RPs are conscious of this timeliness of 10 days. But again, you will find within what frame or within what timeliness even NCLT have to take this decision of admission of the application or rejection of the application. But again, that goes a discretionary power. What we have section 7(9), they have to take call within 14 days. Where an application has been filed under 95, the resolution professional may require a debtor to prove the repayment of the debt claim as unpaid by the creditor. So basically, opportunity is given to the debtor to prove that payment was made to the creditor. Evidence of electronic transfer of the unpaid amount from the bank account of the debtor. Evidence of encashment of check issued by the debtor. Signed acknowledgement by the creditor accepting. So opportunity will be given to the debtor to prove that. But I think not only this, much prior to that, creditor is already under an obligation to serve a notice of the copy of the application to the personal guarantor. But one more opportunity, which is there under 99(2), is required to be given. You will find this where a debt for which an application has been filed by a creditor is registered with IU, a debtor shall not be entitled to dispute the validity of such debt. This is authentication of debt by IU versus a dispute, a pre-existing dispute or a dispute raised upon issuance of demand notice. Nowadays, the tribunals are considering the validity of the dispute in IU portal. They are giving a great amount of weight to the authenticity of debt as far as the NESL is concerned. So here it is same thing which is provided where the debt for which an application is filed by a creditor is registered with IU, the debtor shall not be entitled to dispute the validity of such debt. Many times the emails received from NESLs are not responded on time, and because of which the authenticity of debt turns to be authenticated. For the purpose of examining an application, the RP may seek further information or explanation in connection with the application as may be required from the personal guarantor, creditor, or other person who in opinion of the RP may provide such information. person from whom information and explanation is sought under 4 shall furnish such information and explanation within 7 days. These all deadlines are discretionary. The RP shall examine the application and ascertain that application satisfy the requirement of 94 or 95, as the case may be. The applicant has provided information and given explanation sought by RP, and after examining an application, he may recommend acceptance or rejection. Where RP find the debtor is eligible for fast start, I'm not touching upon that, that is not yet enacted. RP shall record the reason for recommendation. So when I will be placing a report before the Honorable Tribunal under Section 99, I will be placing my reasons for recommending acceptance or rejection of the application, and RP shall give a copy of the report under subsection 7 to the debtor or creditor, as the case may be. But in this case, yes, the copy of the report will be served upon the personal guarantor. And if it is a 94 case, it is required to be served upon the financial creditor. Now here it comes admission or rejection. The adjudicating authority shall within 14 days from the date of submission, for which we have a grievance that is pending since 2 years. But when you see the timeliness within which it is required to be admitted or rejected, the timeliness is 14 days from the date of submission of report under 99 by the RP. The adjudicating authority shall within 14 days from the date of submission of report under 99 shall pass an order either admitting or rejecting the application referred in 94 or 95, as the case may be. They have a timeliness of 14 days, which is under the code. And this is something we can see within what time frame the things are being. And I said there is a room for adjudication in Section 7 and Section 10. There is ample of room for adjudication of such application. But here, when already a default is established, when a corporate debtor is in CIRP, the default is established, there is no much room for adjudication. And this is very well possible within the given time frame of 14 days when the default is already established, and more particularly in the case when 94 applications are being made. When adjudicating authority admit an application under 1, it may, on the request of the RP, issue instruction for the purpose of conducting negotiation between a debtor and creditor for arriving a repayment plan. Adjudicating authority shall provide a copy of the order passed under 1 along with a report of the RP and application referred in 94 95, as the case may be, to the creditor within 7 days from the date of order. So that copy of the order and the copy of the application will be served upon to the creditor. If application referred to in subsection 94 and 95, as the case may be, is rejected by the adjudicating authority, the same thing will be taken care of by the adjudicating authority. That adjudicating authority will intimate the fact. If the application referred to in 94 or 95, as the case may be, is rejected by the adjudicating authority, please take care of it. And there was a question which is required to be addressed upon the intent. On the basis of the report submitted by the RP, that application was made with an intent to defraud its creditor or resolution professional, the order under subsection 1 shall record that the creditor is entitled to file bankruptcy order under chapter 4. So this is something which is very crucial, and the role of RP come to the picture. And here the RP will not only placing the report, but will also place the intent with which 94 application is being made. If the application referred to in 94 or 95, as the case may be, is rejected by the authority on the basis of report submitted by the RP, the application was made with an intent to defraud its creditor or the resolution professional, the order shall record the creditor is entitled to file for bankruptcy order under chapter 4. So this is something which we are going to see in the time to come when such application will be referred before the Honorable Tribunal, that the creditor should be allowed to straight away move a bankruptcy application under chapter 4 of the code. Moratorium. And as I said, interim moratorium will come to an end the moment the application will be admitted, because here the moratorium will commence. Where application is admitted under 100, moratorium shall commence in relation to all the debt, cease to have effect from the end of period of 180 days, beginning from the date of admission of the application or on the date adjudicating authority passes an order on repayment plan, 114, whichever is earlier. So approval of the plan or order of liquidation. And if the plan gets approved, what we call in CIRP, before the expiry of 180 days or extended timeliness, the moratorium will come to an end. So here, the interim moratorium shall cease to have effect. Moratorium in relation to all the debt and shall cease to have effect at the end of the 180 days, beginning from the date of admission of the application or on the date on which the adjudicating authority passes an order for repayment plan under 114, whichever is earlier. During moratorium, any pendency with regards to legal action or proceeding in respect of any debt shall deem to have been stayed, including SARFAESI action or action initiated under RDB Act. The creditor shall not initiate legal action or legal proceeding in relation to any debt, because intent of 94 or 95, that is to bring a resolution or to enable a personal guarantor to frame a repayment plan and allow a personal guarantor to implement that repayment plan. The debtor shall not transfer. Now, this is an onus to prove if the intent is malified. So, personal guarantor shall not be allowed to transfer, alienate, encumber, or dispose of any of its asset or legal right. Now, here there is no provision pertaining to that two-way transaction. And this is something which is going to be one of the practical difficulty which person is going to face. There is no preferential or extortionate or fraudulent transactions, or there is no look back period, or there is no provision what we have in section 43 or 44 or 66, or this is something which is one of the lacuna as far as the personal guarantee application or insolvency resolution process is concerned. And that's why this is going to happen, that a debtor is going to transfer or alienate or encumber or dispose of their asset or the asset of the legal rights or beneficial interest. So this is going to happen because of having ambiguity with regards to the transaction which are preferential in nature or fraudulent in nature or extortionate in nature. When an order admitting an application under 96 has been made in relation to a firm, moratorium shall operate against all the partner of the firm. We are not dealing into that, but this is the most relevant point I'm sharing with you. The debtor shall not transfer or alienate or encumber or dispose of any of its asset or his legal rights or beneficial interest therein. Since there are no look back period or clock, as far as these transactions are concerned, the provision of 43 or 66 that should be mutatis mutandis made applicable to this proceedings of insolvency resolution of the personal guarantor. Otherwise, the transaction will be made initially and then application will be made before the NCLT. So this is something which is quite crucial as far as the inclusion of those provisions in insolvency of the personal guarantor, which is the need of the time. Now here it comes the question, public notice, the cost to the public notice 102. The adjudicating authority shall issue a public notice. Here the wordings are, the adjudicating authority shall issue a public notice within 7 days of the passing of order under 100, inviting claims from all the creditor within 21 days from the date of issue. And the RP will be getting next 9 days for verification. We will be dealing into that part, but adjudicating authority shall issue a public notice. And that's why you will find before every NCLT bench, when you will be visiting any NCLT, there is a notice board, and in the notice board, you will find so many notices qua initiation of insolvency of the personal guarantor to a corporate debtor. So adjudicating authority shall issue a public notice within 7 days of the passing of the order under 100. Purpose is to invite claims from all the creditor within 21 days of the date of issue. Notice include detail of the order admitting application, particular of the RP with whom the claims are to be filed, last date for submission of the claim. Notice shall be published in English and vernacular language newspaper, affixed in the premises of the authority. That is what I was talking about. Affixed in the premises of the adjudicating authority, placed on the website of the adjudicating authority. This is something which you will find practically before the NCLT benches. Registering of the claim by the creditor. The creditor shall register the claim with the RP by sending details of the claim by electronic communication or through courier, speed post, or registered letter. In addition to the claim referred in 1, creditor shall provide to RP personal information and particular as may be prescribed. So it is about submission of the claim before, and there is a requirement to submit a claim within a specified form which is there in the regulation. So no such classification for a financial or operational creditors. Preparation of the list. As I said that there is a time frame which is prescribed, 21 days. Adjudicating authority shall issue a public notice within 7 days of passing of an order, inviting claim from all the creditor within 21 days from the date of the issue of the public notice. It is going to be a responsibility on the part of the RP, but adjudicating authority shall also under an obligation to get the same thing affixed on the adjudicating on the premises of the adjudicating authority, and it will be placed on the website of the adjudicating authority. As far as your last question is concerned, Mr. Rajesh ji, it is very well a responsibility on the part of the RP to give it publication in the newspaper. And we were discussing with regards to the cost and the provisions of which are being made in the order which are being passed by the NCLTs. Registering
Hello.
of the claims. Yes, ma'am.
I have a query. Over here, you said that there is a publication which is required to be done. Like in corporate insolvency, we can find on the website of IBBI as to against which corporate debtor any initiation has been done or any order has been passed. For personal guarantors, from where can we find this information? Because many a times if something is missed, the creditors face a problem.
Absolutely, but there is no reference to the board in this case, what we have in case of a corporate debtor.
Okay.
There is no reference to be giving a publication with the IBBI, what we have in the corporate debtor insolvency. This is something which is missing here in this case. So you will find this information, but this is what provided placed on the website of the adjudicating authority. This is the NCLT website which is being referred upon. So in that circumstances, there may be a new tab which is going to be placed before the public domain that this is supposed to be reported, or else it will be replaced with the IBBI only. But at this moment, these are being referred or these are being published outside the premises of the adjudicating authority in the newspaper at this moment, but no reference to the board is made till date.
Okay. Thank you.
Hello, sir.
So, yes,
Hello.
sir. Yes, sir.
Hello, sir.
Please, sir.
Can a section 95 application be filed against a personal guarantor who expired?
Sir, if you can please repeat it.
So can section 95 application be filed against a personal guarantor who has expired?
See, as far as the personal guarantee is concerned, personal guarantee application is out of the agreement which was signed by the personal guarantor at the time of extending that guarantee, which includes legal heirs. Correct. So very well an action can be maintainable against the legal heirs of the personal guarantor for that agreement which was executed in favor of the secured creditor on behalf of corporate debtor. So action can be initiated against the legal heirs, because when a person is no more, the rights and obligation will be transferred to the heirs.
Now, sir, the question is whether the report that RP is to file with the adjudicating authority will have to be served first before the financial creditor, then corporate debtor, as well as the debtor, that is the guarantor. Now, if the guarantor is dead, I have a case here, live case. In this case, the bank has filed an application under section 95, but the person died long before the application was filed. Now, the question is to whom the notice will have to be served by the RP.
So if this application is made by the financial creditor under 95,
yes,
the notice is required to be served upon the corporate debtor on whose behalf the personal guarantor has extended a guarantee. And second was, in this case, since you are cognizant of this fact that the personal guarantor himself is no more, you should serve a copy to the legal heirs.
So that means this application is maintainable.
Absolutely, yes.
Okay.
Death of a person will not bring an end to that guarantee extended. Otherwise, there is no purpose. When you see the agreement of the personal guarantor, or when you see the guarantee deed as far as the guarantor is included, guarantor includes the legal heirs.
Okay, I see. Thank you, sir.
Yes, Savir, sir. Yes, so 103, that is all about registering of the claim. And as far as the registering of the claim is concerned, the creditor shall register the claim with the RP by sending details of the claim by electronic communication through courier. So that is what we dealt with, preparation of the list of creditor. And as far as the list of creditor is concerned, the RP shall prepare the list of creditor on the basis of the information disclosed in the application filed by debtor, claim received by the RP under 102. RP shall prepare the list mentioned within 30 days from the date of notice. So basically, we'll be getting 9 more days post receipt of the claims from the claimants to the personal guarantor. Repayment plan. Now, this is what we used to have, a resolution plan in case of a corporate debtor. As far as the repayment plan is concerned, now here I will be having, so in case of the corporate debtor, it is the RA who propose a plan. Here, the personal guarantor who will be preparing the plan in consultation with the RP with an intent to propose it before the COC for the purpose of restructuring of his debts and affairs. Repayment plan may authorize or require RP to carry on. So in the repayment plan, what I need to address is, I have to address the concern pertaining to carrying on the business or debtor's business or trade on behalf, release the asset of the debtor, at administration and disposal of the fund of the debtor. So this is something which is provided that the repayment plan may authorize RP to. So RP will be very well allowed in case of the CIRP. It is the corporate, it is the RP or the IRP who get a seat of the board. Here, it is the RP who will be having the authorization to carry on the debtor's business or a trade on his behalf or in his name, realize the asset of the debtor, administer or dispose of any funds of the debtor. Repayment plan shall include following, namely, justification for preparation of such plan and reasons on the basis of which the creditor may agree upon the plan. So you need to show how it is commercially viable. That is a justification of the plan and reasons on the basis of which the creditors may agree upon the plan, provisions for payment of fees to the RP or other matter as may be prescribed. So including the expenditure, it's not only the fees, and there is an expenditure which is again going to get a first seat in the waterfall mechanism. As far as the report is concerned, now there is a divergent views that why there is a discretion and why there is no mandatory to have a COC or committee of creditors meeting in this personal guarantee case. So here the committee or the meeting of the creditor will only subject to the recommendations of the RP and not in every cases. But this is what I feel that amendment is going to take place in this aspect, that creditor meeting is going to be made a mandatory requirement for an RP. So 106 talks about a report of RP on plan. The report, the resolution professional shall submit a repayment plan under 105 along with its report on such plan to the authority within a period of 21 days from the last day of submission of the claim. Please read it again. As far as the RP is concerned, once the plan is proposed by the personal guarantor, I will be submitting my report along with the plan to authority within 21 days from the last date of submission of claim under 102. Report referred in. See, the timeline is quite difficult to meet because 21 days is initial time frame which is given under the provisions of the code for submission of the claim, and thereafter within 21 days it is provided within a period of 21 days from the last date of submission of claim. 102 when we see the last date within 21 days of the date of issue. So this is 21 plus 21. 102 which deals with the RP shall submit the repayment plan under 105 along with its report on plan to NCLT within a period of 21 days from the last date of submission of claim under 102. Report shall include what we used to frame that whether the resolution plan is in compliance with 30 subsection 2 or not. Same thing. Repayment plan is in compliance with the provision of any law for the time in force. So it is having more wider prospect. Plan is in compliance with the provision of any law for the time in force. Repayment plan has a reasonable prospect of being approved and implemented. Necessity for summoning a meeting. Now, this is something which I feel that it's not about necessity, but it's a COC who need to approve the plan. there is a necessity for summoning a meeting of the creditor if required to consider the repayment plan, provided where the resolution professional recommends that a meeting of the creditor is not required to be summoned, that reason is required to be provided. Now here, if you'll find, it is the committee of creditors who approve the repayment plan, and it requires the consent of more than 75%, more than 3/4 of the value of the creditor. Here all the decisions are being taken by the COC with 51% majority, but as far as approval of plan is concerned, it requires the majority of more than 3/4 of the total value of the creditor. So I think it's not only the summoning of a meeting is something which should keep as a, yes, the question is it possible to share one copy of the NCLT notice placed at NCLT and paper notice of the case? Again, Rajesh ji, if you can please express your question, I'm not getting it. I'm referring to your question that is it possible to share one copy of NCLT notice placed at NCLT and paper notice of the case? आप अगर अपने क्वेश्चन को अगर थोड़ा एक्सप्लेन करेंगे, I can able to understand and address upon it. Guarantor cannot operate personal bank account because again, this is subject to the control of the RP now. So I'm coming to my point again. As far as 106 is concerned, where I was showing my concern pertaining to and why it is upon a discretion of the RP to decide with regards to calling about the meeting of the creditors. This is what I said, that report shall include that the repayment plan is in compliance with the provision of any law for the time in force. So this is having a wider prospect to put the submission. The repayment plan has a reasonable prospect of being approved and implemented. That is what I need to place it in a report under 106. There is a necessity of summoning a meeting of the creditor if required to consider the plan. That is what I need to include in my report. And where if I recommend that a meeting of the creditor is not required, then I have to state the reasons for the same to be provided. Report under 2 shall also specify the date on which, time and place at which the meeting should be held if he has an opinion that a meeting of the creditor should be summoned. And in that case, I need to take into consideration where the majority of the creditors are from. For the purpose of subsection 3, the date on which the meeting is to be called shall not be less than 14 days. So I have to give 14 days notice and not more than 28 days from the date of submission of the report. So if I'm of that opinion that meeting is required to be called, the RP shall consider the convenience of the creditor in fixing the date and venue of the meeting of the creditors. So I think this is something which I feel that it is required to be avoided, and there has to be a mandatory requirement for the COC meeting. So in the case when in the capacity of RP, where I will be placing the repayment plan before the adjudicating authority, I have to place it with my report. This is what provided in subsection 1 of 106, that RP shall submit a repayment plan under 105 along with a report on such plan to be adjudicating authority within a period of 21 days from the last day of submission of the claim. And in that report, I have to mention any necessity for summoning a meeting of the creditor if required to consider the plan. And where the RP recommend that meeting of the creditor is not required, I have to state the reason. And this is going to be amended very soon. Summoning of the creditors meeting. RP shall issue a notice calling the meeting of the creditor, and as I said, 14 days prior notice is mandatory, but not more than 28 days notice. That is what we studied in subsection 4 of 106. The date on which meeting is to be held shall not be less than 14 days and not more than 28 days from the date of submission of report under subsection 1. Summoning of the meeting of creditors, the RP shall issue a notice calling meeting of the creditor at least 14 days before the date fixed for the date of meeting. RP shall send notice of the meeting to the list of creditor prepared under 104. Notice shall be sent under subsection 1 and shall state the address of the adjudicating authority to which the repayment plan and report of the RP on the repayment plan has been submitted and shall be accompanied by. So when I will be submitting a report, or when I will be placing before the COC, the notice shall state the address of the NCLT to which the repayment plan and report of the RP on the plan is submitted. I have to state the address. Copy of the repayment plan I will be sharing with the notice. Copy of the statement of affairs of the debtor. Copy of the report of the RP, and proxy form in case if the committee of creditor or the member, that is a creditor, if he want to send somebody else on his behalf to act as a proxy. The proxy voting, including electronic proxy, shall take place in such manner and form as may be specified. This is what the point, Mr. Uday, that we were discussing, that there is no provision which mandates RP to get this published on IBBI website. That is what we were discussing few minutes back. Where I should place it, it's the adjudicating authority which is going to place it before a public domain in a conspicuous manner, which is accessible to all in its own premises. It is required to be published in the newspaper, and it is somewhere provided in the website of the adjudicating authority. So very well, you will find this in the NCLT's website in the time to come. At present, not on the IBBI website. The conduct of the meeting of the creditors. The meeting of creditors shall be conducted in accordance with the provision of the section and section 109, 10, 110, 111. And you will find many of the things in the regulation wherein the quorum is prescribed, that is 33% voting shares. Or in case if the quorum is not available. So all such provisions are there in the regulations. In the meeting of the creditors, the creditor may decide to approve, modify, or reject the repayment plan. Approve, modify, or reject the plan. RP shall ensure that if the modifications are suggested by the creditor, the consent of debtor shall be obtained for each modification. This is subject to the modification, this is going to be approved. So when RP has to make it sure that if the modifications are being suggested by the committee of creditor, the consent of debtor shall be obtained for modification. The RP may, for sufficient cause, adjourn the meeting of the creditor for a period not more than 7 days at a time. Voting. Now here you will find the right of the secured creditor, that is to relinquish or that is to enforce the security. We were discussing with regards to section 94, 95 versus an action under SARFACI or RDB. A creditor shall be entitled to vote at every meeting of the creditor in respect of repayment plan in accordance with the voting share assigned to him. It's a value-based voting again. The RP shall determine the voting share to be assigned to each creditor. Creditor shall not be entitled to vote in respect of the debt for an unliquidated amount. In dispute, creditor shall not be entitled to vote in the meeting if he is not a creditor mentioned in the list or an associate of a debtor. So definition of associate is of some importance. Same related party. Right of secured creditor in relation to repayment plan. Now, this is where you will find something in common vis-a-vis a liquidation regulation. A secured creditor shall be entitled to participate and vote in the meeting, but secured creditor can only be entitled and vote if the secured creditor has actually relinquished and has not decided to enforce the security interest. The secured creditor participating in the meeting of the creditors and voting in the relation to the repayment plan shall forfeit his right to enforce security during the period of repayment plan in accordance with the terms of plan. So if I'm forfeiting my right of enforcement of security interest, I will be very well allowed to cast my vote in the meeting. Otherwise, I will be only entitled to cast my vote for the unsecured part of the debt and not for the entire part. Where a secured creditor does not forfeit his right to enforce security, he shall submit an affidavit to the resolution professional at the meeting of the creditor, stating that the right to vote exercised by creditor is only in respect of the unsecured part and estimated value of the unsecured part of the debt. So when I have decided to enforce the security interest, and if I'm not forfeiting my right, in that circumstances only I will be allowed to participate and vote. Otherwise, I'm supposed to give an affidavit that I'm not forfeiting my right, but I'm going to participate only for the unsecured part of the debt. Unsecured, in case of secured creditor, participate in voting on repayment plan by submitting an affidavit under subsection 3. The secured creditor and unsecured, I said secured and unsecured part of the debt shall be treated as a separate debt. The concurrence of secured creditor shall be obtained if he does not participate in voting on repayment plan, but provision for repayment plan affect his right to enforce security. This is something which is very important. You need to take the creditors into confidence, a secured creditor into consideration if he does not participate in the voting process on repayment plan, but provision of the repayment plan affect his right to enforce security. This is something which is very crucial, that if a plan is of such a nature, repayment plan is of such a nature which impact or which hinders or somewhere which is impacting the right of the secured creditor to enforce security, then in that case, even though the person, the secured creditor, has not forfeited his right, but such a resolution plan or repayment plan of the personal guarantor shall not be taken into consideration without giving an opportunity or without getting the concurrence of such secured creditor. Approval of the plan by the creditor, and this is something that is what we used to see, that approval of the resolution plan by the committee of creditor with 66% voting share, but here you will find it is required to be approved by a majority of more than 3/4 in value. This is 111. The repayment plan or any modification to repayment plan shall be approved by the majority of more than 3/4 in value of creditor present in person or proxy and voting on the resolution in the meeting of creditor. Approval of the repayment plan by the creditors. So it's not only a 66% voting share, but it requires a majority holding more than 3/4 in the value of the total debt. The repayment plan or the modification, I think the secured creditors are having more stronger sit in the insolvency resolution process of the personal guarantor rather than invoking and fighting before the forum called DRT. The repayment plan or any modification to the plan shall be approved by a majority of more than 3/4 in value of creditor. It's value of creditor, and that's why I said they will be having more stronger seat to deal into the process of insolvency resolution of the personal guarantor. As far as the reporting of the meeting of creditor on repayment plan is concerned, so post approval of the creditors on the repayment plan, it is required to be reported to the adjudicating authority. The RP shall prepare a report of the meeting of the creditor on repayment plan, and the report shall contain whether the plan was approved or rejected. If approved, the list of modification, if any, resolutions which were proposed at the meeting and decisions on plan resolutions, list of creditor who were present and represented at the meeting, and the voting record of each creditor for all the meeting of the creditor. Other information as RP thinks appropriate to be known to the adjudicating authority. Notice of the decision taken at the meeting of creditor. The RP shall provide a copy of the report of the meeting of the creditor to the debtor, that is a personal guarantor, creditor including those who were not present in the meeting, and to the adjudicating authority. So RP has to place its report before the guarantor. It is also before the creditors, even though creditors were not attending the meeting, and before the NCLT. 114. The authority shall by an order approve or reject the plan on the basis of the report of the meeting of the COC submitted by RP. Where a meeting of the creditor is not summoned, and this is something where I feel that if the meeting is not summoned, how you got the consent? Meeting of the creditor is not summoned, the adjudicating authority shall pass an order on the basis of the report prepared by the RP. But this is not practically possible. You have to go to the creditor to get the consent, because there you will find it is very, very clearly stated that 111 talks about the plan or any modification thereof shall be approved by the majority. So you cannot bypass the route of approaching the COC and getting the consent. 114 it is, the order of the adjudicating authority approved the plan may also provide direction for implementation of the plan. Adjudicating authority is of the opinion that the repayment plan requires modification. It may direct RP to reconvene a meeting for considering the repayment of the plan. Again, it requires consent from the creditors holding more than 3/4 in the total value. Effect of the order of the adjudicating authority on the plan. Where the adjudicating authority has approved the plan under 114, the plan shall take effect as if proposed by the debtor in the meeting, binding on the creditor mentioned in the repayment plan. Where the adjudicating authority reject the repayment plan, the debtor and the creditor shall be entitled to move before the NCLT, knocking the door of chapter number 4, which talks about bankruptcy. I'm reading it again. NCLT has approved the repayment plan under 114. Such repayment plan shall take effect as if proposed by the personal guarantor. binding on the creditor mentioned in the plan and debtor. But where the adjudicating authority reject the plan, the debtor and the creditor shall be entitled to move under Chapter 4 of the Code for initiating a bankruptcy application. A copy of the order passed by adjudicating authority shall be forwarded to the board. Anyways, this is something procedural in nature, implementation and supervision. So RP will be having its role to play, what RP used to play in the monitoring committee, to see whether the plan is being implemented or not. The RP appointed under 97 or 98 as the case may be shall supervise the implementation of the plan. RP may apply to adjudicating authority for directions in relation to any particular matter arising under the plan. Adjudicating authority may issue directions to RP on the basis of the application. Again, a procedural completion of the plan. So this is something which we can see when it will be considered as if it is plan is completed. The RP shall within 14 days of the completion of the plan forward to the person who are bound by the plan under 115 and NCLT the following documents, namely the notice that plan has been fully implemented. So this is his role in the implementation part. The RP shall within 14 days of the completion of the repayment plan forward to the person who are bound by the repayment plan under 115 and to the NCLT the documents, namely a notice to the effect that repayment plan is implemented and copy of the report by RP summarizing receipts and payment made in pursuance of the repayment plan and extent of the implementation of plan as compared with the repayment plan approved by. So what was approved and up to what extent it was implemented. RP may apply to NCLT to extend the time which is provided for further period not exceeding 7 days. So this is something within 14 days I have to place. I can seek an extension. I'm reading it for the sake of convenience again. RP within 14 days of the completion of the repayment plan, forwarding to the person who are bound by such plan under 115 and adjudicating authority the documents, namely first, notice to the effect that plan is implemented and report of the RP summarizing receipts and payments pursuant to the repayment plan and extent of the implementation of plan as compared to what was demonstrated before the creditor at the time of proposing the plan. RP may apply to NCLT to extend the time mentioned in one, which is of 14 days for further period not exceeding 7 days. Repayment plan coming to end prematurely. So it happens that either the time frame which is provided in the repayment plan, I'm fulfilling my obligation much prior to it, or I'm coming to a conclusion that what has been theoretically proposed or what has been proposed in paper is not being implemented. A repayment plan shall deem to have come to an end prematurely if it has not been implemented in respect of all person bound by it within a period as mentioned in the plan. Very important. Plan shall deem to have come to an end prematurely if it has not fully implemented in respect of all person bound by it within the period as mentioned in the repayment plan. Where repayment plan comes to an end prematurely under the section, the resolution professional shall submit a report to the NCLT including which states that all the receipts and payments in pursuance of repayment plan, reason for premature end, details of the creditor whose claims have not been satisfied, and they creditor will be having a liberty to approach under Chapter 4. The adjudicating authority shall pass an order on the basis of report submitted by RP that repayment plan has not been completely implemented. The debtor or the creditor whose claim under the repayment plan have not been fully satisfied, they shall be entitled to apply for bankruptcy order under Chapter 4. But this is something which is very, and that means it is something, even though that means what you have proposed in the repayment plan, you have to implement it. If any of the person who are bound by it has not been repaid, they will be having a leeway or they will be having an option available to approach the tribunal under Chapter 4 for initiating bankruptcy against you. This is very relevant. A plan shall deem to have come to an end prematurely if it is not being implemented fully in respect of all the person bound by it within the time prescribed under the plan. Where a repayment plan comes to an end prematurely under the section, the RP shall submit a report to NCLT and state receipts and payments made in pursuance to the plan, Reason for premature end. Details of creditor whose claims have not been satisfied. And they people are having this right to knock chapter number 4. Adjudicating authority shall pass an order on the basis of report submitted by RP that repayment plan has not been implemented. Debtor or creditor whose claim. Now, debtor is something that means even I can directly go under chapter 4 and for initiating a bankruptcy against myself. That is a personal guarantor. Or the creditor whose claims under repayment plan have not been satisfied shall be entitled to apply a bankruptcy order under chapter 4. Adjudicating authority shall forward the person bound by repayment plan a copy of the report submitted by RP, order passed by RP, and adjudicating authority shall forward the same to the board. Discharge order, but discharge order in case of the implementation of the plan. On the basis of repayment plan, the RP shall apply to the adjudicating authority for discharge order in relation to a debt mentioned in the repayment plan. An adjudicating authority may pass discharge order. The repayment plan may provide for early discharge, discharge on completion of implementation. Discharge order shall be forwarded to the board, but discharge order shall not discharge other person from any liability in respect of his debt. So if some other person is under an obligation, same like a personal guarantor's guarantor, the discharge order shall not discharge, it shall discharge me, but it like approval of resolution plan shall not discharge a personal guarantor to the corporate debtor. Approval of the plan brings an end to the liability of the corporate debtor toward its creditor, but the right of the secured creditor to initiate a personal guarantee always stays with them. Similarly, the discharge order under subsection 3 shall discharge the personal guarantor, but it shall not discharge any other person. It shall not discharge any other person from any liability in respect of his debt. So this is something which is provided, but I think the most relevant part is 117, which clearly mandates that it need to be implemented, and all the persons who are bound by the plan should have been satisfied, and otherwise they will be having this right to straight away go to the NCLT under chapter number 4 to initiate an application under 121, that is for bankruptcy. This is 117 and 118, which are quite relevant. Yes, I will be putting the forum open for the question so that we can have a discussion upon the part, and before we conclude, we should formally end to all the questions which will either remain standing because see, when you see these days 95s are being or 94 are being admitted, 99 applications are being adjudicated, and now practical implications or the practical difficulty or the teething problem will now being faced by the RPs during the course of insolvency resolution of the personal guarantor. So that stage is right now coming in a very short time, because nowadays 99 applications are not much taking time, and the immediately after that 100 section 100 the applications are being admitted. So there will be a practical problem, because as many questions were pertaining to, if there is an application which is admitted again a personal guarantor, how come the creditor to that personal guarantor will come to this, or how come they will be aware of this fact that there is an application initiated against a personal adjudicating authority, but who visit the adjudicating authority? Either the adjudicating authorities are, yes, so adjudicating authority, either the advocates are appearing before the adjudicating authority, or rarely the person, the RPs or the IRPs or liquidators, those who are the regular visitor to the adjudicating authority. So placing it on the board of NCLT probably may not serve its final purpose. Placing it on the website of even IB RP has any power against the personal guarantor, the personal guarantor transferred all his asset to other relative before admission. Yes, why not? And that is what we have seen under section 100. Section 100 is very clear that such an application can be made straight away. The RP may move an application before the adjudicating authority and states that application should be should not be allowed, and straight away the bankruptcy order can be passed under section 121, what we have seen. This is what provided. When you see section 100 and subsection 4, it is very well provided. This is 100 and subsection 4. If the application referred in 94 and 95 as the case may be is rejected by the adjudicating authority on the basis of the report submitted by RP that the application was made with an intent to defraud creditor or resolution professional, the order under subsection 1 shall record that the creditor is entitled to file for a bankruptcy under chapter 4. But as I said, unlike PUFE transaction, there is no provision which can bring the benefit which PG has availed by entering into such suspicious transaction. You cannot derive the benefit back. So that is one of the limitation which I feel, that there has to be such provision which should be in line with what we have 43, 44 or 66 in the IBC. The same provision should be brought in so that there is an end, or there is a kind of fear to with regards to those transactions, or if the transaction was actually taken place, the proceedings can be initiated to bring the benefit back for the creditors.
So these kind of transactions are available in bankruptcy.
Absolutely. So it's bankruptcy is always going to be a second stage, and I feel that why not to have these provisions initially when the applications are being adjudicated, when the report, when RP is placing its report. I can understand there is a very less time frame which is prescribed, but the time frame which is provided of 10 days within which I have to submit my report, if I will be having a leeway, or if I am having a provision in hand, I can very well utilize the provision, and at the beginning itself I can able to identify the nature of such transactions. I think there is a requirement that such transactions should brought in line with what we have in the insolvency resolution process of the corporate persons. Yes. Suggestions with regards to what else to be done or what is required to be done in the, yes, sir.
In a case, there are two corporate debtors and the guarantors are same. And they have applied for under section 94. And two different RPs are there. The assets are common. The guarantors' assets. How to deal with it? Which RP is to deal with the assets?
And that is the point where I was, and again, apart from the jurisdiction, this is also one of the question wherein a personal guarantor is similar. Extended guarantee to two separate corporate debtor. Two separate corporate debtors are before two separate benches.
No, same bench, but different RPs.
Okay, so there is a same bench before with both the corporate debtors are during under CIRP or under liquidation.
They are not under CIRP liquidation, but the personal guarantors are there under section 94.
So let us consider that no CIRP or no liquidation against the corporate debtor is initiated, but section 94 or 95?
94.
In 94, then in that circumstances, one is very clear that the adjudicating authority will frame the first question that you are moving an application. See, this is something wherein I am moving an application under 94. The intent of the application is to initiate the, so how come the second application will be maintainable is my question.
The thing is, in one of the application, the director is the personal guarantor and the other guarantor is also there.
Irrespective of this fact, my point is, what is an intention of moving an application under section 94?
No,
Sir, please allow me to speak. My question is, if you move section 7 or section 9, please consider it. If you move section 7 or section 9, right? If you move, suppose if you are a financial creditor to a corporate debtor and you are also an operational creditor to the same corporate debtor, you will move under section 7. You will move under section 7. There is no purpose moving under against same corporate debtor under section 9, because your intent is to initiate CIRP. Here, the intent under section 94 is to initiate an insolvency resolution process against you or for yourself. So when the intention is for the resolution of the insolvency, what difference it will make that you will be moving before bench as a director in the capacity of personal guarantor, and thereafter you are moving a separate application qua in other capacity as a person. What I said, your first applications, once you have made, it will bring an end to all the subsequent application. And second, what is the rationale of having two different persons as an RP?
No,
My
that
point.
now I'll address both the issues, sir. The thing is, there is a corporate debtor and there is a director. To that corporate debtor, one another person has given a personal guarantee. Okay. Now this personal guarantor has even also given a guarantee to another corporate debtor. Okay. So in both the cases, the two RPs are appointed. When in the first case, the director doesn't have any asset, but when he submits a resolution plan, the assets of the guarantor will be included in that or not?
Come again, sir. Come again.
So there is a corporate debtor
Okay.
in which the director has filed the 94 application.
Personal guarantor has moved 94 application. Yes.
He doesn't have any asset.
Personal guarantor don't have any asset.
Any asset. But to that corporate debtor, his mother has also given a guarantee.
Okay.
For that corporate debtor. She has assets.
Okay.
Now she has also applied under 94.
So both are different person, na? On the one side, I'm moving. On the one side, I'm moving an application under 94. On the other side, since I don't have any asset, I'm moving 94 application. For other corporate debtor, my mother, who is also one of the personal guarantors, moving section 94 application. She is having.
She's a guarantor to both the corporate debtor.
Okay. Okay.
So she has moved an application.
Correct.
Now the personal guarantor assets are there. Okay. Apart from these two corporate, other two corporate entities there, for which the same personal guarantor is guarantor there. They are also before NCLT.
Okay.
And NCLT has appointed two RPs from the panel.
No. But my point is, sir, the application which was made by a director in the capacity of personal guarantor, right? That application under 94, whether he recommended or whether he moved that application through RP or not, that is question number one.
Directly he has moved.
So without proposing a name of RP,
yes.
That application was made. Second, the mother of that person, the mother of that gentleman, in the capacity of personal guarantor, has also moved an application under 94 without recommending the name of RP, right?
Yes.
And now your point is there are two more corporate debtor on whose behalf this two person have given a guarantee.
Yes.
And in that case, the already NCLT has appointed RP in those cases.
This appointment of under 100 is pending, but there are two RPs. Yes.
Though if it is pending before the NCLT, under 100 pending, but RP is appointed, na?
Yes, RP is appointed.
So you mean to say basically there are 4 applications?
Correct. And two different RPs for the same assets.
No, leave assets, sir. Why you are discussing an asset? Here, in case of personal guarantee, your concern is pertaining to a person and not the asset. I mean to say, when in the capacity of director, I moved an application under 94, not recommended any person's name, but yes, there is an application which was made again. How I can move to different application? That is my question, sir. How this can be treated maintainable?
No, there are no two difference. I am saying I am a guarantor to 4 corporate entities.
Okay.
So so that application has been moved by another 2 gentlemen in another 2 companies in which the RP is appointed. He's a son, mother, and father. There are 3 persons. But the assets all belong to the mother.
Okay.
So three applications are there. 4 applications are there.
So you mean to say there are four guarantors have moved section 94 application. But out of four guarantor, only one lady is having asset in her name. Other three people are assetless.
Yes.
Okay. Okay. So where is the question?
The question comes, who will deal with the assets as and when?
Asset, basically the lady who moved an application under section 94 for which an order is passed by the honorable tribunal appointing you as an RP. You being an RP is going to deal with the insolvency resolution process of that lady. The asset is only pertaining to the lady. See, you now cannot, you can see right now you need to detach yourself from the corporate debtor on whose behalf you have extended guarantee, because right, your recovery is not pertaining to only that debt. Now your individual creditors will also be submitting the claim. So the point here is A, B, C, and D, whereas D was the only lady, or D was the lady who was having the asset, moved section 94 application, RP was appointed. That RP will be concerned for the insolvency resolution process of that lady and not for ABC. For ABC, there may be three different RPs, and they three different RP will be confined their process only to A, B, and C respectively. So I don't think so there is any challenge what is given under your circumstances or given circumstances.
Okay.
Whether the RP or liquidator of CD can become RP of PG, absolutely yes. That is recently omitted. I'm just sharing the screen for your convenience, and that is omitted. Earlier, it was considered as one of the disqualification, but now it is omitted. I'm just sharing screen. Yes, it is very well permitted. When you see eligibility of the resolution professional, you will find the star 3, which is very recently deleted. This is in January 2024 only. Earlier it was, prior to the omission, it was stood as has not acted or is not acting as an IRP, RP, or liquidator of the corporate debtor. But this 3-star, you are seeing this. This is deleted and omitted with effect from 31st January. And yes, your question I can address, yes. Even if a person is an IRP, RP, or liquidator of CD, can act as an RP of the personal guarantor.
And vice versa also, right?
Absolutely, sir. And he will be the person who will be in a very strong position to know the in and outs, getting all the necessary information during the inception of the CIRP. He must be in a position of several information to such personal guarantor, apart from what he hold the knowledge or information in capacity of the IRP of the corporate debtor. So yes, they are very well eligible. Earlier it was not allowed, but in fact from January 24, these are considered as an eligible IPs to act as a RP to the personal guarantor. If there is any question to deal with, we should deal into that. Otherwise, I would like to extend my heartfelt thanks to the institute. I'd like to extend my thanks to the Institute of Company Secretaries of India, Insolvency Professional Agencies, and it's always a pleasure to be a part of such forum. All the eminent learned members to share the views, to get the views, to deliberate and to counter the views are always the rationale and the purpose of such kind of webinars. And this interaction was always There's always going to be this brainstorming exercise from where we can able to come to a conclusion that what are the latches or what are the lacunas or where some improvement in the code is required. And there is always a duplicacy of opinion, which is ultimate purpose for which such programs are being conducted. So I will appreciate each and every participants, those who have placed their points, those who have placed their thoughts, those who have strongly contested to the views, backed the views, and through this brainstorming exercise, the laws are getting settled before the courts or before the quasi-judicial forums of the code of NCLT and NCLAT. Once again, thank you very much to the Institute of Company Secretaries of India. Extremely thankful for this opportunity. Thank you.
Thank you very much, sir, for such a nice session. Thank you very much for taking out time and giving your suggestions to us. Sir, you are requested to share your PPT with us.
I will be sharing. See, thank you.
Now, participants, next session will be with Mr. Devvart Rana, sir. He will be taking session from 2:30 p.m. onwards. Next session will be started at 2:30. Till then,
Can we log off and
Okay, madam.
rejoin
Thank
later?
you.
We shall log in again at
sure.
2:30.
Yes, next session will be.
Same link we can log in.
Thank you.
Thank you. Thank you.
field and to today's learning. It's post session, so I promise to keep it as boring as possible, so all of us can sleep. Try not to sleep because otherwise it will be only CPE hours. I hope all of you were there in the morning session also, which Mr. Vinit had taken. It was a pretty insightful session.
Yes, we were there.
Many of you were there, right?
Yeah.
Perfect. So currently, as he had mentioned in the beginning, in the morning also, most of the cases are at the stage of insolvency. That is the first stage of personal insolvency, right? In chapter 3. Bankruptcies have not yet started in that bigger fashion. Reason being, our first stage has to be completed, then only we go for bankruptcy. But having said that, there are cases which have been admitted in bankruptcy also, like in Hyderabad, 2 of the cases have been admitted, like in case of a person called MSP Rao. He's a PG of Konasima. Bankruptcy was admitted. I'm also appointed a bankruptcy trustee in one of the matter called Gati Bhasme Private Limited. So, but having said that, bankruptcy per se, we don't have much experience of. So when we say practical aspects of bankruptcy process, those practical aspects are yet to come actually. But yes, we will be discussing all what we have learned and maybe you have learned. And since it's a post lunch session, let's try to keep it little interactive. Otherwise, it will get over pretty fast. Reason being, bankruptcy. Now it might look like a theoretical exercise at this stage. Uh, Personal insolvency, as we have been discussing since morning, there are, I think, many cases now which have been filed. There are people who have taken 10, 12, 15 cases also who are acting as RP in personal insolvency cases. One person is doing 5, 6 insolvency cases of one company itself. So as an RP in the personal insolvency, there is hardly, so I'm not saying there is nothing to do, but it's a pretty amicable situation. In insolvency, there is no, see, as we are discussing, there is no buffet applications, right, in the personal insolvency. And why is that? That is because this process of personal insolvency is not coercive. It is not at all coercive. It is only giving an opportunity to the personal guarantor to come out of it, finish his story, tell what he can repay, let let the creditors take a call on it if they want to participate. If they don't want to participate, they're free to be out of the process. Correct? It is unlike that CIRP process where it is binding. If you are sleeping on your rights, your right might go away after 32A. It's a clean slate theory, correct, in CIRP. But in personal insolvency, that's not the scenario. See, why I keep referring to personal insolvency is because the reason is CIRP, if CIRP fails, what happens? Liquidation will happen. And if personal insolvency fails, what will happen? What can happen is bankruptcy process. So for bankruptcy, understanding our background also is pretty important from both sides. There were some bankers in the morning, like ARC companies, I think, right? If you have heard, they said, see, if we see nobody is happy with 94, 95. I don't know how come. Bankers are not happy because they think they can't do the surface I, DRT, X. Promoters are thinking that, we have got somebody is raising hand.
Sir, I raised hand. I am from an ARC industry, and we are not happy because we are unable to recover within a given period of time. We don't have much time, and as surface gets stalled, the process of recovery gets delayed.
Absolutely, ma'am. That is what.
And we have certain cases. We can tell you that the reports have been filed by the IP for past almost 1 year, if you say. and still nothing has moved after that. So what you said that within 14 days that has to happen, it has taken more than a year and still not happening.
And that is the experience which almost everybody has, Ms.
And
Deepa.
another one more, and another thing, because of this, we are unable to initiate action in any other laws also.
Absolutely, absolutely. Now, this is your side of the story, right? Now, I'll tell you, because I have filed 94 also, have filed 92, 95 also, have filed 121 also. And being an advocate, we are advising the personal insolvency guarantors also, right? So I'll tell you all from four sides what is happening. So from your side, you are pretty clear. If it is 14 days, if it would have happened, nothing like it. You will not have any grievance. You will say, okay, whatever the law, we will follow it. Time is a problem from your side. From promoter side, they are saying, we never knew this will come. We gave our guarantee in 2011, 12, 13. Who knew that this will come back to haunt us? Can we raise an application that this should not be applicable on us? And that is why all those two cases of Lalit Kumar Jain and Jivarjika went to the Supreme Court saying that this is like retrospectively you are killing somebody. But obviously, this also means that, were they giving only piece of paper which cannot be implemented? So, so by this, can we say that it is coercive on them also, or at least they feel like that it is coercive? Otherwise, why will they complain about it, right? So they also feel that it is wrong on their part. Why it should be happening? You are also feeling that it should not be there. Uh, Even judges are taking a lot of time to dwell on whether it should be running, it should not be running. Now, luckily, for last 2 months, 3 months, as our learned friend Vinit was saying, that yes, lots of cases are being admitted every second day. You see any NCLT orders. If you see those daily orders in the NCLT, you will find that every day there are cases. In fact, in February and March, the top board of the NCLT were all personal guarantees because they were stuck up for so many years. Now, Ms. Deepa and Prerna, I'm assuming that your matter, which is hanging for last 1.5 year, should get resolved. And at times they have 60 matters on one board. I don't know how will they listen to everyone and then they do it, but that's how the life is. Now bankruptcy process, we will start, and let's try to keep it little interactive. As I said, my flow doesn't break, don't worry. Here we are learning now, because you don't have to pass an exam or something that you need to know every section. Let's keep it interactive, keep disturbing me in between, no worries, and we will keep moving forward. I have made a presentation of around 30 slides, which covers the entire spectrum of our bankruptcy. Now, see, as in law or in IPC, or when we say that, what is a deterrent for somebody to do something wrong? Somebody is doing something wrong. What do you say? We will put a fine. The higher the fine, bigger the deterrent. One thought process is that, correct? Now, bankruptcy is that deterrent. Insolvency is not the deterrent. Insolvency is giving the person a last chance. If in insolvency, this person is not coming out with clean hands, with whatever best put forward, you have an option as promoter, as creditors, to initiate the bankruptcy process. Now that bankruptcy process is end of the game. Now, when this is end of the game, we will see how it is end of the game. See, in a company, in a CIRP, liquidation can lead to dissolution. In bankruptcy, we cannot hang a person, right? It's a natural person. So since we cannot hang the person, what do? We can only take away whatever he has and leave him with bare minimum to survive. And that bare minimum we discussed in the morning is 10 lakhs house, 20 lakhs house in the city, one car, some unencumbered tools, something like that, some policies, insurance policies, etc. and take away everything else. It's like stripping that person of whatever possessions this person has. Other than this, any suggestion you think we could have done in bankruptcy, we could have added, or lawmakers could have added? Anyone? Ms. Deepa or Prerna or somebody? We'll try to keep it interactive. Otherwise, I also had a healthy lunch. Okay. Okay, fine. No worries. We'll keep coming back. Bankruptcy process. Let me start this slideshow. Bankruptcy process. What is bankruptcy? Who will tell me? Bankruptcy is when a person or company is legally declared incapable of paying their dues and payable bills. They are legally declared incapable. So they were capable earlier. You had declared them and as an NPA or something, but now they are legally declared as bankrupt. They have nothing. So this is actually Diwaliyapan, how we call it, right? That this person has gone bankrupt. Individual here asks for the help from the government to pay off his debts to his creditors. So this is normally in foreign countries where you have chapter 7, chapter 11. In India, nobody is helping these creditors. Government is not helping these creditors. They have to take haircut and go home. Nobody is helping them. But yes, this is a way of putting forward that individual asks the government, I don't have money to pay. I don't have money to pay my taxes, etc. Other dues which have incurred on me. I need to go off. Whatever I have, please take it and let me live my life. So in the morning, we discussed double dipping, right? Double dipping of PG. I'll come back to these, but so I have made a short note of what we discussed in the morning time. Like multiple and concurrent proceedings of CIRP and PG. Same issues, same party. How come one gentleman was asking about 4 applications have been filed and 2 RPs are there. First of all, if it's the same family, why will they propose 2 different RPs? I mean, and if court is trying to propose, the lawyers can ask that, why not propose 1 RP only, so that your cost is also less. Everything is compiled at one place and can be settled off, right? Now, complexity of location. See, as a lawyer, I can tell you, if there's a decree which needs to be executed, let's say in the state of Noida, in the city of Noida, Delhi courts will not take cognizance of this in CPC. They will say we don't have jurisdiction. So if CPC, which is such an well-established law, courts are not taking, the regular courts like our district courts, they say we don't have jurisdiction, we don't have power to direct attaching assets, attaching, directing the local administration. How does an NCLT sitting in, let's say, Indore will direct a TCP sitting in Jaipur to achieve this process? Now, these kind of issues will come. Right now, we are only talking about, very senior cases. We talked about Anil Ambani cases and, those big cases where people are aware law can get hold of people. There are a lot of cases will come because right now it's only personal insolvency of personal guarantor to corporate debtor. Imagine when the entire spectrum will be open, when everybody will come to the NCLT and say, okay, I'm bankrupt, release me, I'm bankrupt, release me. In district courts, people are going to release their, assets of how much? Even for 5,000, 20,000, 80,000 under that 1999 Provincial Act and all. And there the application fees is only 500. They go there, file it, story is over. So here and right now, imagine our system is so clogged that it takes 2 years and 1 year and 3 years also at times. One case was yesterday where this case is going on for 7 years. CIRP is going on. Athena Demway. I'm representing one of the stakeholder there. So 7 years the CIRP is going on. 2017 it started. So our system is still clogged, but we are now learning what can be the other practical intricacies which will come when we are doing the bankruptcy. So insolvency process first. If it fails, go to bankruptcy. Now, there's a major difference also in CIRP. If CIRP fails, no resolution plan comes after 180 days or 270 days, you straight away go to liquidation. Section 33 is automatic, correct? That is not the case in case of bankruptcy. Bankruptcy, you have to file for it. So if the insolvency resolution process fails, it does not automatically lead to this chapter. So our chapter of bankruptcy is completely different than our chapter 3. Our chapter 3 is personal insolvency. Bankruptcy comes in chapter 4. It's a different chapter altogether. Reason being, these are two disconnected exercises. You have 90 days. Anybody has 90 days to file for bankruptcy once the order under insolvency is passed. Rejecting and 104, 106. I'll show you that, but this is not a natural outcome. Bankruptcy is only a threat which will be there in case they are not doing the personal insolvency. So personal insolvency is only a mediation, an easy step to allow people to offer whatever they have in their hand. If you people are agreeing to it, you people, when I say creditors, if creditors are agreeing to it, take the plan, take the money, say thank you, go home. If not, you apply, RP will apply that, there is no repayment plan, it has failed or it has not been implemented. Creditors are free to initiate the bankruptcy process. Now, problem is if in personal insolvency you are not able to get anything, what will you get in bankruptcy? We will see what all we will get, okay? So who's a bankrupt? Bankrupt, okay? Bank means any branch or place of business, and rupt means it's broken or ruptured, right? So the bank has gone ruptured. Now, nothing is left. Or whatever is left, please take it. Let me go home. This is bankruptcy. Bankrupt is bankrupt only when he is adjudged as such. That means the court has to declare him bankrupt, not otherwise. So some people call that, maybe it's a stigma thing because of which promoters are, trying to get away from this. But half of the promoters are any which ways behind the bars. So for them, I don't know, being bankrupt is such a stigma or not. So that's what the current scenario is. Now this personal insolvency and bankruptcy, I think is because of one reason. Because we always had a regime where we used to call that companies are poor, but the promoters are rich. Correct? Now creditors have a chance to change that scenario. They can go after the promoters also, saying that it's not that company is gone, there was a limited liability on the company and you will go scot-free. No. Now you can also come under the preview of this law, where first we will give you a chance, you will get a chance as a personal insolvency resolution process. Still, if you are not coming out with clean hands, as even if the last chance, then we are going to rip away all the belongings to you and let you go. Right? Now, having said that, when we say we'll rip you off and let you go means we cannot kill the person. 1 year we try to get all this. If within 1 year we are not able to get, we let this person go and live on his life, right? So bankrupt is a debtor who has been adjudged as bankrupt by a bankruptcy order. Bankruptcy order comes under 126, right? Like personal insolvency order comes under section 100, bankruptcy order comes under 126. each of the partners of a firm where bankruptcy order under 126 has been made, it will be on each of the partner, right? So if it is against the firm. And any person adjudged as undischarged insolvent by AA if insolvent. Don't need to read every word of it. So we know what bankrupt means. Whenever we require, we will go to the code. We will see what it actually means. Okay. This we have been discussing, that insolvency versus bankruptcy, right? Bankruptcy is a state of economic distress, right? Because there is because there is stress, that is why there is insolvency, right? Otherwise, what is the meaning of going into insolvency? Whereas bankruptcy is a court order which usually involves selling assets to pay creditors and erase the debts that cannot be paid off. Bankruptcy can severely damage a debtor's credit rating and ability to borrow for years. Somehow in India, we use bankruptcy and insolvency words as a completely same thing. But technically they are different. See, our IBC, anyone can tell me what is the name, what is the Hindi name of IBC? Let's see if somebody is still awake. Participants, please participate.
That is दिवाला और शोधन अक्षमता संहिता 2016.
दिवालिया एवं शोधन क्षमता.
दिवाला और शोधन अक्षमता,
right?
संहिता 2016.
Correct. So this also means that there is some akshamta, there is some disability. That is why the person is coming to you. This is Diwalapan and Shodhan Akshamta. This also means these are two different things. We at least at this stage, we don't confuse it. But in general parlance, we also know that these are, interchangeably used. Insolvency is a state of economic distress, whereas bankruptcy is an order by which it is declared that this person cannot pay off his debt. Whatever is left, please distribute among yourself. Bankruptcy can severely damage a debtor's credit rating. Thank you, Rajji. Individual can be insolvent without being bankrupt. Correct? You were insolvent. Let's say in 90 days, nobody went to, initiate bankruptcy against you. Then what happens? Then after 90 days, you have to go through the process of insolvency again. You cannot start away that, okay, once it is over, now we will go for bankruptcy. No. 90 days, within 90 days, if you did not apply, you have to come back and go do the process again. Insolvency can be temporary and correctable, right? From insolvency, there is a comeback. But bankruptcy has to be, it cannot be without insolvency. That means you cannot go direct. Now, what can be the different stages of default? Default can be, a default has occurred, but let's say no application has been filed. Now it's only a defaulter, let's say. Potential insolvent is when application for insolvency is filed, but order has not come. That is potential insolvent, right? And what is insolvent? That insolvency has been admitted, repayment plan not yet sanctioned. When the repayment plan also is undergoing, but he is not discharged yet, that time we call the person as undischarged insolvent. When all this has failed, adjudged as having failed repayment plan or no plan was submitted, nothing is not coming ahead, then it is called the bankrupt. That is the last stage of our dealing. Financial creditor, operational creditor, I'm sure all of you know. Financial is purely financial based on the time value of money, and OC is which are payable for the services, transactions, trade, employees, governments, workmen, all that. Now let's see the application. We have covered in the morning till chapter 3. Chapter 3 stops at 120. And 120 is that RP should act as per the code of conduct under section 208 and should not do hanky-panky stuff. 121 is the chapter 4 part of it, which is application. So 121 says application for bankruptcy. 122 is, either the promoter or the guarantor himself can, let me stop using the word promoter. So 121 is when the guarantor himself can go, 123 when creditors can go, right? So same like 94, 95, same like section 7, 9, 7, 9 or 10. So similar to that. So 122, 123 is the application for bankruptcy, which is because the one of the main condition when filing application is putting that order that insolvency has failed. That is a prerequisite. Now, insolvency process is a precondition. Direct application for bankruptcy is not allowed. It is possible by either creditor or debtor. Now, you might be wondering why a debtor will want to go himself as a bankrupt. But it is allowed. So maybe we can discuss if people will be participative. Otherwise, I'll continue going, right? And now creditors can file individually or jointly, two bankers, consortiums, all that is possible. In case debtor is a firm, application may be filed by, so this has not been notified as yet, but anyone can file if it will be notified. This has to be done within 3 months of the order passed, 90 days. It's not even 3 months, it says 90 days. Under section 104, 104 is when it is fraudulent, 115 and 118/3. We will see what are these sections, okay? I mean, you have learned in the morning. As the case may be. Applicant may propose an insolvency professional to act as BT. So it is always may. It is not like section 7 where you have to propose a person. It is just like section 9 where you may or may not propose a bankruptcy trustee. See, in insolvency process, personal insolvency process, this person, the guarantor, can anytime remove the resolution professional. He has the power. Nowhere else this power is there, other than section 97, I think. Where, because he is only a helper, he is only a friend to the personal guarantor, not in case of bankruptcy. And maybe that is the reason this, PUFE applications, which are preferential, undervalue, fraudulent, all that is not given. That RP, in the case of personal insolvency, does not have the power to file those applications. Reason being, the moment you will try to file those, you will be enemy of the personal guarantor and he will ask to remove you. So that power is also not there. So they are saying it is an amicable situation. It's more like a mediation. There is no force, there is no coercion as such. Even in our district courts in CPC, we go right under section 10, we go for mediation, which is now starting in, I hope, in IBC also. So this is more like a mediation stage, which fails, then we go for bankruptcy. Okay. Applicant may propose an insolvency professional to act. Application shall not be withdrawn without the leave. In personal insolvency, application can be withdrawn, no problem. But bankruptcy, because it's a severe thing, cannot be withdrawn without the permission, without the leave. Interim moratorium, same way, like there we have interim moratorium, here also there is interim moratorium. Like in the morning, there was a question, one of the financial creditor, I think they were asking that, is it on filing of application or it is like, what is the significance? Now, just to update you, sir, it is now not on filing. It is not on filing. Anybody would like to comment what I'm saying? Am I saying something wrong?
Yeah, it's on filing only, sir.
Yes, it is after filing moratorium starts.
And I'm saying something different, right? So am I telling you something wrong?
It was Kerala NCLT which said that it is from the date of registration.
This is interim moratorium.
Sir, the code says that it is from the date of filing. But date of filing can, the removal of defects in NCLT takes at times 25 days, 25 days.
More
also.
than that.
More than that. I don't want to say that, but yes, it does take, right? And then there will be defects. And then you'll keep curing it and keep curing it, and you can spend 1 year in that. And you are enjoying that interim moratorium. So court had said, NCLT orders are there, that it should be from the date of registration. That means removal of defects. Then only it should be taken, otherwise not. So that I'm only changing the code till that, I'm informing the change in the code till that extent, that's all. But yes, law says it is on the date of filing, because they thought that the filing is absolutely perfect on day one. Interim moratorium commences once the application is filed. So 123 is that application, 124 is your interim moratorium. It will terminate on BCD. So here, this is what we call Bandra Kurla. Okay. So BCD, bankruptcy commencement date. ICD, insolvency commencement date. Bankruptcy commencement date. It debars all actions against properties of the debtor in respect of his debt. Creditors are not entitled to initiate legal action against the property in respect of any of the debt. Such interim moratorium provisions not to apply to transaction notified by, these are, we are all aware of this section, right? Only thing is, after the admission, the secured creditors can go out of this process, that we are aware, right? It's not like CIRP. It is not like personal insolvency. Here, this is similar to liquidation. Liquidation, the secured creditor, if you have single charge, you are not sharing your charge with anybody. No pari passu, no second charge, third charge, etc. is there. You don't want to get into the common pool. You can take your own car. Coming into this process is like sitting in the bus, which the RP is driving, bankruptcy trustee is driving. Everybody will get into it. Wherever it will go, everybody will get their share. But if you have your own car, you have your exclusive charge on the assets of the person. This is as good as doing your own SARFAESI. You can move out of the proceeding also. No stoppage. Any question here? Our learned creditors have?
No, sir. This is what we know.
This is clear to everyone. Good.
I had a query.
Yes, please.
What happens if suppose just before the initiation of 94-95, the guarantor disposes of or transfers any of his immovable assets in the name of family members or a trust or something like that? Because as you said, in this case, we cannot file PFA applications. So what happens in such transactions?
I never said that you cannot file now.
RP cannot file, right?
RP cannot file. But
So
that
how do we
RP process is only 140 days, 120 days. So interim moratorium is 180, but entire process has to be over in 120 days. RP in personal insolvency is not able to file. But as bankruptcy trustee, the insolvency professional has lot more powers. And similar to pay, we can file to claw back, to cancel, to make the condition void, undervalue, extortionate credit, everything is possible.
And what is that time? Is there any time period within which those transactions would have happened?
Yes. So please stay for another 2 hours and we will develop that today.
Sorry to bother you. These are certain.
Perfect.
Because I will just give you an example.
Yes.
So that means whenever you are coming to that topic, you may consider this thing also.
Yes.
See, we have an NPA somewhere around 2010 or 11. We issue 13-2 notice. Within 6 months or a year, they dispose of or transfer their assets in the name of the family members or some trust, family trust only. Okay. Means it's within the family. So they are living there, everything is done. Now suppose, and then because when SARFAESI action is at a stage where the possession is to be taken, they file this section 94 or 95.
Correct.
Or when DRT application is at fag end where their assets can be attached, that is the stage where they do these things. So please keep that in mind when we are coming to that topic.
Deepaji, we are all aware that our promoters are very, very smart. They all know how to use the law. And unluckily, yes, what you're saying is right. Surfacey, in the end, they will stop it. And then the Limitation Act will start kicking in. Then they will take the plea of limitation that this has happened. There is grandfathering effect. But I mean, that's how the law is designed. So at times we have to live with that. So I'll be coming to that part and we will discuss this again once. Okay.
Thank you.
So who can file bankruptcy or when can the bankruptcy be filed? Three situations, right? 104. Creditor is entitled to file application. Application for IRP is rejected by the AA under section 100. So 100 itself, it was rejected, correct? So 100 is the admission, right? If it was rejected at that stage itself, you go straight away for bankruptcy application. Let us say it did not happen that way. So in one of my case, it happened. In 100, they did not submit. If you see our code, funnily, it says creditor shall submit. Now, what if creditor does not submit? It's possible, right? That is not envisaged. Nowhere in the code it says if he does not submit. If he's not submitting, why will you call for a COC meeting? There is no need to file a COC meeting. Why do you need to? Now the code is saying even if nothing, you have to file. Call the COC meeting that new regulations have come. Earlier, RP was at a choice that if there is no need, don't call for the application, straight away file. So 104, 100 of, subsection 4 is when the application is rejected. And when I say any of these orders, everybody is entitled to file. So creditor is entitled to file. Here, so this is 100. After 100 comes those stages of you are putting notice, these claims are coming, all that story is happening. Person is giving you repayment plan. That repayment plan goes in 106 report, goes to the NCLT. After that, there is a COC meeting with 3/4 share. You either reject it or approve it. If it is rejected, you file for application accordingly. If it is approved, you file for accordingly and put the implementation. So if the order of A recording rejection of repayment plan, then under section 115/2, anyone can apply and again go to the same process. Suppose even if the order was approved, now the implementation is started. He gave very rosy picture. I will give you 90% everybody. But it fails after 6 months. Then order of AA on premature ending of the repayment plan under section 1183. This is the third option. If it has come to an end prematurely, you again go for the bankruptcy application. Here also, debtor or creditor whose claim have not been fully satisfied, they are entitled to apply. Now, obviously, everybody cannot apply. If your claim is settled, why will you apply? But even if it is not fully satisfied, you can apply. So 121, 122, 123. This is bankruptcy in one page. It looks so easy. So let us see. We'll just go through it once and then we'll go section by section and discuss the things, what is happening. So application for bankruptcy order is filed. You will get a moratorium, interim moratorium. At this stage, nomination of bankruptcy trustee is done. So either you have nominated or from the panel, NCLT will pick. If it is nominated within 14 days, ideal situation, not in real world, but ideal situation. Within 14 days, bankruptcy order should come. Within that, 10 days, you have to give a public notice. See, in CIRP, public notice in 3 days. In liquidation, public notice in 5 days. In personal insolvency, I think 7 days. In bankruptcy, now the public notice is within 10 days. So these timelines are changing. I personally don't know what is the good reason for it, but it is like that. So on bankruptcy order of AA, that is what we call as BCD, bankruptcy commencement date. Here, bankrupt will submit statement of financial position to the bankruptcy trustee if the application was filed by a creditor within 7 days. Once the notice is there, within 7 days, you'll ask everybody to file their claim. And obviously, the bankruptcy trustee is already aware of, who all filed during the personal insolvency. So that list is any which ways with you. That is why this 7 days only. Otherwise, in CIRP, you get around, I think, 14 days, first 14 days. Then you have 90 days also to file claim. And then in liquidation, you have some other timeline like 14 days to 30 days to file the claim in liquidation. Here you have 7 days to file the claims. Creditors will register. After that, within 14 days of by BCD, so 7 days here and 7 days here, BT will prepare the list of creditors, give notice of meeting. A notice of meeting will be within after 7 days. So 7 days, 7 days, 7 days. So it looks like, pretty fast. Everything will be in place in within 7 days. And 7 days never says working days. 7 days means 7 days. Can be Diwali, Holi, whatever, doesn't matter. So 7 days you have to do. All these are directory only in case of NCLT. When it comes to IBBI or the RP, if most of you are RPs also here, whenever you are doing these cases, please ensure that these are not discretionary. These are pretty mandatory when it comes to RP or BT. So please try to stick to these timelines. Yes, Ms. Deepa.
You have said that we have to file our claim within 7 days. Okay.
Yes.
The issue is that many of times these are paper publications. We don't even come to know about the personal guarantors. They don't serve us a copy. Some other creditor or some other person has filed it. We will never come to know. Then in that case, what do we do?
Okay. I think you had asked this question in the morning time also, right?
Yes. Yes.
Okay. So I have a small answer to this. Okay. So first of all, the RP who is now I'm talking about little real, theoretical scenario. The book of accounts are there with the RP from the personal guarantor. Personal guarantor is aware who all I owe the money, isn't it? When he is putting a payment plan, he will be putting the names of all the people who he needs, who he owes money. A, B, C, D, this bank, that bank, right? Now, all that information is already with RP. RP is supposed to inform all of you, all the creditors. That is one way of doing it. But recently, I've come to know that one of my case, PTC said we got delayed in personal insolvency. What do we do? Now the RP has rejected our claim, which ideally should not be the case, because if your claim is not registered, it does not extinguish your claim. It is unlike CIRP. CIRP, your claim goes away, goes off. If you're sleeping, you were sleeping. In personal insolvency, if you're sleeping, you're not sleeping. You can come whenever you want. Even after so this is within 7 days. This 7 days, within 7 days is to make that first COC thing. You can still come after that. It doesn't stop you. But answer to you that, where to find, is there a central, location where we can find? Unluckily, so far, even with ICSI, also, personal insolvency, we don't have much. In fact, in NCLTs also, there were not much, ado given to this topic. Even in IBBI, where we have IP, RP logins, there also, it's only the corporates which we are focusing on. Personal insolvency matters are not even, there's only public notice which is available, I think. Just IP1 we can file. There is no CIRP 1, 2, 3, 4, 7. There are so many forms which we file for CIRP, but not in this case. So personal insolvency and bankruptcy, ma'am, right now there is hardly any public information available. But there is I mean, if you are in Delhi, trust me, most of the publications are coming in Jansatta and Financial Express. please check them. Right now, that is the only option available. And NCLT,
Thank you.
notice, but hardly anybody goes there. So right now, that is not there. Okay, we can move on. Notice to summon the meetings. After this notice, obviously this looks like short, but it is within a year, 2 year, depends, how much time it takes. Your completion of administration and distribution of estate, a report of the administration by trustee. This report will be presented in the meeting of creditors, and once that is approved, the trustee approval of trustees report by the committee is there. You file that bankruptcy trustee should be released. Now the matter is over. So this is like dissolution. This is like dissolution, right? But dissolution is for the bankruptcy trustee, because the bankrupt has already been dissolved long back. Trust me. You might take 3 years to finish this, but your bankrupt person would be out of this claw within 1 year. So 1 year is maximum any which ways. I hope people are aware of this. So from BCD, it's either 1 year or before. It's not after that. So within 1 year, this person is out of all the troubles. Now okay. So this entire process, we will learn in detail how section wise it is happening and what all we do. Knowing this bankruptcy process, you will be able to take better calls in the COC meetings of personal insolvency, because you know that if this fails, what can happen, or what all powers do you have to take over the person, or suppose you have nothing, you cannot do anything to this person, then you might as well agree to whatever he's offering in the personal insolvency, isn't it? In that case, let's learn section by section. 122, 123, 120, 122, 123 is application, right? 124 is your effect of application, where interim moratorium shall commence on the date of making. And it continues till BCD. 125 says appointment of BT. Now, in this also, if the IP is proposed, same person can be appointed. They check with IBPI. So they ask in 7 days, IBPI will tell in 10 days, and then next 14 days, you have to appoint the person. 125.2 says IBPI will tell in 10 days. Doesn't really matter. 126 is the bankruptcy order. They will pass the order within 14 days if possible. 26.2 says within 7 days you put a notice, put a copy of application of bankruptcy, and the bankruptcy order should be provided. Now 27 says the validity of your bankruptcy order, which has been passed. So this is effective till the debtor is discharged under section 138. So section 138 is discharge of the person. We will learn that, but validity is till then. Anybody would like to tell me what is the validity of a lookout circular or summons or warrant? Anybody knows? What is the validity of a warrant?
Till the cancellation of
Till? Surinder ji is saying something.
सर वारंट एग्जीक्यूशन हो जाए या फिर कैंसिलेशन हो जाए मजिस्ट्रेट से, तब तक वारंट रहेगा.
जब तक एग्जीक्यूशन ना हो तब तक it is valid. Correct?
Yes, sir.
Good. So lawyers, I'm just testing some lawyers in between. So validity is till 138, which is discharge, and this is normally 1 year time. Just a ballpark figure I'm telling you. Effect is, what is the effect? So validity we have learned. Effect in 128 says on passing, the entire estate of the bankrupt will vest in the bankruptcy trustee. all his property without any assignment. He doesn't have to sign anything. It's already assigned. Just that order is required to confirm that this property now belongs to the bankruptcy trustee. So creditor, what will happen? Creditor shall not initiate any action against the property. Creditor shall not commence suit or legal proceeding except with the leave of the A. And secured creditors, their rights are not affected if they choose to. Suppose you have an secured means if you have a property, along with. So if you want to do some action against that property, you are free to do that. You only have to give an affidavit saying, I want to keep this out of the bankruptcy estate. 129 says the bankrupt has to give statement of financial position. Bankrupt shall submit to the bankrupt within, BT, within 7 days. Very ideal, but let's hope it follows. 130 is the public notice needs to be sent. Ms. Deepa was asking. So this notice has to be sent to creditors mentioned in the statement of affairs submitted by the bankrupt. So bankrupt himself at least knows whom all he has given guarantees. So all that notice has to come to you. You don't have to keep searching. It is bankruptcy trustee's duty that if you are mentioned there, he should be sending it to you. And also public notice has to be given because in our India, public notice is for general public to be aware. If something has been missed, it should have been covered by that. Okay, this was 130. 131 says registration of claims that you file with BT with the proofs. 132 is preparation of list of creditors. 133 is summoning of the COC within 21 days. So 7 days, another 7 days, another 7 days. Pretty easy to remember for IPs who are RPs here. Please keep it pretty easy. 7, 7, 7. So 7, 14, 21. Section 134, it says conduct of the meeting. Now, anyone can tell me what is the quorum for CIRP proceedings, COC quorum?
33%.
Very good, sir. So 33%. In bankruptcy trustee, bankruptcy period, there is no quorum. BT will decide the quorum. Whether 1% is good enough or 10% is good enough or 20% is good enough. There is no quorum mentioned. But going by precedent, if you want to keep it 33, it's up to you. You want to keep it 50, it's up to you. If there's only one person, let's say you don't want to call anybody, it's up to you. So conduct of meeting, BT shall convene the meeting, constitute COC, decide on the quorum and prepare minutes and share with the stakeholders. 135 voting rights. Voting rights are only for the liquidated debt only. And obviously here also we exclude the associates and the secured creditors who are opting out, correct? So secured creditors who are saying we want to, exercise our right to enforce our security independently, they can be kept out till that part. So what are unsecured part, they can still be there in the COs. 136 says that the BT shall conduct the administration and distribution of the estate according to chapter 5. And two of the regulations are important, which is regulation 8, which says within 90 days you should file one preliminary report. And regulation 10 says that every quarter you should file a report at least. So in 1 year you file at least 4 reports, and then suppose you run it for 4 years, then you have to file every quarter. So it doesn't mean that you are getting free on year 1. You may be stuck with this process for 2 years, 3 years, 5 years, till the entire estate is disposed of. Right now, we don't have experience of people. If anybody is here who has been appointed as bankruptcy trustee, please tell me. Do we have anyone here by any chance? Okay, doesn't look like. So right now we don't have any bankruptcy trustee here in this group. So 137 says BT shall convene a meeting of the COC on completion of administration and distribution of the estate in accordance with chapter 5 and decide or approve release of BT under 148. So 148 is your going home. Your means our BT is going home, insolvency profession. Now let's see the 138, which is the main discharge order. This is the Scot-free ticket, right? That okay, now you go home. BT shall apply to AA for discharge first on expiry of 1 year from the BCD. And this is subsection 1. That means this is on top. Or within 7 days of the approval of the COC of the administration of the estate of the bankrupt under 137, if the approval is prior to 1 year mentioned above. So it's whichever is earlier, not whichever is later. So this is 1 year or less. So 1 year you have to leave the bankrupt out of this preview. Not the bankruptcy trustee, but the bankrupt will go out of the preview. And obviously regulation 11 says that file your final report along with 138 so that under 148 you can be released. Now what will happen? 138 we have filed. 138 means let this person go, my lords. What will happen in 138? 138 says release bankrupt from all bankruptcy debts except excluded debts and debt incurred by fraud or breach of trust. Now, I think this is a pretty vast thing. Ms. Deepa, you were asking that you believe that it has been done by fraud. We can still keep this person intact here, saying that by fraud or breach of trust, if this has happened, he is not released. But all other cases, the person is released and excluded debt also. So excluded debt we learned in the morning, right? Like student loan, if you have to pay maintenance in marriage, some court order, all that is your excluded debt. We will learn. If you want, I have made notes of that also. We'll learn what are excluded debts and excluded assets. So what are the after if any? Sorry, you were saying something I missed.
No, I said thank you. One more thing.
Yes.
In this case, suppose the creditor, because it's a personal guarantor. So if at some point of time they don't mention about any unsecured creditor, financial creditor, then how will they find out? Because in corporate, if you see, the company balance sheet many times does not mention who are the guarantors. Okay. And this may be not a family guarantor. This might be somebody else who is a third party guarantor. So in such cases, how will the insolvency professional find out as to who are the creditors?
The person has to give his financial affairs, right? Because he wants to get out of this clutches or what we call the rigors of law. He has to tell who all he owns the debt to. If he's not mentioning you, see if he forgets by chance, by mistake, that is a separate scenario. But if he has not mentioned you, he knows that you owe, let's say, 50 crores. And your name is not mentioned in the statement of affairs, he's hiding it. Then there are, fines and punishments, which we will learn in the end of this session today, that what are the punishments available, whether can we put him behind the bars, what all can we do to this person. And obviously then that is the threat, because in law we always says, what if I don't do, what will happen? So what will happen is we will either take you to imprisonment or we will put another 10 lakh, 20 lakh, 50 lakh fine. So if he has given a wrong statement, your claim does not just vanishes. It will remain. You will come back to NCLT saying this statement of affairs, he is well aware, we have been communicating, she still did not give it, he hide it. That means there is a flaw. Now that flaw, because of that flaw, kindly compensate our loss and that loss has to be covered by 3 times. That means he can again get into trouble if this person is not coming with clean hands at this stage also. But
Okay.
if you are asking for an answer that how in IBBI website CIRP notices are there, ma'am, that is not there right now.
Understood. Understood. Thank you.
Section 140. So effect of discharges, we know that he will go away. But what happens if, so before that, what happens? In section 140, we learn what are the disqualification of bankrupt. What happens, right? If bankruptcy start, what can happen? So till discharge or recall, there is a possibility of recall of orders also here. Huh? In liquidation, there is no recall or any such thing. But here, let's say if the order was wrongly met, the person could not represent himself or something, or if there is some apparent error on the face of the order, AA has the power to recall the order under section 142. We will learn that in coming slides. So, but what are the disqualification? Disqualification is this person, this guarantor, he cannot be appointed or being appointed or acting as a trustee or representative of trust, estate or settlement. He cannot be appointed and he cannot continue as such. Second, he cannot be appointed and he cannot continue acting as a public servant. So any government servant, any public servant office, public office, he will be removed from that, at least for that period. He cannot be elected to any public office. Any public office is like elections, like MLAs and mayors and all that. So he cannot be put in that also. He cannot be elected to any public office. Also, being elected, sitting or voting. So he cannot be a sitting member, cannot be elected, cannot be nominated as a member of the local authorities also, like development authorities and all. It cannot be. So a lot of restrictions in terms of if this person has some social standing, then this person is scared of this part. Okay. What are the disqualifications? This is for people who have some social standing, right? If they don't have any social standing, you know the answer, right? So what can you do to the person? Under section 141, we learn the restrictions. What are the restrictions? So disqualification is disqualification. Restriction is we hold you from doing something. What all we can hold him? He will not act as a director or promoter, or he will not form, or he will not manage any new company during the period of 1 year. Okay. He will not create any charge on his estate, or he will not take any further debt without the BT sanction. BT is bankruptcy trustee sanction. He will also have to inform every of his business partner and every party with whom he is trying to enter into commercial transaction that he is going under bankruptcy and he is a bankrupt and still is entering into contract. If they want to still entertain it, they can entertain, but he has to inform. And the limit for this is around 1 lakh rupees. Anything above 1 lakh, he has to tell them in writing clearly. Also, last and but not the least, I think it's an important one. He or she cannot travel overseas without AA's explicit permission. So this is also an important one. Disqualification under section 140 and 141, we learn the restrictions on that. So restrictions, if you see, cannot be a member of professional body, cannot be director, promoter, cannot create any other charge, cannot take further debt, must inform partners, must inform every party before entering 1 lakh and above, cannot maintain any legal proceedings also, cannot travel overseas without permission.
So, one question.
Yes.
This bankruptcy, or even in the morning also we spoke, this is quite easier to implement in the regions like Mumbai, Pune, or Delhi, Bangalore. But when it comes to the rural area, it is very difficult to implement.
It's
we can
almost
implement,
impossible. It's almost
how
impossible.
to implement in the rural when you go from all this uh, matlab Mumbai, Pune, and all this. If you take even Delhi, if you go to the natives or rural place, how
You
to
know,
implement this
we
kind of?
have a joke that this law stops at 50-kilometer circle from Supreme Court. After 50 kilometers, it's tough to get bigger
Yes.
assets to go after. Imagine when, that is why we keep saying that, imagine when personal insolvency will also come under NCLT or DRT, where you have 1 lakh rupees you have to take from somebody who's sitting in hinterlands of Bihar. How will you get that out? So they'll wait for 1 year. After 1 year, they are discharged. Simple.
Not only 1 lakh, even it is very difficult to take the 1 crore also from him.
You're right. You're right. You're right. So these practical this, and as I said in the beginning also, many of us have not been bankruptcy trustee yet. We are also learning the law. Right now, we are learning the law. We are also facing difficulty because see in a CIRP, what happens? You have uh, at least bank statements. Sorry, ITRs and statement of accounts, everything on MCA, ROC somewhere. In individual, how do you find it out? Individuals ITR I cannot access. How do I access those ITRs? Where to find them? And they have stopped filing ITRs 10 years back. They know that this thing is happening. They have stopped it. What will happen? Income tax will not give any other new loan. They are not getting new loan any which ways. CIBIL is already zero for them. So they are any which ways dealing in cash most of the time. So yes, those are practical difficulties we are facing, and that is why I said let this interaction be little more interactive. So we discuss it out, and you also tell us as RPs what do you think. See, we say that appoint an agency which can look at how we call investigators, and all that is also an option. Currently, I don't know how they are being used. So we'll be. I think somebody was raising hand. Sorry, I missed.
No, that's me.
Yes,
I was talking about like the earlier slide, the last thing about the restriction that he has to take the permission from AA to travel abroad and out of
yes,
the country and all. So,
yeah,
is there anything by which way is his passport been impounded or taking charge of his passport? See, because the thing is very much sure, no bankrupt is going to take permission. He'll definitely fly away if he's having that thing with him.
correct, sir.
That was a small question, and even whatever my colleague has said, that is also right that remote locations you do not have that control.
Absolutely, sir. And remote control locations, you any which ways have panchayats. There is no law there, right? So
Hmm.
how do you implement an insolvency? They have not even heard of NCLT. What is NCLT? So they only know Sipahi Babu and Thanedar Sahab. So how do I get and implement my right there? Agree, sir. Plus, there is no mention in our code that we should impound the passport or ask the person to surrender the passport. So, in my view, I think at the time of application itself, when the bankruptcy order is being passed, the lawyer should direct that this should be kept with the RP or the bankruptcy trustee, because I know cases, sir, where people are, standing on the other side of the airport. They clear the security check and they wait for ED's hearing. So whenever, if the ED says, okay, bail is extended, they come back.
Or
Or
they fly away.
bail is not extended, then go home somewhere. So
Uh,
that's a sad truth of uh, what we are living in with, sir. But yes, fair point. I think all the lawyers who are listening here and all the resolution professionals who are being appointed as bankruptcy trustee, I think it's a good takeaway that let us put a prayer in that itself, that please stop this person from traveling overseas. And only possible way to do this is hold the passcode. Because there is no option of passing a lookout circular and this and that right now. It's not there.
No, by that time, to sir, he will be settled somewhere else. Sure, thanks a lot, sir. No worries.
So we are discussing that, as you rightly said, we are just discussing right now. I'm not AA and you are not AA. We are here learning what the law is talking about. Right?
Yes, yes.
Okay. So after 140 and 141 restrictions and disqualification, we come to section 142. Now this modification or recall of order can be on application or suo motu also if there is an apparent error, if both the bankruptcy debt and expenses are paid and or satisfactorily secured. And then obviously that is binding on all of all the people involved. You know why this recall order is also given? In one of my matter, in the bankruptcy matter, the order has been reserved 5 times. So normally in NCLT, when the order is reserved, there is no chance of, reopening it. My order has been de-reserved 5 times. Reserved, de-reserved, reserved, de-reserved, reserved, de-reserved, right? Only because courts are not inclined to start the bankruptcy process. They are trying to give them a chance. Reason being, like, and what is the logic which is coming to the picture is, if in CIRP, let's say it fails, you go for liquidation. In liquidation also, first 90 days, what do? You can sell it as a going concern even during the liquidation, isn't it? Going by the same premise, they are saying in bankruptcy process also, why don't you take a repayment plan from the person? And if it succeed, then we will modify or recall the order, finish it. So, till last moment, we keep giving chances. And then obviously, people are using their chances to get away. So 142 is modification or recall of order. After that, fees of bankruptcy trustee, always a problem, right? So fees of bankruptcy trustee is given under regulation 4.2 of schedule 1. So either the ARCs or financial creditors can decide on the bankruptcy fees, how much you want to give. If it is not decided, then as per schedule, first 6 months you have particular fees, next 3 months and next 3 months. And then thereafter, that slab is there, right? So fees will be in proportion to the value of estates, and it will be paid from the distribution of estate as per section 178. Now 178 is exactly similar to section 53. You know what is section 53, right? Waterfall mechanism, where we call that priority of payments, etc. Right? CIRP cost have to be paid first, all that. Exactly similar. So first is bankruptcy process fees, then comes secured creditors and workmen, 24 months. Then comes your, other OCs and employees and all that. And in the end, if something is left, you can give it to the bankrupt person also, which is never a possibility. We were saying in the beginning, bank insolvency professional, in case of insolvency resolution professional, can be changed anytime and anybody can change him, right? But here the bankrupt does not have an option of changing. He cannot file an application that change the bankruptcy trustee. It is only the COC with 75% votes which can change the BT. In CIRP it's 66%, here it is 75%. But rest everything else is same. In CIRP, even resolution plan is 66%. But here the repayment plan is 75%. So that has not been changed. So replacement of BT is by 75% of goods. Other than
May I ask you?
yes, Ms. Deepa.
Like an insolvency professional can also be changed by these creditors?
Creditor is COC only, ma'am.
Yes, can they change the insolvency professional?
So let's not use the word insolvency. You want to change bankruptcy trustee or you want to change resolution professional?
Resolution professional.
Anytime, ma'am.
Okay.
The poor person is at your mercy most of the time. As soon as you have 66% votes to change the person, you can change the person. And at
Okay.
times they used to ask in courts, initially they said you have to give reasons why you want to change. Then one of the senior NCLT members said that why you want reasons? They will say that you are not doing a good job, then you will go away. So why you want them to put a blame on you? They are asking you to go away, then go away peacefully. What is wrong in that? So only you should not change the person only because that person is not in your panel, like which is maintained by many banks. Only because of that reason you should not change. But if the person is not acting properly, not acting as per the law, you have all the rights to change the person. Okay. So replacement of BT is possible. Resignation of BT is also possible. Nowhere else it mentioned resignation of an IP. I am yet to come across in the IBC code. So resignation of BT is also possible. It is possible when he intends to cease practice as IP, or conflict of interest or change of personal circumstances have happened, like how we do in law, like for judges, they recuse themselves if some new light has come. So this person can also recuse himself from this BT duty if new things have happened. Also, there can be a reason vacancy in the BT office for some other reason also. Many of our IPs are above 60 now. So, there can be vacancy because of some other reason that is covered under section 147. 148 is your release, your BT. So bankruptcy trustee release. So he's released on he or she. When I say he, please count as C also. So this person is released on appointment of new BT or completion of administration. So 137 is your completion of administration. 138 is discharge of your bankrupt, right? Now this is that fee structure. If anybody would like to just take a minute here, we can read it. First option is decision by COC or creditor, or second is percentage basis. First 25 lakh, you will get 10%. Next 50 lakhs, you'll get 7.5%. Next 1 crore, 5%. All that is. So initially the fees looks pretty decent, but normally we know that in first 6 months, how much things are going to happen. So we normally look at this side, this one. So 5, 3, 2.5, 1.8. This is practically this is possible. This is on realization. This is on distribution. Percentage of fees on distribution. Okay. So when you become BT, then we will look at it further. But right now, before giving your consent to act as BT, please read it once if it is already not decided by the creditors. Next. So this was chapter 4. Chapter 4 is till 148. So chapter 3 is personal insolvency. Chapter 4 is bankruptcy trustee, bankruptcy process. Chapter 5 is administration and distribution. How do you do the administration? Administration means first day you are in charge of the estate. So estate looks pretty, a nice term to look at. But estate in India does not mean you have a big estate, right? Estate can be any asset of the person. Function of BT. Function of BT is investigate the affair of the bankrupt, realize the estate of the bankrupt, and distribute the estate of the bankrupt. Investigate affair, realize the estate, and distribute. Duties will be giving information. This is duties of the bankrupt. Bankrupt, but how he has, what he has to do in that 1 year, because 1 year is totally free. He'll not get a job, he'll not do anything else. How he is going to survive? Now, there are as a practical question, there are people who came to us. They said, you are not allowing us to do anything. No public office, nothing, no jobs. Nobody will give us job at this age. So how are we going to survive for 1 year? Now, in this 1 year, I need, let's say, 10 lakh rupees, 15 lakh rupees. My total malkiyat is 20 lakhs. Now, how you want to distribute it? You tell me. 10, 15 lakhs I need for my survival, or let's say 12 lakhs. What is the next step? Any suggestion here? Anybody can have? Should we allow that 12 months expenses? The person has to survive, right, on something. Bank accounts are with you, everything is with you. How will this person survive? Can you give him some monthly stipend? No answer. Okay. No answer. So right now, even I don't have an answer. We
But
have to
what
learn
if
it.
his family is earning good?
You are assuming that, ma'am.
Yes, it is assumed. But what if he is having a good family background, or let's take this Anil Ambani's example, which we took in the morning also. Never a case that he was actually poor. Everything was on paper. So in that case, his family was owning a good uh, properties and all.
Ma'am, our worry is we are talking an example which is easier to understand.
Yes.
So just now we were talking about hinterlands of Bihar. How do I do that? The person says, I have only 10 lakhs, I need 10 lakhs, story over, thank you. So we don't know. At times, when it comes to personal insolvency and bankruptcy, these things are really tough to determine. How do you know whether this person is saying correct? So few days back, I got a person who's coming to me, uh, promoter of a large school group in personal insolvency, and obviously he came for advice. I told him to ditch his BMW and start running I-10, because you have to appear poor also, right? If you don't want to give a good repayment plan.
Actually.
So they also have learned that. Now, they're saying, oh, it's not my car, it belongs to my daughter. I said, who gave it to the daughter? You only must have given it to the daughter. Then why are you doing it, like, on the face of it? But they will give all sorts of stories. And as a human being, as a bankruptcy trustee, how much powers you will have, how much you will exercise, all that remains a question which we are now learning. And hopefully, when a lot of bankruptcy cases will start getting admitted, we will have these seminars again, so that to learn how we are now tackling them.
Okay.
Yes, let's move. So duties of bankrupt is giving information to the affairs, giving correct and factual information. Okay. He has to attend to the BT as and when required. So the BT is saying you come tomorrow, he has to come tomorrow. He has to attend. He cannot say, oh, today I'm not available. Today I have a function, today I have a party, I'm enjoying. Let's meet after 1 month. That is not the case. He has to attend to the BT as required. Also, giving notice to BT of any acquisition or devolution of any property or increase in the income within 7 days. So if there is any increase in the income, let's say his Nana ji has passed away and given him 100 crores, new property is devolved, he has to inform you. So all that within that 1 year, this person has to inform. That is duties of the bankrupt. 151 talks about the rights of the BT. By his own official name, he can hold the property, make contracts, sue and sued, enter into engagement in respect of bank. So this person becomes the bankrupt. Or let's say that phase changes to this person. He can do anything. Execute power of attorney, per commercially I'm talking about, okay, not family wise, but commercially this person can hold property, make contract, sue, be sued, enter into engagements, commercial engagements, that's possible. General powers, while discharging functions, he can sell any part of the asset, he can prove his debt, he can demand, if let's say some dividend has to come from somewhere, he can draw that, take in the account, he can exercise right of redemption of any pledge, hypothecation. Suppose the car is with the bank and it's only 10,000 is remaining. You give that 10,000, take your car back. It is your money. You can take that. He can exercise any right of any security, transferable property, all the. So see, the law talks about the bigger picture. At times we only look at the trees, right? We don't look at the forest. So the forest talks about he has all these powers, he has all these rights. Now, in that, how much he needs to use, that depends on case to case basis. Again, just like going to COC, approval of creditors is required in many cases. Many cases like wherever money is involved. So that somebody is there to check the, working of the BT also. Now, also, so arbitration, if you need to go, if you need to settle some cases, you can take approval of the COC. Now, BT can appoint the bankrupt also. The bankrupt himself he can appoint to supervise, manage, and assess. And when I say appoint, this also means you can pay him some money to survive. So suppose this person is coming, he's saying, I don't have any money to survive. You will ask him to work to get all these big things sorted. If he's helping you, if he's doing right things, you can allow him some money, but obviously with the approval of the COC. Bankruptcy trustee can appoint other professionals also. Okay. So insolvency professional, nowhere it is mentioned. Sorry, resolution professional in personal insolvency is not allowed. There he is not allowing any valuers or accountants or nothing like that. But in bankruptcy trustee, he can appoint a valuer also, he can appoint second valuer also, he can appoint uh, other professionals like investigators and land identifying agencies and all. And that will become part of the bankruptcy cost, which is paid at the top, right? Section 154 says vesting of estates in the BT immediately from the date of appointment, without assignment or conveyance or transfer, any other deed. Sorry, somebody was saying something.
बढ़िया में हाँ हाँ
Raji is
आप
looking
कैसे
for biryani. Raji, please, biryani sham ko sir.
हाँ बोलिए
Your phone is not muted, I think so. That's okay. Vesting of estate in the BT immediately from date of appointment without assignment, it is vested in the BT. Estate of bankrupt includes what? All the rights and the properties except excluded debts and property held in trust. Also, PF, pension fund, gratuity fund of
नहीं क्या
employees,
क्या बोला आपने
etc. are not included. Sorry, some.
हाँ अच्छा
राजी म्यूट कर लीजिए प्लीज, हो सके.
अच्छा हम्म हम्म
अंजलि जी म्यूट कर दीजिएगा सर को 2 मिनट के लिए. ओके. Acquisition of control by the BT. BT shall take possession and control of all
अपनी
property.
अपनी एक्चुअली क्या है कि मैं एक वेबिनार के बीच में था तो उससे फ्री होता हूँ और फिर उसके बाद मेरे एक सीओसी में लगा हुआ हूँ 5:30 बजे से सीओसी में रहूंगा अपने लेट इवनिंग में बात करते हैं ठीक है ना ठीक है ना
Muted him. Okay. Okay. So acquisition of control, same like an RP, IRP, you have to take control of the person. In insolvency, personal insolvency, there is no taking over of control. Huh? There is no, you don't go to the person's house, you don't take over things. As bankruptcy trustee, you have to take over everything. So obviously, as bankruptcy trustee, your job is lot more difficult than the resolution professional in the personal insolvency. And that is why, just a question for all insolvency professionals here, do not quote fees which people are quoting in as in personal insolvency. People are even quoting 25, 30, 35, 50,000 a month. As bankruptcy trustee, you won't be able to survive on that. So your job is lot more and lot more difficult because you have to now actually fight with this person because you are now stripping this person of all his assets.
So I had a small question in this, just
Yes.
for my understanding, that
Yes.
if the BT is taking over all the assets, books, and control over the properties and everything, so is the bank accounts and everything and signing of checks and everything been included in that?
Yes, sir. He
Cause
can.
upon disposal, cause if he disposes the assets like the other properties and all, then he will take those monies into accounts of the bankrupt, or he will open a separate account as a BT on this.
Ideally, sir, ideally he should appoint a, see how in CIRP we do, we open a
Exactly, that was my question.
right?
Okay, is it the
We,
same ways or?
same way, sir, same way. See, person, see in a company, it's easy to have a stamp and for, let's say, so and so Build Mart Private Limited, I can sign, somebody can sign, right? For a person,
Hmm.
Suresh signing for Ram will be, pretty difficult. So if
This position will be a little bit awkward because when if in a BT, the person will be paying his own personal bills, some mediclaims that he would have taken. All
right.
this control to be taken by BT will be a harsh and a very tough decision. Like he'll be cornered in every place then.
Sir, it has to be. So actually, that is why I'm saying the bankruptcy process is not an easy process and should have been like this so that the person gives you a good repayment plan. If this is not harsh, the person will not give you a good repayment plan. Repayment plan is the last chance for this person to do something good. Whatever has happened to his capabilities. And right now we are assuming that every promoter is a crook. Let's not assume that. There might be some genuine failures also, right? So if there are
Absolutely.
some genuine failures, this person has a way out to give you a good repayment plan to the best of his abilities. If it's still not available, then he will say, okay, go to bankruptcy. What can I do? That is the best I could have done. But if the law is not strict, sir, it might be harsh, but that's how the law is. You should take over all his assets like how we do it in CIRP process. So all his assets, but collecting any money, in my view, it doesn't say, okay, the law does not say should open a account. In regulations, it says, yes, you should open a separate bankruptcy account so that I think regulation 4 or something it says that you open a separate bankruptcy process account so that all the proceeds can come into that.
I think it has to be. So थोड़ा ऐसा रहेगा. It has to be like that. मैं देखते sir. We'll read on that.
I think there is a section there. Okay. Today creditors are talking, RPs are not talking. I don't know why. RP should also talk, isn't it? Okay. Let them sleep. So excluded assets. These are the excluded assets which are not touched by. And obviously, when these are excluded, people have a tendency to keep them as inflated as possible. So personal ornament exceptions is there, right? Personal ornament of debtor or his immediate family. No question of vesting of assets of immediate family members. Let's say you are personal guarantor, the wife owns no lakhahar of 10 lakh rupees. Can you take it? It doesn't say, sir. The law doesn't say that that necklace can be taken. So actually till 1 lakh it has to be given. It has to be kept with the person. So if you're a Sikh, you have a kada of, let's say, 1 lakh rupees, golden kada. He or she has a right to keep it that way. Your tools, books, or vehicles and other equipments which are necessary for your personal use or the employment or vocation, those also have to be left. But how many vehicles have to be retained? Let's say this person says, I'm in the business of taxi, providing taxi services. Can he keep 5 cars? Is that a possibility? You might get an option, right? He'll say, my business is taxi flying only. Now this is the only job I can do. So I'll keep 5 cars for me, 5 luxury taxis, all 5, let's say, Mercedes. Because this is necessary for my employment or vocation. So these kind of stories are also, we have heard, personally I have not heard, but these kind of stories also people have started talking that, they are still living their luxury life and saying that, we need it for under this provisions. Same way, furniture, household equipment or provisions for basic need. Now it does says basic need, but I don't know how do you, take away somebody's dining chair if it costs 5 lakh rupees or something. So these are easier to write in the code here, but I think it's pretty difficult to exercise that, right? And if it's only single dwelling unit, let's say 50 lakh rupees, how will I take this person out and say that, okay, only 20 lakh is allowed? So either he will have to arrange 30 lakhs from somewhere else, get that valuation done and keep that unit with himself, or he will have to go to a rented place. If he has to go to a rented place, now BT has to pay for the rent because how will he live otherwise? So all these things will also come into the life of BT when we are going ahead. Also, unencumbered LIC or pension or life insurance plans have to be there. Again, these life insurance plans should not be in multi-crores, okay? They should not be that he's making a pension of 100 crores or 200 crores like that. Should be reasonable, right? 50 lakhs and 1 crore is fine. But if it is already continuing, let's say for 10 years, how do you stop it? Do we have right or should we have right? Because now we know the person is already 60. He has been making money for, let's say, putting money to insurance companies. Now, if you stop it, what will happen? They will enjoy. So somebody will be happy, but issues on excluded asset. Similar issue is with the dwelling unit also, right? Dwelling. Yes. So dwelling unit should be residential, not the commercial and all, right? So if there is an unencumbered single dwelling unit, which I personally does not believe that there will be any single unit which is unencumbered. So people like promoters, they must have given some security somewhere. So how it will ever be unencumbered? Anyone can give me any example which you come across a person who's taking so much of loan, who's in so much of stress, has a very clean property which is unencumbered. I personally doubt. So I don't know whether we will get any such property which is unencumbered.
I have one question.
Yes, Mr. Raj.
Yeah, suppose one person is having running LIC policy, he is regularly paying the premium.
Correct, sir.
And as a bankruptcy trustee, whether the premium need to be examined, whether it is very
Reasonable.
heavy because the outflow is there and it is going to be for his future. So what the course of action the BT should take?
Just now, sir, 1 minute back, I think we were discussing the same thing. In that case, how are we, what are we going to do? Suppose he is making annual payment of, let's say, 20 lakhs. How will you make that 20 lakhs payment? It's not possible, right? So if it is a reasonable one, and that word reasonable is actually missing from the code. It never says that how much. It only says that this is excluded. Now, that reasonability has to come again from the BT. BT has to decide. And now, like we have been taking example of Mr. Ambani. You don't expect him to have a life insurance policy of 1 crore only, right?
Yes, please.
So if I tell him, sir, please take 1 crore only, he'll say, you poor people, don't talk to me. I need at least 100 crores. So how do you take a call? So obviously then again it will become on a case to case basis, kind of debt you have, kind of assets you are getting from the person. There can't be a yardstick here, right? So that is why maybe that is the reason our lawmakers have not put that number also. They have just given a you can call it a freeway or you know a discretionary power to the BT. Yes, if it is too out of the ordinary, let's say, obviously BT has option to either take it to the COC, or if COC is also not in a position to decide, then take it to the adjudicating authority. So let them give a verdict on that. But right now, question raised by you, I don't think it is any straight answer to it. Okay. So ruler means ruler, which is out of, you know, Narega law and all. I don't think this you need to read right now. Uh, this I have already said, right? Most bankrupt owned properties are of much higher values, but they are not only higher value, they are also encumbered also. So any which ways, we are not going to get any dwelling unit out of anywhere. And in fact, even if you get that dwelling unit, you know that either it will be transferred in the spouse name or Sasurji's name or somebody's name, or he'll be a co-partner in the property, or he will be a joint owner only. The second person says, my part is this is only a joint owner. How do you decide that? Now people have started doing one more thing. They have started even in newspaper now it is coming. If any one of you has been attending NCLTs, people are putting in the newspaper that we are disowning our son. We have nothing to do with this because asset is in my name. I will disown the person. He is doing something wrong. Let him suffer it. Obviously, the property is not with you now, right? Because they have disowned the person. What will you do in those cases? Or let's say the house is under tenancy. How the tenancy rights will happen? Whether you will continue paying that kind of rents, or you'll ask him to move from that place, go to some other places. So issues I'm enumerating right now, issues, dear. I'm not able to answer you how we have to deal with that. Reason being, this has to be on case to case basis. It cannot be a one yardstick fits all.
Yeah. One more question. Suppose person debtor is a co-partner of an HUF.
Yes.
He has got the interest in that HUF, and HUF got good properties. There ancestral properties are there.
Yes.
So in that case, as a bankruptcy trustee, how you are going to have an access to his interest in that one?
Absolutely right, sir. I mean, tell me, do we have a right? Can we have a straight away answer here?
That's why my question is because we need to have the answers such type of questions duly regulated in the regulation. Until those things are there, it will be subjective decisions by individual IPs, and it may have a negative repercussions from the A.
Mr. Saraugi, you are absolutely hitting the nail here. Only problem is when you are developing the law, and trust me, I think that is one reason. See, there is no jurisprudence, right now in terms of bankruptcy is there. CIRP, we are running for like 8 years now, correct? We have a jurisprudence which has developed. So slowly, you also know how many changes have happened in our law, right? Every 15 days, there used to be new law. The book which we buy every time that 1,000 rupees goes bad, because there are new amendments coming. Now bankruptcy is not yet touched. Imagine this 75% of COC voting is still there. Nobody has touched it. Reason being, it did not come into picture. It was not touched. So now when bankruptcy cases are coming, they have started admitting. Now and that is why we're discussing also today, right? We did not have this bankruptcy 6 months back. We were not taking these classes. Now we are discussing in a forum so that our regulator IPA is here. I'm sure they are also listening. Whenever they are talking with IBBI, they will also be putting this to right forums, that these are bigger issues. And certainly there is no one answer to it, sir. It has to be right now, it has to be case to case basis. And slowly the jurisprudence will develop, orders will come, uh, dictates will come from NCLTs, and we will learn that, what exactly to be done. I
Right.
hope, right in the beginning, I said, sir, I don't have the right answer because everybody has a view on it.
Now
Right now, we are only talking views.
We are discussing only views at the moment because it's not possible also. That
It's not possible also. You
Yes.
are right. Yep. And these are the excluded debts. Excluded debts are debts which refers to the debt which is not part of either repayment plan or discharge. So they cannot be discharged. Maintenance to be paid to any person. Let's say you have to pay maintenance to your father or your wife or daughter or somebody. It will be there. Liability with respect to a student loan. Now, I would like to ask why this is there, why the student loan liability is excluded.
It's very difficult at the moment. What scenario the lawmaker has envisaged? It's very difficult to.
No, don't you think it's little interesting? Why they are identifying one particular loan?
It's interesting.
No, I have an answer also. That is why I'm asking.
Yeah, please. That will
Otherwise, I'll not stop and ask, right?
Yes, please.
Anybody else? Any thoughts other than Raji?
Yes, sir. There is.
Or financial?
Hello.
Sabir ji. Yes, Sabir ji.
Yes. Actually, in case of educational loans, what the banks take is that is the educational loan is taken jointly in the name of the student borrower as well as the guardian. That is parents or that is the case. Perhaps this is for this reason.
Sir, you are a creditor or you are insolvency professional?
I am an insolvency professional. I was earlier a banker.
You are both. Okay. Any other banker can give me some idea? Banker, when I say financial creditor here, because we have some people. Deepa ji was here, and I think.
Yeah. Sir, I feel that, hello?
Yes, we can hear Shankar.
Yeah, I feel that education is the fundamental right under the constitution. So, and it is, the loan is for the other son. It is not for the individual. So you cannot stop a person from studying just because his father has become bank.
No, who's stopping him? The money has gone, sir.
Yeah, but when the student loan is included in the bankruptcy trust, the next thing bank will do is it will recall the loan, no?
Sir, this is not asset, sir. We are not bringing.
No, I'm telling that if the student loan is included in the bankruptcy trust,
sir, it is not
bank
accounted. That is what I'm telling you. This is not excluded asset. We are calling it excluded debt.
Debt.
What you're saying is, I am getting it, but what the word you're using are not correct, sir. See, we are not bringing it. We are saying that liability will not go off. The money has gone, somebody is studying, maybe you yourself is studying, but that
Yeah, because the
liability
student
to
is
pay
going
the...
to pay it off, no?
Sorry, come again, sir.
The student has the right to pay it off.
Right or liability, sir?
It's liability.
Liability.
So student has the liability to pay off.
Yeah.
And let's say the guarantor himself is a student, then
No, I don't have answer.
no, good, sir. See, we obviously we all don't
Good,
have.
good, good.
Sir. We are just simply discussing. Reason being, we are learning here, right? So liability with respect to a student loan, in my view, okay. If anybody has any view, then please say. Otherwise, I'll throw my view.
Somebody has given comment on this.
In chat.
No. Chat. That's the answer is no. Okay.
Amrish Chaurasia ji doesn't want to talk. He is writing, I think. It is otherwise paid by the student. So there are many things which can be paid otherwise by somebody, right? So
I think you can give your observation on this matter and we can continue.
I think this, see.
Sir, I have a view. Actually,
Yes.
student loan itself is unsecured loan. That's why.
Student loan is an unsecured loan.
I think so.
Not necessarily, ma'am.
Okay.
Yes, at times you're right. At times these are unsecured, but that's why I said let the bankers, they can give some idea what
And
can.
it's, there are few riders to the sanction of the student loans. As and when the student loan is taken by the dad, there is a moratorium which has been implied on the student loan, and in
Yes,
future
sir.
when it is a qualitative or some competitive exams which he has qualified for, and being a professional, when he starts earning, he will be repaying the same. So for that is the reason when the father is applying for the student loan for a kid, there is a moratorium which is implied. So that is why I think this has been excluded at present, and the later on be paid by the student upon he starts earning from his profession also. One thing is that if the question is coming that whether the guarantor himself is a student and he has taken the loan, then also again we have to read the riders under the sanction of the student loan wherein there was a moratorium being given or not. And definitely it's a waiver under right to education and the other things. I don't think it needs to be paid, and it has to be excluded.
While giving the education loan, the bank also getting the property mortgage of that particular parents or the guardian, and while giving the monitoring period, they're supposed to pay the interest amount which is supposed to be paid by the parent or the guardian. So that is the question where the interest amount should be paid from this that considered as a debt or what.
Sir, right now you are explaining what is student loan. Our question is why this liability is not waiving off. Everything else is waived off, right? All his liabilities. He is giving a scot-free card after 1 year. You are bankrupt, you live your life how you want to live. Correct? Only the student loan is excluded. I think, okay, let me try to say what I think, okay? See, student loan normally you take it when you are pretty young, right? Hopefully, right? If this student loan part is also allowed to be finished under the under this regime, now what will happen? Every student will come out of the college who is not getting, let's say, a job, will file for bankruptcy. Will file for bankruptcy, and within 1 year he'll go scot-free. And obviously, full life is ahead of you. You can, what's wrong in you starting the life again? So student loan is one loan which you have taken because right now you are at a stage where your entire life is ahead of you. Why you want that liability also to go away? That liability let you pay whenever it is accrued, and it's up to you. Otherwise, sir, And as a student, you don't have any social big standing, right? Who cares whether you are getting, able to enter into an agreement, enter into a contract, or you have any big properties also with you? Nothing, right? You will say, I'm a student, I don't have any money, I'm filing for my bankruptcy. First, you'll file insolvency, then bankruptcy. Nothing doing, right? Your liability could be over if it was not mentioned here. So student loan, in my view, they are not allowing to let it go because your entire life is ahead of you. You should not take undue advantage of a law which is made for some genuine failures or from somebody who is already, see, how many promoters and guarantors you know which are in the age group of 20 and 30s? Most of us, we are talking about promoters who have, at the fag end of their, you know, working life. We are talking about those. So, but student loan, I think this is the reason we are not allowing. Student loan liability will remain intact even after all this process. That's all from my side. Also, damages for any negligence, breach of statutory obligation, that is also not done away. Let's say court has said you have to pay 10 lakh rupees, that liability also doesn't go away. Any fine imposed by court or tribunal, any other debt, but there is no prescription as yet. Okay. What slide number we are at? 23. I have half an hour. Okay, let me try and cross till 178. So 150, we have covered till exclusive debt. Okay. So 158 is restriction on the disposition of property. Now comes the part where our creditors are superbly interested. Okay, let us see this. There is a restriction on disposition. Disposition means selling and letting go away of the property. Now, this will be void if it is between the bankruptcy application filing date till BCD. If any transaction has happened between that, it will be filed as, can be declared void. It cannot be declared void unless it is, full money has been received. It was entered in good faith and, without any notice, etc. Then we cannot get it. But otherwise, this can be declared void. So between when the interim moratorium has happened till BCD, during interim moratorium, it should not have been disposed. 159 says any after acquired property, that is any property acquired or developed after BCD till discharge. So during that 1 year, if the BT comes to know that this person has bought some property somewhere, that property will come back to my estate. As a BT, you have the power to get it back to your estate because he has acquired it during that period, which people are smart enough not to do that. But if somebody is doing that, you have powers to get it back. That is called after acquired property. And now see this after acquired property, I'm sure you will not get to know within 1 year, right? Nobody is stupid enough. You might get to know about this after 2 years or maybe 3 years. Suppose you are still bankruptcy trustee in that meantime, you can get it back to you. That is where this section will actually have its impact. Nobody will tell you within that 1 year that, we have acquired this property. But yes, if it comes to your knowledge, within 15 days, apply to the NCLT, asking them to devalve it into your estate. Also, any onerous property is any unprofitable contract, right? I'm getting a benefit of 2 lakh rupees and I'm paying 2.5 lakh rupees for the same. Doesn't make sense. Any unsaleable or any not readily sellable property, or let's say I'm supposed to get 200 rupees somewhere. But to get that 200 rupees, I have to spend 1000 rupees. So that becomes an onerous property, right? What is the fun in getting that? So we can we can declare that this is onerous property. We don't want it. Somebody wants it, please take it. We are telling you, you keep it. So that is called onerous property under section 160. We can give that with the permission of COC. As a bankruptcy trustee, you can do that. 61, 62, 63 talks about how do you give the notice of disclaim, what will happen to the disclaimer of leasehold, and who can challenge against this also. There might be some people who will say, no, this should not have happened. You should have continued. How can you leave it? All that challenge will come. Now comes the good part, okay? The undervalued transactions. How what we learned in 43, 44, 50, and 66 is here. Section 166 is the undervalued transactions. Undervalued transactions during the 2-year preceding filing of bankruptcy application. So 2 years. Any transaction with associate preceding 2 years is deemed undervalued. Now this is a funny part. Nowhere we says that it is deemed undervalued. But in bankruptcy, if it is with an associate, and associate is your family member, father, mother, parents, like that, right? So any transaction with associate, if it is within 2 years, it is any which way is deemed undervalued, even if it is at par with the market value. It is deemed undervalue, you take it back. I hope this point is clear. This is an important point. Deemed undervalued, already deemed. It is, you don't have to prove it in a big way. It is deemed. And this, because of this transactions, we should have a reason that because of this transaction, bankruptcy has triggered because of this process. Also, it is undervalued transaction if it is given to any person as a gift, no money has been received, or in consideration of marriage, or it is significantly lower in value than the market value. And obviously significantly doesn't have a number normally, but 25-30% lower is significantly lower. Right? So undervalued transaction in
Can I put a question here?
Yes, please.
Suppose there is an undervalued transaction of 2 crore property, it is sold on the 1 crore. Now, you want to take back as a BT that property. In that case, the earlier transaction is cancelled. So you need to pay a 1 crore rupee to the
buyer.
So in that case, since 1 crore rupee which was taken by
is already
has already gone.
Correct.
You don't have the money.
Correct, sir.
So in that case, how the process is to be taken further?
So that 2 crore rupee, when you're taking over, this transaction is void any which ways, right? So out of the proceeds which you will receive, you will sell it again.
Yes.
Out of that proceeds, you will give to this person his share. If it was let's say, if that money was there, either you return it first of all. If that is not there, you sell the property, you give that money to the person who bought it.
Okay. Now I'm giving you a situation. Suppose the properties was of 2 crore. It was sold in 2 crore, but the recorded transaction is 1 crore.
But the
recorded transaction is 1 crore.
So how do you know it was sold for 2 crores?
The buyer is claiming that I have paid 1 crore rupees extra.
No, claim has to be proved, right?
So this is the practical difficulties. It may come. He will say that I have.
Sir, everybody will say I have paid the cash.
Yes.
How will you accept that?
Yes.
Who will say they have not paid the full money? Tell me.
Everybody
will say that, right? So record says 1 crore, it is 1 crore. Simple.
Okay. Got it.
That is how black money will go from our market, right? When we start catching such things, right? So hopefully things will now, get into cleaner side. That even after you have taken it, even after you have registered it, somebody, some bankruptcy trustee might come after 5 years saying that 2 years, sorry, that you have done it wrong, give it back to me because you took it at half the price. So that is why better to go on to the check part, okay, always. We'll move on, sir. So 164 was under value, 165 is preferential transaction. Preferential transaction is you have given preference to one person or one creditor, right? So during 6 months preceding filing of bankruptcy application with unrelated and 2 years with associates. That is a preferential transaction. And because of that preferential transaction, bankruptcy should have been triggered. Now, any person who's a creditor or surety, might be included if that transaction puts the person in a better position, otherwise in the distribution of estate. Right? What is the waterfall mechanism in bankruptcy trustee? Which section? Anyone remember? Anyone remember?
Next section, maybe I don't know.
No worries. Don't remember right now. Just like 53, you have to come to, I'll show you.
Same way.
Yeah.
53.
Sorry?
Is it in same way?
Same. Exactly same.
Okay.
Exactly like 50.
Suppose in a situation.
Section 178, sir.
Okay.
Yeah.
Suppose in a situation, a debtor has sold the property, or it is repaid the money in preference prior to start of the insolvency resolution of guarantor. Now it has crossed admission and process, IP process. It took around 2.5 years and 3 years or 4 years. After that, bankruptcy process is triggered. Now, this preference transaction, how debt is to be taken? Because that transaction will be out of the bankruptcy preference transaction in that case.
I hope others are also listening attentively. I think this is a pretty important reason, good question, I should say. See, this 2 years, 1 year, 6 months, they were carved out by the lawmakers, assuming something, correct? They assume that when it goes to NCLT, they will take 14 days to admit. Sir, if it is 14 days to admit, then you are telling me 2 years is fine. Perfect, no problem. But if that admission itself takes 2 years, then what is the meaning of 2 years here, right? So, I mean, I hope you got my answer. There is
I know there is no answer at all.
It should not have happened.
The lawmaker has to revisit these points.
Should be revisited, sir. Because this 2 year is based on the fact that lawmaker assumed 14 days it will be done. If not 14, 15, 20, right? They never assume that it will take 3 years or 2 years. Because if it takes 3 years, then what is the significance of this 6 months? The 6 months is waste.
These provisions are redundant in the present circumstances.
Absolutely.
The admission which is being done in bankruptcy after the insolvency IRP process.
Correct, sir. So you rightly use the word redundant. At times these does sound redundant, but that's how the law stands today, sir. I think we do need to revisit these timelines. So if time has taken during this course, then this should be extended. I think instead of saying from B, C, D, they should say it should be, prior to that kind of. So luckily in preferential, they say from the application, but they do not assume that, the personal insolvency itself can run for 2 years and 3 years, right? So then what would have happened? We don't know. Though it is assumed that even in personal insolvency, there was a moratorium. So the person must not have done something, here and there.
No moratorium. In my illustration, I have taken that part because in moratorium it was not done. It was done prior to IRP, to 6 months back or 2 years back, in prior to IRP process.
Correct.
Immediately after the IRP process, the bankruptcy process is triggered. So it will not come in that one.
Yeah, so 6 months will certainly not come in that month. 2 years might still come.
But in that case, at that moment, there was moratorium.
It happens. I think at times these timelines sound redundant when the process unnecessarily take time. Sir, see, they give you 3 days, 5 days, in fact, I'm sure every one of us has done some CIRP assignment. They'd say 48 hours you have to circulate the minutes, isn't it? When you're talking in hours, that means the law was designed in a way that it should not take this much time. If it is taking this much time, something has to be corrected somewhere. Or if it is not possible to correct that part, then let's correct this 2 year, make it 4 years or 5 years, something like that. And then we will do it.
Yeah, please continue. We
So 164.
I have one thing. I think the bigger question is how to find out undervalue transaction for an individual.
Undervalue is easier, sir. What is
No,
problem?
you don't know what is his assets actually, no, because all the assets will be encumbered. Unencumbered assets, you only have to admit, no.
Absolutely, sir. So you are right. So his balance sheet, his ITRs you have to take. He has to give you what he filed that time. His TDS returns must be there. With the PAN card, you should be able to get, what transactions he entered into. So knowing what is undervalued is easier. But how to identify it, that where is the transaction, where it has gone is a tough task, sir. Yes.
And I think knowing undervalue will also be difficult because less than 50 lakhs, if he sells the property,
Correct.
then there is no TDS also.
That is another issue.
Yeah.
Yes, absolutely right. Below 50, that 1%, 26 QB also is not gone. And and bank statements, I'm sure he'll not show you because, all that things will happen. You will, and even if that money comes, it will come in like tranches. So 10 lakhs, 5 lakhs, something like that. So, I mean, we have to do a lot of forensic audit in that, how that money has come, where it has come. I'm saying there are difficulties, but it can't be done. It's not that. Only problem is who will put good money after bad money. So our creditors, are the bankers, are they willing to put good money after bad money? They will say, okay, you put it. If something comes out of the transaction, you spend it. If nothing is coming out of transaction, sir, we all have experiences, right? How RP's fees is also not coming on time. So how do you expect BT to put all these efforts, put all the new team on this and unearth all these transactions? So it might be a challenge, yes. So 164 undervalue, 165 preferential transaction, 167 is extortionate. Extortionate is like extortion, right? You have you have taken loan on 40% per annum interest or 60% per annum interest. So those are extortionate credit transaction. You can skip those. Now transaction and the time period is 2 years for that. Obligation, any party can apply for discharging obligation. Demand damages, which can also be, those demand can also become bankruptcy debt. So every contract, if you see any government contract also, they write that if the person become insolvent, we are not supposed to do our part of it. We can come out of this contract, which is taken care of here. 169 section says the continuation of proceedings on the death also. So, and the proceeding shall continue as if the person is alive. For us, he is not dead. Only difference what will happen is administration of the estate of the deceased person, the funeral and testamentary expenses will need to be paid, which are pari passu with the secured creditor. So you have to pay right at the top. Mutual credit and set off is permitted here. Also, under section 140, 174, 75, 76. So you pay interim dividend. Let's say there is a lot of money left, right? You will say, okay, I'm giving first interim dividend. Give some money to people so that they are at least something has come. So they are happy. Then 75 says distribution of property. It can be done from the property in existing form. Let's say that house is not, you're not able to sell that house ever. And and you're able to give one of the creditors says, okay, I'm ready to take it as it is. I'm ready to give 20 lakhs, 5 lakh, 10 lakh, whatever. And COC accept, you can give it in the same way also. It doesn't have to be the hard cash only, hard money only. And last is 176 final dividend. After realizing entire estate, as much as it could be realized, you give a final notice for dividend on a particular date. Obviously, BT has to ensure that, enough money is left for the process to run. 78 is that priority of payments are cost and expenses of BT in full, secured creditors and workmen for 24 months, employee for 12 months. Fourth is government dues for last 2 years. And fifth is all unsecured debt. And if any surplus left, then you give it to the bankrupt also. Okay. Last chapter, we have 10 minutes. If there is no question, then maybe we can just cover it up quickly. So give me 5 minutes, I think we'll finish it up and then any questions. So what happens if this person is not giving you information? If false information to resolution professional is given. And normally this covers the CIRP part also. Okay, so just covering that. If there is false information given to RP by the creditor or debtor. So creditor also, if you're filing form CA and C and D and wrongly, and there is penalty, there penalty of imprisonment of 1 year or fine up to 5 lakh or both. And imprisonment of up to 2 years for creditor and fine up to, sorry, it was debtor. So normally it is 1 year imprisonment, 5 lakh penalty or both.
These provisions is common to all chapters.
It's common too. So that is why it's a separate chapter,
Yeah,
chapter 7, offenses and penalties. But for bankrupt, it's little detailed. That is why I'll come to that. If contravention is done by IP, insolvency professional deliberately, then imprisonment of 6 months and 1 to 5 lakh fine is also there. 1 is minimum fine, 5 is maximum fine, and 6 months you can be inside also with Kejriwalji. 186 is false information, concealment by the bankrupt. So this is a separate section itself. If the bankrupt is giving you incorrect information, right, which we assume that they will not give us complete information. So when they are giving false or concealing any information. So if knowingly conceal, omit, wrongly represent, then imprisonment of 6 months and fine up to 5 lakh or both. And this includes non-disclosure of details of the disposal of any property which would have been part of BT estate. So if they're not telling you and you're able to identify somehow, then there is a severe penalty. Then 6 months at least you can put them and 5 months fine also. If they fraudulently withheld or destroyed or falsified. So, whenever you go and take over the books, they will burn it, which is happening in many CIRP cases also. They burn down the godown. They'll say now no books is available. So if they fraudulently does this, then there is an imprisonment of up to 1 year or 5 lakh or both. So 1 year and 5 lakh is normally common in most of the stages. If contravene restrictions or disqualification of section 140, 141, then 6 months or 5 lakh. If they don't deliver the property to you, which is under your control, they are saying, I'm not allowing you access, then 6 months or 5 lakh or both. Like in 19.2, right? There is only direction. Here, if the bankrupt is not giving, then you have a straight away apply under 186, ask for 6 months imprisonment of the person so that he allows you the access to the property. This is like taking physical possession instead of symbolic, right? If 12 months before filing, he made substantial loss, let's say deliberately they have made that loss, then up to 2 years of imprisonment and 3 times the loss value. Or if the loss value you are not able to determine exactly, then minimum, then 5 lakh also can be put. Wrong actions by BT, obviously, bankruptcy trustee, the name itself is trustee. So if trustee is doing something wrong, because bankruptcy trustee has lot of powers, he might have a lot of money also from the personal guarantor. So if this person is doing something hanky-panky, imprisonment up to 3 years, nowhere else it is 3 years. Only the bankruptcy trustee can go for 3 years. Or fine of 3 times or 5 lakh, as we say. So as bankruptcy trustee, I'm again reminding you, please be very careful. RP will only go for 6 months. But bankruptcy trustee can go for 3 years also. So be careful. And enough for today. Any question we have? Some chats are there. Let me see. Harmeet ji saying, can we take a break? Harmeet ji, another 3 minutes and we are all on break. I guess I have come to the conclusion of my PPT part. If no other comments, then we can close it here. Anjali ji, we are done for the day. Thanks ICSI for inviting, and I hope we have done some justice today. Anjali ji, it's concluded from my side. Anjali ji has gone, I think. Sir, you are mute. Raj Kamal ji, you are mute.
Yeah, actually the time is up to 5:30, so she will come back at 5:15.
Hey, I thought it's 5 o'clock. My mistake, sir. Sorry. Okay, if it is 5:30, then let's discuss. I mean, nothing wrong. Any comments or any suggestions? I mean, instead of let's say, what do you think? How the bankruptcy trustee needs to go about? What are the avenues? Devangji, I would like to hear, that side of the story. How do you expect a bankruptcy trustee to do? What do you expect them to do?
So far, like from our side, we are not able to comment on anything. Like from my side, because the reason is we are yet to enter first of all into the personal insolvencies, get the matters being admitted slowly, then go forward and then see till reach till the BT. So for now, I don't have any comments. But definitely going forward, if it is going to be the way the presentation was and the things, it will be definitely beneficial. But the very first part of the entire session, since morning, was like if I think on from a perspective of an RP who has to like as the duties cast upon him and what he has to do, that is the presentation was too good, sir. But from the perspective of the secured creditor, at present, this is not going right in our favor at present. Let's see if you good results coming up, then see that how the bench is like we're getting the orders and then how we are moving ahead.
I agree with you, sir. Only thing you're not considering, let me put it here. See, you are ARC, right? You
Yep.
have taken over those loan must be at a very good price also, right? Let's put it that way. Uh, some bank had given 100 crores, you have taken it on say 50 crores, right? Now you want as soon as possible because your mandate is accordingly, right?
Yes, sir. Yes,
And
sir.
as far as your thing is concerned, see,
Hmm.
if it is a single car, you have exclusive charge.
Yes.
You also know Surface is a better option for you.
Hmm.
Right? Everybody knows that. Your
Yep.
problem comes when there are 2 people and 3 people. Any which ways you are part of the pool. You have second charge, you have third charge, you have unsecured charge. In that
See,
case,
let me, sir,
uh,
let me put it this way.
uh,
Giving across one example also, and let
yes,
me tell you that today my team, we are approximately 15 people in this session out of this 55, 60 people.
nice. Okay.
So from my team it is there, and I'll give you an example of one case wherein at the very verge of taking over all the secured asset of the debtor through DRT and under surface and all. One fine day in the morning, before going for the positions, we receive an application and letter from a debtor which we even don't know that he is, that I have already filed in 95 and then there is an interim moratorium and you cannot move it. Like, this was surprising. We were not knowing without even producing any documents or anything. And after a delay of around 1.5 year, NCLT rejects his application due to the non-removal of objections and all. And after that, we were able to. So the point is, sir, that at the filing of this application, the interim moratorium starts without even going into the merits, looking into the papers, that what is then even the dues or like liability is not established, nothing is happening, and the blanket interim moratorium is given. Now, sir, we are very much hurt from this. So,
Uh,
if at all it starts after the admission, we can still understand, sir. But at this point, though,
I want to concur with your thoughts, sir.
yep.
But just to give you a little respite,
Hmm.
that part is taken care of. That even if defects are not removed,
Hmm.
please do not assume it is admitted. Interim moratorium does not start from that.
सर बेसिकली होता क्या है मैं आपको बताता हूँ सर मेरे हाथ में 5 साल रहते हैं सर initially 5 years being an ARC of which first year goes in settlement talks with him taking the action and all another 1.5 year goes for this entire process getting it admitted so what remains so for that is the major concern apart from that sir the all the two processes bankruptcy and even the insolvency if the process is followed after an admission the way it is shown and it has been presented it definitely very much beneficial to the secured creditor. I'm not denying that, sir. But let's see, sir. Let's hope for the best how it comes.
I agree that for you every day counts. So I
Actually,
understand that is why, as you rightly said, you have 15 people here to understand what exactly is going on.
because
So
we have been doing this, sir, continuously, day in, day out.
I think a representation should be made to the lawmaker that the moratorium should start with the order of section 97, not before that. So that will take care automatically, like in CRP, it is on the
saying
date of admission
97
of
or
the
100, sir?
yeah.
You're saying 100 or 97?
97 is given to the it is given to the RP for the report and all those things are there. So at that moment of time, it is reasonable to start the moratorium. That's the interim moratorium start from there, and the normal moratorium should start at section after admission of section 100.
Sir, Kamalji, just to apprise you, 97 order comes pretty early, sir. So if the moment this is declared, what you call
Yes.
defects are removed, straight away they do not waste time in that. They'll say, okay, RP is there, have you proposed? Fine, okay, give notices. So that does not take time. Problem is after his report,
Yes,
then
it
it
takes
takes time because then the person comes and contest it.
Yes.
And contesting in our law, we know
And
what.
in between the Supreme Court matter was there, so it took extraordinary delay The experience last 2 years. It is.
They were only giving dates, right? They never
Yes.
took a call because it doesn't actually make sense also if
Yeah, yeah.
somebody tells something. There were
Yes.
382 applications combined. Even Supreme Court said that, okay, let everybody come in one line. We will say in one go. It's a long order. I'm sure every one of us
Yes,
must
yes.
have learned what Justice Chandrachud dictated. Like he actually took 2 days to dictate that, right, in the open court.
Yes, yes.
I think it was a pretty good.
I witnessed that dictation.
Yes, sir. So it was a good decision, we believe. Uh, Looking at Mr. Devang's, contention, he is also right. Sir, Devang, sir, I'm assuming you are a very good ARC that you might be taking assets which are exclusively held to you or hypothecated to you.
So
But any
holding DRT decree of 100 crore, assets worth 100 crore, and stuck due to 95. Now you can understand my situation, sir. And not one account,
that is
many.
why it is hurting more because you had a chance. You said, okay, this is the, year end, it'll add into the kitty pretty well. But obviously they also tried. But sir, trust me, it's a very good law when there is multitude of claims, or when you have first charge, second charge, pari passu charge, all that issues. In that case, you will find that insolvency is a better resolution mechanism than any place else. And here, only problem I feel, sir, in insolvency, that timelines are not being met. If those timelines are being met, then it's an amazing law to resolve things. Uh, on paper, we
this is
call it, it's not a recovery mechanism. We all know it is a cleaning mechanism. Uh, let's stick to the timelines if possible. But we advocates only does, all that stuff. I know that. So, but yes, sir, that is happening.
It's very easy to say, it's very difficult to implement.
It is very difficult to implement, no doubt.
So this is Paresh from Pegasus ARC. I just have one question relates with the whether the borrower is going for the section 94. So can we declare him as a willful defaulter as we already have the his loan background as he's making delay payment for the loans?
Sir, willful defaulter has nothing to do with going for 94. You can declare as per your rules. What stops you?
So is that make any difference while he is going to file the application under section 94?
Sir, 94 is filed by defaulters only.
Whether it will impact for that
No,
particular
there is
process.
no impact. What impact? So what impact do you want to happen? You want to reject it then and there, go for bankruptcy straight away. Is that?
Not like that, sir. While going for the section 94 by the borrower, what he expecting that he is expecting some kind of a time and some kind of a resolution plan from the RP. Okay, so if he already have the making the so much default for the payment, he is already having the willful default and he's having we just make the asset tracing for that particular borrower. So is that make any impact for the section 94 application for the RP resolution plan?
Sir, I'm asking you, what impact do you want?
I think what Paresh wants to say is that declaring this guarantors as a willful defaulter, so something would be an added tool to the entire process. Like if there is a few assets which have, like monies, you have been cited somewhere else, made properties in some other family member's name, even after declaring an account NPA, he has like put aside the money somewhere else and placed the money. So for that reason, if he declare him an a willful defaulter out of the regular practice, will it be added advantage within this act or not? That is what he wants to
Advantage is only to admit the application bit early. So
say.
maybe you will save a date or so.
ठीक है.
Other than that, what advantage you will get? So either the application is admitted or not admitted. If not admitted, bankruptcy. If admitted, then let the process run. So otherwise, there is no one very good point I think I am taking away because my bankruptcy is getting admitted on 3rd of May. With the order, I'll ask the my lords to attach the passport also. At least keep the passport with the RP so that this person doesn't fly away.
So in that case, if you don't do that, there is what is the point of asking for a permission to fly abroad? He's holding a passport, he will definitely go. Why will he wait for you?
I know, sir. So that's what I'm saying. It's a pretty good takeaway for me also. I'm sure.
सर मॉर्निंग में क्वेश्चन अराइज हुआ था कि कॉर्पोरेट गारंटर अगर है उसकी डेथ हो गई है तो उसके लीगल हायर्स को मतलब इंक्लूड कर सकते हैं उसमें, तो मेंटलिटी पे क्वेश्चन उठा था। तो मेरा ये क्वेश्चन है सर कि कुछ जजमेंट्स हैं सुप्रीम कोर्ट हाई कोर्ट की, उसमें ये बोला है कि अगर लीगल हायर्स को कुछ एसेट्स मिलता है तो उसको लाइबिलिटी भी उतनी ही होगी। तो इन केस अगर अगर गारंटर जो है उसकी एसेट्स उसको मिली नहीं तो वो मेंटल कहाँ से होगी सर?
आई थिंक आपने सुबह भी ये पूछा था ये क्वेश्चन, राइट?
श्योर ने था, मैं अभी क्लियर कर रहा हूँ, मेरे को ये क्वेश्चन था कि मैं क्लियर करूँ।
जी 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 सर, मेरे इन माय पर्सनल व्यू आई थिंक वो मेंटेनेबल नहीं होता है, बिकॉज यू गेट लायबिलिटीज व्हेन यू गेट एसेट्स। Just because you are son of somebody, and see, it's called personal liability, right? Personal guarantor. Personal means person is the guarantor, the human being. अब वो बंदा ही नहीं रहा, what will you do? What kind of guarantee are we expecting?
Can I give my input? This is my
Please,
simple
sir.
mind
Please, sir.
only.
We are waiting for.
Yeah. Suppose a person has died, so his estate will be liable for the.
Absolutely right.
Number one. Number two, since the legal heirs are getting their estate, to that extent, any liability is to be paid out of that estate only. But still, that legal heir might have other his own earned assets. I don't think that will be liable for the payment.
Right, sir, not maintainable.
I think we have same opinion.
Hello, sir. May I add something?
Yeah, yes, please.
Yes. I think Section 95 application is not maintainable against the survivors of the personal guarantor, because if it is a resolution process, it is not a recovery process. The creditors can adopt some other measures for recovery of their debt, but I think Section 95, which is for resolution of the personal guarantor, it is not maintainable.
So in
actually,
that
there are two judgments, one of NCLT Kolkata bench and another of NCLT Delhi bench. They have rejected this Section 95 application on the basis of the death of the personal guarantor.
So in that case, the state by bankruptcy process can start.
That is different. But that is one thing is, it is not a recovery process.
Yes, yes. Resolution is not possible since the borrower is not there.
Borrower is not there.
Yeah, I also feel the same way.
And that is why in bankruptcy, it is clearly mentioned how the deceased estate will be treated.
Yes, there 167. Yes, Section 167 is there.
167 says, as if he was alive, we are considering it. For personal insolvency, I am of the same opinion, sir. But in law, everybody has their own opinion. Because NCLAT, if everybody believes their opinion, then why do we need NCLAT? And if everybody believes NCLAT, then why do we need Supreme Court? So everybody has their own opinion and nobody is right or wrong. Currently, my view also stands with that if the person has gone, if his estate is left, please follow that up and you can get it back. If nothing is left, let the Divangat Atma go away and forget it.
सर जैसे 138 एक क्रिमिनल प्रोसीडिंग है, अगर डायरेक्टर ने कुछ चेक इशू किया है तो मतलब जब वो कंपनी में था तो वो लायबल रहेगा। सुप्रीम कोर्ट की जजमेंट है, मार्च 2023 में आया था। वैसे ही जो अभी दिवांग सर ने क्वेश्चन पूछा कि वो फ्लाई कर जाएगा, तो इसमें ईओडब्ल्यू भी एक क्रिमिनल प्रोसीडिंग है। अगर मैं आईओ को एक एप्लीकेशन देता हूँ कि इसमें कुछ इसने फ्रॉड किया है या कुछ ऐसा कुछ कर रहा है, तो आईओ के पास तो सर पावर है, वो उसके केवाईसी से पासपोर्ट की डॉक्यूमेंट्स निकला के और एयरपोर्ट अथॉरिटी को एप्लीकेशन दे सकता है।
सर कितने आईओ ये करते हैं?
सर हमने एक करा था बैंक में, लेकिन एक्चुअली हमारे पास नॉर्मली छोटे लोन्स में क्या होता है, पासपोर्ट की कॉपीज नहीं लेते हैं वो लोग। अगर बड़े लोन है तो 10 करोड़, 20 करोड़, 50 करोड़, तो उसमें वो पासपोर्ट की भी लेते हैं। तो अगर मेरे पास कॉपी है तो फिर मैं एप्लीकेशन दे सकता हूँ, क्योंकि मेरे पास रिप्लाई आया था एयरपोर्ट अथॉरिटी का, जिसमें उसने बोला कि सर हम आपके पास अगर पासपोर्ट की कॉपी है तो आप मुझे दे दो।
आप
मैं
एलओसी
इसको एक बार
आप एलओसी इशू कर सकते हैं, राइट?
हाँ, हाँ वो डायरेक्टली कर सकता है। एयरपोर्ट
बट
अथॉरिटी उसके लिए
बट
पासपोर्ट की कॉपी मांग।
जस्ट फॉर माय अंडरस्टैंडिंग सुरेंद्र जी, एआरसीज भी कर सकती हैं एलओसी, या ओनली बैंकर्स और
नहीं,
लाइक?
हम भी Pegasus भी कर सकते हैं सर। मैं Pegasus पे
अच्छा, ओके ओके।
हम बिल्कुल करते हैं सर. We are definitely doing it. Even in OAs, we are filing an attachment of impounding passports and other assets and everything. But unfortunately, due to this code, we are stuck. Yeah.
नो सर, इन दिस केस आई होप यहाँ पे 15-20 आईपी तो होंगे ही. सो इफ वी आर गोइंग फॉर bankruptcy, I think this we should ensure that we will ask for passport to keep at least some deterrent is there कि भाई otherwise this person will come after 1 year, मैं तो यही था जी, साबित कर लो. How do you get into proving all that? So better is keep at least some way somewhere he will come to you and talk. So good takeaway for me. And I guess that's where we are. But insolvency is going on in full swing, Devanji. So I'm sure you are also aware. Insolvency proceedings. Uh, they send me a mail once. In one of my case, I asked that please submit the repayment plan, and they sent a mail saying we are preferring an appeal. Now, what does this mean? This means they are not submitting the repayment plan.
Okay.
And
बराबर.
correct. So I went to NCLT, sir. They are not willing to submit and they are now going for appeal. Kindly treat it as closed. There is no repayment plan. Obviously, NCLT closed it, allowed us to file bankruptcy.
बराबर.
They are saying we never said that we are not submitting repayment plan. RP has wrongly assumed that we are not willing to submit the repayment plan. We only said we are preferring an appeal. Now, these kind of things are going on for 3 years now. So we have lived that
तो
life, sir.
बात यही है ना सर, सुबह से वही तो बात कर रहे हैं.
We are living that life, sir. We are in and out living that life. But that's how we are in India. So we have to follow law.
Devvrat, can I put my opinion here?
Yes, sir, please.
Suppose the debtor has given you a RP that we are preferring appeal. I am not going to give the repayment plan. Then in that case, RP should give him reply that till we get the stay order from the enclave, we are not stopping the process. So if you are not able to, you are not giving the repayment plan, in that case, we are going with our compliances and we are reporting according to the NCLT. And that's all. That is what it is being communicated. And after that, let NCLT take a call.
सर यही तो किया होगा ना, आपको क्या लगता है? यही किया. So I sent the same mail. I said, fine, sir, we'll file my report accordingly. That's all. And on this, they are now challenging. And imagine now, after 2 years, they are saying we are ready to give the repayment plan.
So
and court is saying, why don't you take it? And I'm saying I am already discharged. In what capacity should I accept it?
Let him approach NCLT again and let the admin process be revived.
Under what section, sir?
So let NCLT use the rule 11, or they let them file the 94 again. Let them get the liberty of filing the.
Where do we have an option of filing 94 again? 95 it was.
Let the NCLT take it.
So it has to be some innovation, right?
Yes.
And that's why I said this case 4 times order reserved and opened, because all that innovation is going on. We are trying to find some.
Let the enclave put their decision in this matter.
Sir, they went to Enclave rejected it. Enclave Chennai, we fought for 7 hearings. Sirsha Marlaji was there, nothing happened. It was rejected, their appeal. Now bankruptcy trustees should start, and I have told them same like in liquidation, give me repayment plan. If creditors accept it, I will come back for withdrawal under 142. If not, then I'm your estate manager. I will take over your property.
Okay, you are BT in that case.
I was RP and now I'm proposed BT in that.
Okay.
So
That's
I'm
all
saying
right.
proposed because it's not yet
I think
admitted.
it's all right. It's all right.
Sir, हमें तो all right लगता है. Problem is when they get their senior advocates and also judges भी नहीं सुनते हैं कभी-कभी हमारी. So that's
वो
what
तो
is
ठीक बात
happening.
है। नहीं, आपकी क्या हमारी मतलब आप हमारे लिए भी साथ में ही बोल रहे हो, एक ही बात है।
हाँ सर, हमारी मतलब हम भी RP. When I reach there, I'm BT. I'm an RP, right? I'm not an
Yes.
advocate at that time. But yes, that's how the law is.
चलिए,
So
I think
अंजलि जी आ
दीपा
जाइए. I
मूर्ति,
think.
सर
दीपा
मेरी एक
मूर्ति।
क्वेरी है.
Yes, दीपा जी. Finally you are here. Good.
नहीं सर, मैं सब सुन रही थी. मेरी क्वेरी अभी भी रिजॉल्व नहीं हुई, तो मैं खुद ही सोच रही थी क्या कर सकते हैं. सर एक सिंपल सी क्वेरी थी. मैंने आपसे कहा था कि हमने 2010 का एनपीए 2012 में उसने बेच दिया किसी फैमिली मेंबर को या रिलेटिव को, जो भी है.
जी.
सो नाउ वी हैव वन मोर थिंग कि वी कैन गो एंड जब हमें पता चलता है वो सेल हुआ है, फॉर सेटिंग असाइड दैट ट्रांजैक्शन, राइट?
Correct.
नाउ that transaction I can do it under in civil court, setting aside वाला डिक्लेरेशन सूट वगैरह.
Declaration of suit, हाँ.
अब लेकिन अब बैंकरप्सी केस में आप सिर्फ 2 ही साल ले रहे हैं, उसके बाद तो उसको 1 साल बाद डिस्चार्ज मिल गया. मेरा सिविल सूट तो सालों साल चल सकता है. सो डू I have the right even after the completion of the bankruptcy proceedings to proceed with that?
मैम वो ना वो जो बोलते हैं ना रेजुडिकाटा में आ जाएगा कि इट इज ऑलरेडी डिसाइडेड. व्हाई आर दे नाउ कमिंग टू सिविल कोर्ट्स? सो राइट नाउ जो आप बोल रहे हैं इज लिटिल टू अर्ली फॉर मी टू कमेंट, बिकॉज फॉर मी आई कैनॉट गो 8 years and 10 years. So these it never talks about fraudulent going back. See, in section 66 there is no time limit in CIRP. You can go 5 years, 7 years, right? But in personal or bankruptcy, it does not talk about that. It only talks about 2 years. Right
सर 2
now,
साल तो बहुत कम है ना.
मतलब
For
अगर
these
14 दिन
personal
में
guarantors,
मैम
sir,
अगर 14 days में एडमिट हो जाता तो 2 साल कम नहीं थे. बट यस, अब बहुत कम है सर. अब तो मतलब मुझे लगता है इट्स रिडंडेंट. एंड योर आंसर ऑल्सो इन माई व्यू, इफ टुडे यू विल आस्क मी, CPC में वैसे भी वो केस लेने में इंटरेस्टेड नहीं रहते हैं. सो द मोमेंट दे विल फील एन आउट वे नॉट टू टेक योर एप्लीकेशन, they will not take your application. They'll say this is already decided. Fate accompli बोलते हैं हम इसको. तो
once a person is discharged from the bankruptcy, after that any case prior to that, it's very difficult to get revived. Until it goes to the Supreme Court and Supreme Court sees the situation and they give their own
सर
judgment.
वहां तक तो अपील में जाओगे ना, ओरिजिनल जुरिडिक्शन को कैसे लेके?
हाँ, तो ओरिजिनल जुरिडिक्शन के रिजेक्शंस को ले लेकर के ऊपर जाना पड़ेगा.
सर इतने पैसे होते तो अगर उसके पास इतने पैसे होंगे, देन एज अ BT ओनली यू वुड हैव गेट हिम. तो उसके पास या तो है नहीं और ही इज आउट ऑफ इंडिया. उसमें आप करोगे क्या उसके पीछे? सो
कुछ नहीं होना है
सर.
इन द प्रेजेंट सर्कमस्टेंसेस कुछ नहीं होना. या प्लीज
सर, EPFO है वो हर CRP में नॉर्मली अपना क्लेम डालता है सर, और प्रूफ देता नहीं है सर. 2-3 साल से CRP में अटका हुआ है. तो उसमें जब हम RP को बोलते हैं तो RP बोलते हैं जी मैं क्या कर सकता हूँ इसमें. तो इसमें कुछ इंश्योरिटी जैसे कोई अपॉर्चुनिटी होती है, अभी आपका अपॉर्चुनिटी क्लोज हो जाएगा, आप 1 साल से लास्ट अपॉर्चुनिटी दी गई है, उसके बाद 4 हियरिंग लग गई है, लेकिन आप फिर भी नहीं कर रहे, तो इसमें RP के पास में कोई एप्लीकेशन मूव करने का प्रोविजन है?
सर EPFO ही एक ऐसी चीज है जिसको हम तोड़ नहीं पा रहे हैं. सच बताएं तो एज एन RP, I mean it's nothing to do with bankruptcy trustee now, but EPFO is one thing because it touches employees and that cadre which nobody wants to take a wrong decision on. Neither the lawmaker, neither Supreme Court कोई bad नाम नहीं कमाना चाहता. So EPFO and EPFO always gives one-sided decision. They never ask you. They will always pass a dictate. इतने पैसे चाहिए आपसे. अब आप उसे फाइल करते रहिए सेक्शन 7 में, किसी में 30, उनके पास 1000 सेक्शन है सर. So our problem is you have to admit it. As an RP, I am only collating the claim. It's not that I am paying. Now after Jet Airways तो उनकी ताकत और बढ़ गई है. Now
जेट
after
एयरवेज ने क्लियर कर दिया, 53 में 12 हो गया, उसको प्रायोरिटी दे दी है और आप उसमें कुछ कर नहीं पा रहे.
आई नो सर वो हमारे लेवल पे यहाँ नहीं सेटल हो सकता सर ये. सो इसके लिए कुछ कुछ हमारी लिमिटेशंस हैं. सो राइट नाउ वी कैन ओनली डिस्कस व्हाट इज हैपनिंग, व्हाट आर द
जजमेंट आई थी.
प्रॉब्लम्स.
ईपीएफओ क्या करता है अपने क्लेम में, क्योंकि जब भी ईपीएफओ की फाइलिंग होती है, जैसे टीडीएस की होती है, इनकम टैक्स की होती है, उसी टाइप की उसके पास में अगर इम्प्लॉइज की लिस्ट आई और जो सैलरी उनको मिल रही है उसके बाद चाहे वो छोड़ के चले गए, लेकिन वो पेनल्टीज भी लगाते हैं, इंटरेस्ट भी लगाते हैं, अपने एक्सपेंसेस भी इंक्लूड करते हैं. हालांकि एक जजमेंट भी आ गया है जिसमें ये बोला है कि ईपीएफओ जो सैलरी का ड्यूज है प्लस इंटरेस्ट आप ले सकते हो, लेकिन डैमेजेस या फिर आप जो पेनल्टीज जो
वो
इसमें
नहीं है,
इंक्लूड करते हैं वो नहीं ले सकते.
वो हटा
जो
सकते.
क्लियरली है, फिर भी वो नहीं अपना रिप्लाई देते हैं कि जी हम इसमें इतना हटा रहे हैं.
सर
जब
इन सरकारी डिपार्टमेंट से आप भी आई एम श्योर 20-30 साल से झेल रहे हैं. वी ऑल्सो नो हाउ द थिंग्स यूज टू मूव. दे अभी लकीली दे आर एक्टिव इन फाइलिंग द क्लेम्स. वो फटाफट आता है आजकल. बाकी
हाँ,
सब उसी तरीके से चल रहा है. इनकम टैक्स ऑल्सो सिमिलर वे. अपील आप फाइल करते रहिए, ऑल दैट विल गो ऑन. अनलकीली नाउ एनसीएलटीज ऑल्सो डोंट टेक अ डिसीजन ऑन इवन ऑन रीपेमेंट प्लान. They say that you go to respective authorities and discuss with them. So there is no concept of 32A कहाँ गया if we have to do all that. So I mean गुजरात वैट ने पूरा गड़बड़ शुरू करा था सर. We all know that, right? And then Jet Airways came, and Jet Airways में EPFO has become such a strong contender कि इनकम टैक्स भी दूर है, EPFO सबसे आगे है. सो इनकम टैक्स को आप पूरे पैसे खा जाओ, कोई प्रॉब्लम नहीं है. ईपीएफओ को तो ग्रेचुइटी भी लेगा वो, एंड दे विल टेक एवरीथिंग एल्स. सो एंड देयर क्लेम इज नॉट कैंसिल्ड. अगेन दिस वाज विद द assumption that their claim will not be like in multi crores, और जैसे आप लोगों के 18% 20% हर साल जुड़ते हैं, शायद वो ऐसे नहीं मांगेंगे. दैट इज एन assumption, but again it's a case to case. I have similar view which all of you have.
कुछ करने के बाद में सर ये जजमेंट आई जिसमें बोला गया कि आप पेनल्टीज और ये नहीं ले सकते. तो जब ईपीएफओ से पूछा गया तो बोला कि मेरे कमिश्नर को सिर्फ 2 रुपए की पावर है अमेंड करने का, इसमें छोड़ने का. इसमें पावर ही नहीं, 2 रुपए की नहीं.
I know that sir, that what you are saying is right. और so that काफी चीजें चेंज होती हैं. So that is why वो ट्विक से नहीं होगा. जैसे आईपीसी भारतीय न्याय संहिता बना है, ऐसा कुछ करना पड़ेगा. तो तब जाके
सीआरपी में जो क्लेम सबमिट करने का टाइम होता है, 1.5 साल बाद सर एप्लीकेशन मूव होती है एनसीएलटी में और अप्रूव भी होती है और क्लेम फाइल भी होता है. हमने कई बार आरपी से पूछा कि क्लेम एडमिट करना है, वो मना कर देता है. कोई बात नहीं, हम एनसीएलटी चले जाएंगे, एनसीएलटी में एप्लीकेशन फाइल करेंगे, अप्रूव होगा, क्लेम फाइल होगा.
सर उसी को बचाने के लिए तो 90 डेज कर दिया है अभी आजकल, आपको पता होगा. 90 डेज और टिल द रिजोल्यूशन प्लान इज फाइल्ड, बिकॉज दे नो एनीबडी हु विल कम. इंडिया में नेचुरल जस्टिस का बहाना तो सबके पास है. सो नेचुरल जस्टिस का वर्ड यूज करो, काम हो जाएगा. सो वो होता है सर. वी आर अवेयर ऑफ दैट. वी आर लिविंग दैट लाइफ फॉर लास्ट 7-8 years. सो दैट
सर
इज.
जैसे फैमिली डिस्प्यूट्स में अपने कोर्ट में इनकम एंड एक्सपेंडिचर एफिडेविट देते हैं, क्योंकि फैमिली कोर्ट में ये माना जाता है कि जो वो इनकम टैक्स भराएगा या फिर उसके क्रेडिट कार्ड की ट्रांजेक्शन है, वो हो सकता है कि वो पूरी ना बताए. तो इसलिए उससे एफिडेविट लेते हैं ताकि अगर कुछ मिसमैच मिले या फ्रॉड मिले तो इस पे सीआरपीसी में हम एक्शन ले सकते हैं.
पकड़ सके,
तो जैसे ही
करेक्ट.
आपकी अगर मान लो डेटर से कुछ इन्फॉर्मेशन लेता है कि भाई तेरे पास क्या प्रॉपर्टी है, तेरे तूने क्या ट्रांजेक्शन किया, तो वहां पर भी सेम एफिडेविट लिया जाता है. क्योंकि अगर वो नहीं लेगा तो फिर जो हमने 7th चैप्टर पढ़ा है उसमें इंक्रीजमेंट की कोई बात ही नहीं है. और दूसरा सर एनसीएलटी के पास तो क्रिमिनल की पावर ही नहीं है ना. तो वो एग्जीक्यूट कहाँ से करवा रहा है? क्योंकि एनसीएलटी के पास तो आई डोंट थिंक कि पावर है पुनिश करने
This
की।
has to be what you are hitting on right now. I don't know. I should we should discuss here because NCLT genuinely doesn't have those kind of powers which a regular court has. In fact,
Yes.
238A इसीलिए तो आया था कि treat them as court. लोग तो उन्हें कोर्ट ही नहीं मानते हैं. They'll say it's a tribunal only. What can they do? In my own cases, sir, I'm telling you, I have property execution petition. Delhi नहीं admit करता है. वो बोलते हैं सर कानून के हाथ लंबे तो हैं पर इतने लंबे नहीं है कि कोटा तक पहुंच जाएंगे. So you might as well file in कोटा only directly. So NCLT, I agree completely with you, sir. राजस्थान वाला NCLT बेंगलोर की बात क्यों सुनेगा? I don't know. या गुवाहाटी की क्या बात सुनेगा? उनकी क्या पावर्स हैं? क्या उनके पास? सर लॉ इज ऑल अबाउट कोएर्सिवनेस. नहीं सुना तो क्या कर लेंगे? तो क्या कर लेंगे तो कुछ है ही नहीं ना सर. वो तो क्या कर लेंगे का आंसर मिसिंग है. एंड बिकॉज दैट इज मिसिंग, और प्रमोटर्स को सर कंटेम्प्ट ऑफ सुप्रीम कोर्ट भी नहीं रोक पाता, तो यहाँ तो इनसे तो क्या फर्क पड़ेगा.
अच्छा, एक मैटर में आपसे जानना चाहता था रिगार्डिंग CRP and other matters. RP is supposed to give CRP form and all those things. In case of personal insolvency, whether any reporting system and forms are there?
अभी नहीं है सर, अभी नहीं है. That's what दीपा जी has been trying since morning, कि अगर कोई CRP फॉर्म्स हैं, कहीं पब्लिकेशन होती हैं, तो एटलीस्ट यू कैन पुट योर ईमेल आईडी और दैट पर्सन कैन बी आइडेंटिफाइड. जैसे सिन नंबर से हम कंपनीज का डाल सकते हैं. IBBI कैन कीप यू इन्फॉर्म्ड. फॉर पर्सनल इंसॉल्वेंसी अभी तक नहीं है सर, but there are proceeding emails. I think Anjali is here. She can also tell. Monitoring emails from IBBI as well as IPA, where you need to inform them that this proceeding is going on. But there are no 1, 2, 3, 4, 5, 7, 8. All those forms are not there.
Only under section 2082 we need to inform that's all.
208 code of conduct में हाँ उनको we inform them, and there is a dedicated website for the email IDs for that. Proceedings at
Yeah.
I will find that. उस पे we inform, and that's all. That is the only compliance right now. उसमें तो हम regulatory fees और वो सब भी नहीं है सर अभी तो. And that's why I'm saying personal insolvency is pretty new, and bankruptcy is obviously, after 5 months, 6 months, we should be able to tell you that, this is happening, that is happening.
So I think now time is also over. So.
Anjali ji, Miss Anjali Gupta is there?
Yes, sir.
Acha, Anjali ji, yes, we can close the session. Thank you for.
Okay, thank you very much, sir, for giving your valuable time and making the session so much interactive. And sir, you are requested to please share your PPT.
I'll share with you or in the chat box.
So you can share with me. I will share with all the participants.
Okay. I'll send it to you. I'll send.
Okay, sir. Thanks a lot.
Okay. Good night, sir. Enjoy your weekend.
Thank
I hope
you, sir.
Saturdays.
Thank you, sir. Thank you.
So, thank you,
See
sir.
you, Miss Deepa. See you. Bye.